We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, take time on it. Though we may criticize it, this is our own, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a bit of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, take time on it. Though we may criticize it, this is our own, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We are a peaceful people, struggle is always struggle, and we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. This land is all I know, we gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere, make no mistake. Cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We love the open country of the Rupununi and the Essequibo, take time on it. Though we may criticize it, this is our home, we love it, and we need to keep it, we have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We are a peaceful people, struggle is always struggle, and we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. This land is all I know, we gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere, make no mistake. Cause we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time on night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one grass, not a bit of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one chorus, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here. And we ain't moving nowhere, make no mistake. Cause we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake, not one rice grain, not one grass, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time on night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain. We ain't giving up.
Speaker.
Thank you. Please be seated. Honorable members, we will now proceed with the second reading of the Criminal Law Procedural Paper Committals, Bill 2024, Bill number 7 of 2024, published on the 9th of May this year. Honorable Mohabir Anil Nandlal, Minister of Legal Affairs and Attorney General.
I traveled that religious road already, Mr. Speaker.
So you never lose the conversion?
No, sir.
Okay, Mohammed.
I embrace all of our major religions. Sir, I rise to move that the Criminal Law Procedure Paper Committal Bill of 2024 be read a second time. Mr. Speaker, this is yet another bill coming from our government that will have, once it's enacted, transformative effect on the legal system of our country, in particular, our criminal justice system. This bill, Mr. Speaker, seeks to abolish traditional oral preliminary inquiries in Guyana completely. The bill provides for the abolition of preliminary inquiries as provided for in the Criminal Law Procedure Act, Chapter 1001, and the substitution thereof with paper committals, which involves reviewing the evidence and arguments presented by both the prosecution and the defense in written form, rather than conducting an oral in-person hearing. Currently, paper committals are utilized by almost every country in the Caribbean. Antigua, Barbuda, Barbados, Belize, Dominica, Jamaica, St. Lucia, and Trinidad and Tobago have all incorporated paper committal as part of their criminal justice system. The United Kingdom, from where we inherited our legal system, introduced paper committal in its legal system since 1967 by virtue of the Criminal Justice Act of that year. Mr. Speaker, that is 1 year after independence was granted to Guyana. We have labored with what is now clearly an outmoded process for nearly 6 decades thereafter. I do not think that anyone can dispute that the time for paper committal is long overdue. Paper committal, Mr. Speaker, for the record, was first introduced into the criminal justice system of Guyana in the year 2008 by virtue of the Criminal Law Procedure Amendment Act of 2008. That amendment vested in the magistrate holding a preliminary inquiry into an indictable offense a discretionary power to admit evidence from either the prosecution or the accused person in the form of statements, documents, writings, and other articles in the absence of witnesses, and after hearing and considering submissions from attorneys at law representing the accused person, can either commit the accused person to stand trial or discharge him, as the case may be. Those amendments also vest in the magistrate a discretionary power to require witness to attend, give oral evidence, and be cross-examined. So what we had then, Mr. Speaker, was an option for paper committal or the option of conducting the traditional preliminary inquiry. Unfortunately, these amendments are hardly ever invoked in practice, resulting in the paper committal mechanism never really being activated or used in those provisions. It would appear that lawyers continue to insist on an oral preliminary inquiry, and the magistrates exercise their discretion in favor of such requests. So once the discretion existed, the lawyers, the accused, and the magistrates apparently exercised their choice in favor of an oral preliminary inquiry. Again, as a matter of history, in the year 2010, the National Assembly passed the Sexual Offences Act, Chapter 803, which was piloted by my distinguished sister, the Honorable Priya Manik Chan. That act also provides for paper committal. Section 43 of the act mandates that where a person is charged with a sexual offense under the act, there shall be no oral preliminary inquiry and instead paper committal shall be held, a paper committal shall be held in accordance with the procedure set out in the first schedule. So, Mr. Speaker, in the Sexual Offences Act, that option was not given. The Paper Committal Act, in very clear and mandatory language, abolished paper committal, oral inquiry in relation to sexual offenses and mandated that all sexual offenses be done by way of paper committal. Why paper committal? Oral preliminary inquiries, however short they may have been intended to be, today takes about an average of 3 to 4 years minimum to be completed. So if a person is not on bail, that person is remanded to prison for this period. This is one of the main reasons for overcrowding in the prison system of our country. Of course, the state bears the expenditure for the upkeep of these persons and their conveyance to and from prison centers to magistrates' court across the country. The financial burden on the state is an extraordinary one. I cannot also omit to mention that the protracted period on remand can also result in the deprivation of the accused of his right to a fair trial within reasonable time, a fundamental freedom guaranteed to him by Article 144 of the Constitution of Guyana. So much so that a few years ago, Chief Justice Chang granted bail to an accused person, Hemchand Prasad, who was remanded for 8 years while his preliminary inquiry was being conducted. It is public knowledge that this was and still remains an unprecedented decision, the decision to grant bail, that is, because bail, Hemchand Prasad was not a decision to grant bail, but a decision to grant bail where there is a charge for murder. It is not normally granted. In this case, this gentleman, Hemchand Prasad, was on remand for murder for 8 years without his preliminary inquiry being completed. In a very elaborate and well-researched judgment granted on May the 9th, the learned Chief Justice found as a matter of law that this undue delay violated the accused's fundamental right to a fair trial and granted bail as a redress thereof. In the course of his judgment, the Chief Justice made these seminal observations, which, sir, with your leave, I am taking the liberty of placing on the record, and I quote, "It is the responsibility of the state to ensure that there is in place an efficient and properly staffed legal system to discharge the constitutional duty of the state to provide a hearing within a reasonable time to every accused person. In the instant case, whatever the delay which may have been caused by legal challenges made by the applicant to the committal proceedings cannot be laid at the doorstep of the applicant, since they were successful applications, not frivolous or vexatious applications. It was the relevant prosecutorial authorities which had the responsibility for instituting charges against the applicant, and the relevant magisterial authorities which had the responsibility for conducting the preliminary inquiries. It is those authorities which must bear responsibility for the lengthy and very regrettable delay which has attended the progress of committal proceedings which lead to trial. The applicant was charged with the offense of murder since April 2000. He still faces those charges to this day and is yet to have a valid preliminary inquiry commenced, let alone concluded into those charges. This court has no difficulty in making the ineluctable finding that the constitutional right of the applicant to a fair hearing within a reasonable time, provided for in Article 144(1) of the Constitution, has been and is likely to be further infringed. He was charged since April 2000, and a preliminary inquiry necessary for the committal and indictment has not yet commenced. Unquote. And this judgment was in 2008, this gentleman being charged in 2000. I give this assembly this live example of how long it takes for a preliminary inquiry to be conducted under our current system. And I give another example. Currently, a citizen, Jones Raymond, from Mykobi Village, Region 8, has launched legal proceedings against the state, suing the Attorney General for breach of his fundamental right to a fair trial within reasonable time. The facts are that he was on remand for almost 10 years, awaiting his preliminary inquiry to be concluded. He's seeking compensation in the tunes of tens of millions of dollars against the state. After nearly 10 years, his PI was still yet not completed. He was discharged by a high court judge during a jail delivery process. So 10 years, and this brother was languishing in the prison on remand for murder without his PI being completed. A judge conducting a process called jail delivery found him in there and released him. And he's now suing the state for his incarceration for 10 years while he awaited a PI to be completed. I have given just two examples, Your Honor, to illustrate the unfortunate reality of our current situation. Currently, Mr. Speaker, there are 621 persons on remand in our prison system. And I have no doubt more than 60% of those persons are awaiting conclusion of preliminary inquiries. No doubt these and similar factors would have been the main reason for the move to paper committals across the Commonwealth and, of course, the Caribbean. Last year, when the Caribbean Court of Justice visited Guyana, in a meeting with myself, they requested the government to consider resorting to a full paper committal system. In a public engagement with the legal fraternity and other stakeholders held in this very room, the CCJ also made a public call for Guyana to move in this direction. Mr. Speaker, I now move to provide a summary of the current oral preliminary inquiry so that members would understand. Under the current law, the traditional or oral preliminary inquiry was necessary before any indictment could be made. The prosecution witnesses are required to personally appear in court and provide oral testimony, which can be challenged through cross-examination by the accused or his attorney at law. All of this oral evidence is reduced into a deposition by the magistrate and read over in the presence of the accused, and the witness is required to sign and bind himself over to give evidence at the trial in the High Court. When a prima facie case is made out against the accused person, based upon that oral testimony reduced in writing and forming part of that deposition, the magistrate is required to call upon the accused to answer the case and to allow him to make a statement or lead evidence and call witnesses if he so chooses. Where the accused elects to give evidence or call witnesses, the evidence of the accused or his witnesses is taken down on deposition in the same manner as it was done for the prosecution witnesses. Where witnesses for either side are unable to attend the court because of illness, the magistrate has a power to go to that witness to take his or her evidence on deposition at that place. If the witness is outside the particular magisterial district, the magistrate of that district is empowered to take the witness deposition and to transmit it to the magistrate presiding over the committal proceedings. At the end of the evidential aspect of the PI, and after hearing submissions from the accused and the prosecution, it is open to the magistrate to find that the prima facie case is made out, in which case the accused will be committed to stand trial. Even after an accused person has been committed to stand trial, either the prosecution or the accused may provide proof on oath that there are other witnesses who can give evidence to prove respectively the guilt or innocence of the accused, in which case the evidence would be taken in the same way as the other evidence in the PI. The opposite side is always given an opportunity to cross-examine. Further, even if the Director of Public Prosecutions, within 6 months of receiving the papers after committal, may resend the paper to the magistrate with directions to reopen the PI, to take further evidence, and to follow such other directions as the DPP considers appropriate. Where this happens, there is a deeming that no committal has yet taken place, and the matter proceeds accordingly. These instructions are required to be done in writing, and the magistrate obligated to comply. Where the magistrate finds that there is no prima facie case, the magistrate shall discharge the accused. Up until recently, by virtue of Section 72 of the Act, the Director of Public Prosecution had a power to direct the magistrate who had discharged an accused on the basis that there was no prima facie case disclosed on the evidence to reopen the PI and to commit the accused to stand trial. This particular provision had withstood constitutional challenge grounded in the separation of powers doctrine since in the 1970s. However, in 2022, in Marcus Bisram against the Director of Public Prosecutions, 2022, 5 Law Reports of the Commonwealth, page 1, the Caribbean Court of Justice struck down Section 72 as being unconstitutional. The court held that the Director of Public Prosecution could no longer act under Section 72, but that the DPP was for good reason, that if the DPP, for good reason, is disappointed with the decision of the magistrate to discharge an accused person, an application could be placed before a judge of the Supreme Court with the deposition and other materials, with a request for that judge to commit the accused person to stand trial. The principle that the CCJ identified was that the doctrine of separation of powers prohibited any authority from giving directions to a judicial officer, including the DPP. In the same way that the Constitution says that no one can direct the DPP in how to conduct her business, in the same way, no one can direct a magistrate or a judge in the manner on how to conduct their business. In fact, the Chief Justice or the Chancellor, nor the Chancellor, can direct a judge on how to determine a particular matter. So you have intrinsic independence and extrinsic independence in the judiciary. So those were the principles, Your Honor, that guided the CCJ in striking down Section 72. In short, Mr. Speaker, the oral preliminary inquiry is an extremely protracted exercise. And it also has, at least in Guyana, you had some unique provision whereby the prosecution is required to lead all the evidence available. And if 6 months pass after the committal, the prosecution is prohibited from leading any further evidence. I will show how those provisions have changed now for the better in the paper committal scheme that this bill seeks to promulgate. Mr. Speaker, not unexpectedly, when paper committal was first introduced in the region, it was challenged as an abrogation of the right to a fair trial. Obviously, as I said, you are now moving from a position where witnesses were testifying in a witness box with a right of cross-examination by the accused person to a position where, on cold hard paper, in terms of statements, a magistrate is now making a finding. The question, as I was going to explain to my learned friend, the Honorable Ramjatan, you hardly have the opportunity to question admissibility of evidence. And that's the point I was making so forcefully in the previous bill. Because it is not the role of the magistrate to determine admissibility of evidence. That is a question for the trial judge. So all the statements, once they are relevant, they are going to be admitted and they are going to be adjudicated upon by the magistrate. So this is a strange process that was being introduced after more than 100 years of oral preliminary inquiry. So anxieties were excited. Persons became suspicious and they challenged it, naturally, both in the Caribbean and in Guyana. There were several challenges across the region. One emanating out of Antigua and Barbuda spiraled all the way to the Privy Council. The relevant constitutional provisions of Antigua and Barbuda are thoroughly examined. They are almost identical to the corresponding provisions in the Guyana Constitution, and that is the provision that deals with a right to a fair trial, because that was the basis of the challenge. And the provisions of Antigua Barbuda are almost identical to the Guyana provision in that regard. And in the end, the Privy Council ruled that the paper committal process did not infringe on the constitutional right to a fair trial. And the case is Humphreys against the Attorney General of Antigua and Barbuda, 2008, United Kingdom, Privy Council, page 61. In Guyana, as I said earlier, the paper committal process is contained in the Sexual Offences Act of 2010 and naturally was challenged, and challenged on many occasions. Unlike what the Honorable Member Comrade Ramjatan said in the previous debate, we never brought that bill here because of back to the Parliament to rectify any deficiency because of any technical challenge. What we did was we awaited for the challenge or challenges to be concluded in the judiciary. So there was a period of time when we didn't charge, or rather the DPP did not charge for sexual offenses until the challenges were exhausted. At first instance, a case was filed by a gentleman by the name of Ray Bacchus, and Chief Justice Chang heard the challenge at first instance and struck down provisions of the Sexual Offences Act which dealt with paper committal. The learned Chief Justice found, as a matter of law, that those provisions collided violently with the right to a fair trial as guaranteed by Article 144 of our Constitution. And the matter went to the Court of Appeal, and our Court of Appeal followed the decision of the Privy Council, and our Court of Appeal rendered a written ruling which is reported in the name of Director of Public Prosecutions against Bacchus, 2018-96 West Indian Report at page 404. And I quote, sir, from our Court of Appeal. A careful reading of the provisions of the Act and the Constitution informed that at first blush, the paper committal proceedings allowed for the committal of an accused in the absence of cross-examination and in the contravention of the constitutional guaranteed facilities. So the judges are saying, yes, at first blush, it does appear that there is a violation. However, that restriction on an accused person's right to cross-examine at the preliminary inquiry did not relate to the trial and did not affect the fairness of the trial. As I said repeatedly, the PI is not the trial. So the fact that you are not being able to cross-examine at a preliminary inquiry does not affect your right to a fair trial. And that is the constitutional right that you have, a right to a fair trial. What is going on in the magistrate court is not a trial. So it does not reach the threshold for the constitutional right to be invoked. And that's what they're saying here. The determination of guilt and cross-examination were reserved for the trial at the High Court. The process undertaken by the magistrate at the committal proceedings was to filter the relevant statement without making a determination of guilt or innocence. To filter the relevant statement. You hear what I was speaking about? No question of admissibility. Relevant statement. Filter it. The preliminary inquiry being only but one stage, the denial of cross-examination might have appeared to operate unfairly against the defendant. However, the proceedings were fast-tracked for both the virtual complainant and the defendant. In addition, the trial provided adequate safeguards for the rights of the defense, and at that trial, the accused had the liberty to cross-examine all the witnesses. The provisions of the Sexual Offences Act, insofar as it removed the right for cross-examination at the stage of the committal proceedings, had to be balanced against that of the victims and the backdrop against which the legislation was passed. While the rights of the respondent had to be safeguarded, the interests of the public and the victims of sexual offenses had to be respected, if not protected. And I will substitute victim of sexual offenses with the term victim of any crime. Their rights have to be protected and respected. It was in the public's interest that victims of sexual offenses were not subjected to cross-examination twice at the preliminary inquiry and at the trial. Again, I substitute sexual offenses victim with victims of crime. They should not be subject to two sets of cross-examination when one is not a trial. Applying the tests of rationality and proportionality, the deliberate action on the part of the drafters in excluding cross-examination at the PI stage seemed proportionate to the objective. Further, the respondent had failed to show that the deferral of cross-examination was not reasonably justified and that it excessively or arbitrarily invaded the engagement of his constitutional right. Accordingly, the procedure of paper committal was not unconstitutional, neither was it unfair to the accused person, and the section complained of did not breach Article 144 of the Constitution of Guyana. Unquote. So, Mr. Speaker, you have here a comprehensive examination by our Court of Appeal, and that's as far as it went. Ray Bacchus, for good sense, did not appeal to the Caribbean Court of Justice, so the matter was left there. And this is the final pronouncement on the concept of paper committal in Guyana, as exists in the Sexual Offences Act. And it is replicated here in almost identical form. The point I want to make is that the concept of paper committal in Guyana has been thoroughly examined and it has received judicial affirmation, approbation, and assent. So the question of whether there is any legality surrounding it ought not to arise. Mr. Speaker, having laid down those foundational principles, I now go quickly to the bill. Mr. Speaker, as I said, the bill abolishes oral preliminary inquiry. So there is no longer the 2008 position where you have an option. There is no preliminary inquiries anymore, oral preliminary inquiries. And in all cases where preliminary inquiries are to be held, those cases will now be substituted with a paper committal process, as is adumbrated in this bill. Mr. Speaker, Part 2 includes clauses 5 to 20, and this part sets out the procedure to be followed in paper committal, and it also empowers the magistrate to adjourn the proceedings beginning a paper committal or at any time during the proceedings. Once the matter is adjourned, the magistrate has a power to remand the accused, all the necessary powers that a court will have. It is significant to note that under clause 6.3, where the magistrate adjourns the proceedings are to be resumed no later than 21 days This mechanism is intended to guard against protracted and prolonged adjournments. Mr. Speaker, one of the main policy considerations, one of the main trigger for this bill is because of the time that is wasted in oral preliminary inquiry. The main purpose of this bill is to bring efficiency, expediency, and dispatch to the criminal justice system. And that is why throughout this bill, there are tedious requirements. And here is one. If the magistrate decides to adjourn, then the magistrate is prohibited from adjourning a matter beyond 21 days. Clause 7 is a very important provision. It provides for the admission of evidence and sets out again the timeline for which all relevant evidence should be filed by both the prosecutor or the person acting on behalf of the prosecutor or the accused person. So again, the relevant evidence and their time frames for when they are to be presented. It will be noted that the bill in its current formulation refers to credible evidence and not relevant evidence. A change will be effected shortly by me before the conclusion of this process to change the word credible to relevant. There's a misspelling, there's a mistake there. The word credible should not have been there. It has to be relevant evidence. Credibility is a matter for the trial and not the paper committal. The bill proposes that the prosecution must submit all the evidence to the court's registry no later than 45 days following the initial appearance of the accused. The accused is given a corresponding time frame to submit evidence if they wish to do so. So you have a 45 days on both sides to submit evidence. Again, there is a minor error because the bill speaks to all evidence. I will move an amendment to remove the word all. And that is what I want to point out, and I was referring to earlier. We are removing the requirement for all evidence to be led at the preliminary inquiry. This has caused untold problem. You can lead sufficient evidence. You don't have to lead all the evidence. The current requirements require you to lead all the evidence. And if you don't do it within the prescribed time, then you are shut out from leading the evidence. You have to, at the trial, persuade a judge that you had really, really compelling reasons for not leading the evidence, which you had in your possession. And that has led to valuable, probative evidence being excluded from being admitted because of the mistake of some prosecutor or some oversight on the part of the prosecution for not leading that particular evidence. After a while, the law shuts you and you can't lead it at all. Here we are removing that prohibition. You are only required to lead sufficient evidence that would establish a prima facie case. Or if you're the defense, a sufficient evidence that you feel is sufficient to establish a defense for you at that point in time. And that's all you need. You keep the evidence and you can lead it in the magistrates, in the High Court. The Sexual Offences Act has that problem. You have to lead all the evidence. And we will have to bring that act to amend it because it is causing the problems that I have alluded to. Transparency is an essential element of a just trial procedure, and the bill addresses this by stipulating that the accused must be provided with a copy of all the evidence submitted by the prosecution. And of course, the prosecution is to be supplied with all the evidence that the accused intends to rely upon. Again, the bill imposes time frames to ensure that there is no undue delay. I spoke about the 45 minutes. Needless to say, the court has a power to extend these time frames for good reason. Hopefully, these time frames will not be abused. Significantly, while the bill currently states that both the prosecution and the defense are required to submit all the evidence, well, I spoke about that amendment that will come. So that position of all the evidence will not prevail. The remainder of the bill seeks to provide for the evidential requirements that must be satisfied with respect to written statements sought to be admitted as evidence in paper committal proceedings. A written statement, for example, to be admitted, the bill says, must be signed or marked by the person who made it, and critically, it must contain a declaration by the person who made it to the effect that it is true to the best of the person's knowledge and belief, and that the person made the statement knowing that if it were tendered in evidence, the person would be liable to prosecution for willfully stating in it anything which the person knew to be false or did not believe to be true. Is the ordinary standard admonition in relation to evidence. When you take the oath, the evidence is going to be the truth, nothing but the truth, etc. And if you lie, well, obviously, you are liable to be charged with perjury. That is the rationale being captured, or those are the principles that are being captured in those provisions of the bill. The bill contains further requirements for persons who cannot read and those who are suffering from physical disability or physical disorder that render that person unable to sign or otherwise make a mark. The same procedure, if a person can't read, etc., and they go to sign a deposition, having given the oral testimony, there is a procedure that allows you to do that. That procedure is replicated here. This part also sets out the requirement which must be met for depositions to be admissible as evidence for the purpose of paper committal, and it also provides for the evidential requirements that must be met with respect to other statements sought to be admitted as evidence in paper committal proceedings. Clause 11 of the bill provides the evidential requirement that must be met with respect to other documents sought to be admitted as evidence in paper committals. These are documents other than the statements that would have been the oral testimony. These are now exhibits, medical certificates, etc., death certificates, etc. It further empowers a magistrate to issue a summons or warrant directing that a person's evidence be taken as a deposition or requiring that person to produce documents or other exhibits. A normal power that a magistrate has to summon witnesses, to subpoena witnesses. Obviously, that power is retained by the magistrate in relation to paper committals. This part also provides for a magistrate to commit an accused person for trial for an offense if the magistrate is satisfied with the evidence. The magistrate has the power to commit the accused without consideration of the content of any statement, disposition, or other documents, except where the accused is unrepresented, where the accused is represented, and the attorney has asked the court to consider a submission, and there is sufficient evidence to commit the accused to stand trial. So if it is all the evidence goes in and the accused doesn't say anything, the magistrate can commit. It means that the accused is not contesting the PI. So the magistrate doesn't have to go through and make a finding. It's not pleading guilty, but admitting to the court that a prima facie case is made out against me and I am prepared to stand my trial. That's what it means. However, if the accused is unrepresented, to protect the interests of the accused, then the magistrate has to go through statement by statement and form the view of whether the evidence meets the threshold for committal. If, of course, there's a lawyer appearing for the accused person, that lawyer would be allowed, once requested to do so, to make submissions of insufficiency of evidence, etc. Clauses 16 and 17 set out the procedure whereby a magistrate may commit an accused for trial without consideration of the evidence and the procedure for committal or discharge of the accused on consideration of the evidence. I just spoke about that. Clause 18 requires a magistrate to record the reasons for committal or discharge of an accused person in writing. Obviously, the magistrate must give reasons for the decision, one way or another. Clause 19 empowers the Director of Public Prosecutions to make an application to a judge of the High Court for a warrant for arrest and committal for trial of a person discharged by the accused by the magistrate if the DPP is of the opinion that a prima facie case against the discharged person was established and the discharged person should have been committed to stand trial. This here again is addressing the CCJ ruling in Bisram. Section 72, had it been there, would have empowered the magistrate to empower the DPP to direct the magistrate to reopen the PI and commit. That section 72 is no longer there, and it has been replaced by another provision. Here, we are enacting the provision again. So if the DPP feels that a person who the magistrate discharged should not have been discharged, then the DPP has a right to go to the High Court to ask for, firstly, a warrant for the arrest of the person, if the person should not be on bail, if it is a murder charge, for example, and then make an application for the committal of the accused person. Of course, once that process is triggered, that High Court judge will then be holding a hearing. You will have all the depositions before him. He will have to invite the accused to be heard, and there will be a mini hearing once again, where the DPP will attempt, obviously, to persuade the judge that should that there is sufficiency of evidence for a committal order to be made. Finally, this part makes provision for the person whose statements, deposition, documents, or exhibit was not tendered in evidence during the paper committal to give evidence at the trial. So there is a provision, as I said, not all the evidence is required to be led at the paper committal stage. So if you are a witness, but the DPP decided that she had sufficient evidence and did not require your evidence to lead it at the paper committal stage, but needs your evidence for the trial, there is a provision in the bill that will allow for your evidence to be given at the trial, for your statement to be tendered and served on the defense, and of course, for you to go into the witness box to testify at the trial. Mr. Speaker, Part 3, Roman 3 of the bill consists of clauses 21 to 26, and they provide consequential amendment to the Criminal Law Procedure Act and to repeal the relevant sections. Obviously, we have to repeal those sections that are still there dealing with oral preliminary inquiry. We have to repeal them because they are no longer in use, and make consequential amendments to facilitate paper committal. Also, Mr. Speaker, sections of the Evidence Act speaks to how oral evidence in a PI is to be admitted. Those sections of the Evidence Act will have to now be amended, and they are hereby amended, because you will not have oral evidence at a preliminary inquiry anymore. Finally, again, the Evidence Act and the Criminal Procedure Act, the bill provides for them to apply to the Act where necessary, with such modifications that may be needed for the due administration of the Act. So there's a general omnibus provision that informs that whatever provisions may be left unattended or unamended, they must be read now with such modifications as to bring them in conformity with this new bill. So,
Honorable AG, you're concluding now?
Yes, Mr. Speaker. I'm sorry, sir, to be so long in the presentation, but it's a bill of some substance, and I thought that I would outline the provisions as simple as possible and as elaborate as possible, in particular for the benefit of members of the House who are not lawyers but who are expected to follow these complex legal process. So, Mr. Speaker, I thank you very much, and I ask that the bill be read a second time. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Attorney General. We have a switch. The Honorable Kemraj Ramchatan will go now, and the Honorable Geeta Chandan Edmund will come after the Honorable Sanjeev Dattani. Kemraj?
Excellent job, AG. I fully support this bill, and I would just want to make some comments about it. This bill ought to have been here for a very long time, as he mentioned. In England, it was passed since the 60s, I understand. And of course, we probably were very hesitant since those days, and probably because of the criminal bar associations of the various territories wanted it the way it was always. The lawyers in countries as ours usually are very hesitant to move with the pace of things, being, ingratiated with the procedures of oral hearings. And the fact too that, Mr. Speaker, oral hearings at the preliminary inquiry stages have what they call a benefit for defense lawyers especially. And probably all of those were reasons, apart from others, that delayed it until 2024 here in Guyana. I want to support it also for the reason that it is going to do away with a lot of delays at that preliminary stage. And those delays, I hope, are not now going to be scuttled onto the trial stage. Because what we are going to have would be tremendous amounts of PIs being sent up, committals happening, and then the trials now at the High Court before juries taking a long time and creating something of a bottleneck. Because if we were doing 1,000 PIs in a year or 100 PIs in a year, what we're going to do now is lots more. And they will then be referred to the High Court. That can create a bottleneck, because are we going to have that kind of extended sizes and the judges to ensure that there be trials happening expeditiously? That is one comment I make, and I think it's a fair comment, because you can have that bottleneck now at the High Court instead at the Magistrates Court level. The other important point I want to make is the very important statement made by the Honorable Attorney General that that credible evidence is going to be amended to relevant evidence. You know what that means? It literally took back all that he was talking about the Fugitive Offenders Act. Because relevant evidence means admissible evidence. It is what makes admissibility relevant. It is relevant, and that is what makes it admissible. And that is what we were saying, my contention was. And now you're going to say, because credible evidence, you can take everything that this person say. He could say all kinds of things about where the sun rises, and because he is saying it, it's credible. And so what's relevant is a totally different company altogether. And that is why I am glad, because obviously he was mistaken in his earlier debate, about this thing, credible evidence. He is now changing it to relevant evidence. I also want to make the point here, Mr. Speaker, that I noticed that he also mentioned, and very surprisingly to me, that he's going to change all the evidence to just a sufficiency of evidence. Now, I want to say this. A preliminary inquiry is an inquiry, whether it's paper committals or not, to reveal to the accused person the case that he has to meet. Now, if you're going to give only that sufficient evidence, and let's say you got 10 other witnesses that ought to be completing the evidence, and you hold it back, and you don't provide all the evidence, then the poor accused might not know what and who are the witnesses that will have to come up at trial. And that is, no, it is not his trial, because a paper committal requires of especially fair prosecutions to have fair trials, the concept of them knowing what they have to meet. And if they right now come and say, well, I'm going to only do a sufficiency of evidence so that the magistrate can commit, and I'm going to hold back 10 witnesses whose statements I do not give, but I'm going to give them at the High Court trial, that is being unfair. And I am encouraging the Honorable Attorney General, please don't get into that arena whereby you're going to change. If you have all the evidence that you are going to bring against that person, then it should be shown to him at the committal stage, that is the PI stage. No, yeah. Because at the trial, what can happen is that he would need time. He would need time, and you're going to just give him before 7 days or whatever the time? And then, well, you see, that's the trouble with this Attorney General. He hasn't practiced at the criminal bar. You got to go and investigate as to the background of that witness that you will be now put upon only in 7 days, and you might not get all of that going in your favor. But you have to understand, it is the concept of fresh evidence. Fresh evidence, you must not be surprised by it. If you got to get it down there, and if you want to be fair to the accused, bring all the evidence that you as a prosecutor got, so that indeed he will know how to prepare for his defense, which is a constitutional right. And don't tell me that we're going to change it from all to now a sufficiency of evidence just to get it done. All right, but I am making the point that since in a preliminary inquiry or the committal stage, an accused gets to know the case he has to meet, let him get to know the complete picture. That's all. If you don't want it that way, well, fine. Well, it is a prima facie case, but at least ensure that the evidence that he has to meet is known to him. And that is what the preliminary inquiry is all about. Mr. Speaker, those were the two concerns. I would not have made them had it not come from the Attorney General. I would have said that, yes, indeed, it is a transformational piece of legislation. We ought to have gotten it a long time ago. And indeed, it takes care of the times and the delays and all of that. And it also brings to bear that indeed we should have speedier trials, especially for indictable offenses and matters that will have to be dealt with by the jury. So indeed, I wish to support it, with the exception of let's not go not allowing the accused persons not knowing all the evidence that he has to meet at that very stage, so that when he takes a lawyer, the lawyer now gets all the statements. The lawyer gets all the statements from all the witnesses that is going to go to the trial before the jury. And that lawyer can prepare to meet all those witnesses in due time, rather than a 7-day period at the High Court trial. You give him some new evidence that he was not prepared for in this period of time. Now, let's read the thing. You got to understand what we lawyers do. at the criminal bar. I don't think you did so much work at the criminal bar. And please understand why it is that we have preliminary inquiries. It's to know the case that we have otherwise. And so please understand me. So that I support this bill wholly. And please, Mr. And not with no amendments that is going to come, because when I saw it, apart from credible, which ought to be relevant, it is not fair for cross-examiners not to know what they will meet up at the trial. They must meet that at the committal stage so they can do their preparation long before. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Member Mr. Ramjatan. Honorable members, let me apologize to the online persons following us because we've been having a lot of problems with the feed today and the ability of our members to sign in. And it still continues to happen. So we're still trying to fix that. And now for the Honorable Member, Mr. Sanjeev Dattadin.
Good evening, Mr. Speaker. Mr. Speaker, I wholeheartedly support the Criminal Law Procedure Paper Committals Bill, Bill number 7 of 2024. Mr. Speaker, this is a significant milestone in the evolution of our judicial landscape. The Honorable Attorney General should be congratulated for taking our criminal justice system from the ancient times into the modern world. The introduction of paper committals, Mr. Speaker, through this act will not only bring a system in place which the rest of the Commonwealth world has been doing for decades, but will no doubt bring a system of justice to Guyana, or the administration of justice to Guyana, which is most useful. Mr. Speaker, if we're going to pursue justice, fairness, and efficiency within our legal system, legislative reform is necessary. This particular legislative reform, Mr. Speaker, is a giant leap forward. It is a testament to the modernizing of the judiciary and the judicial system, but it pays homage to the adage and to the remark that justice must not only be done promptly, but it must be done efficiently. Member Duncan, it simply means if it's too fast, it might not be too good, and if it's too good, it might not be fast. So for those unfamiliar with paper committals, Mr. Speaker, if I may, in the current system of our judicial system, where we have preliminary inquiries are conducted by the taking of oral evidence, the challenges that are faced are not only that of time. The challenges that are faced is it's a burden on the service, the criminal justice system itself, to keep those records of pages upon pages upon pages, handwritten pages, I might add, of evidence. So all of the witnesses that are to be called are going to have to come to court. They're going to have to give all of their evidence. Then they're going to go through the process of cross-examination. the poor magistrate will sit there and copiously have to write every word said. Not only does that slow the system down unnecessarily, but it means that those records have to be kept and obtained and typed and then put into depositions, and then you can get to a trial. For those of us at the criminal bar, Mr. Speaker, you would know that upon completion of a preliminary inquiry that is conducted orally, it will take not an act of Parliament, but practically an act of God for you to have that record completed in time for the next session. It is physically impossible to be done. There's so many preliminary inquiries that are going on simultaneously that you have to get all the exhibits, all the records, and you have to have all of that done and then put into a deposition for the High Court trial. Mr. Speaker, what paper committals do would be to take the documents themselves, since the weight that could be attached to the evidence or the credibility of a witness could not be questioned at that stage. It is pointless to engage in lengthy cross-examination to find whether a witness is credible or not. It does not assist the defendant, and it only delays the process. What has to be found is there must be sufficient evidence for you to go before a jury. Now, Mr. Speaker, the judicial system must provide for all of whatever it is the state will use against you to be provided for you, to you, for your defense. The Constitution, Mr. Speaker, by Article 144C, provides that every citizen is entitled to a fair trial within a reasonable time, but also to the time and facilities in preparation of that trial. Time, meaning you must be given enough time to prepare your case, and facilities means you must know, and it has been adjudicated upon in the courts of the Caribbean, this country, the Caribbean Court of Justice, the courts of the Privy Council, that facilities means you must know what is the evidence against you. You must know the witnesses, you must know what are the exhibits, and you must have this in advance. Mr. Speaker, this act, this bill provides that since the test is one of sufficiency, that what you should have or what you have before the magistrate is sufficient evidence. Now, Mr. Speaker, the Honorable Member, Mr. Ramjatan, is advancing something that at first blush would appear to be a great concern. Essentially, what would or could happen is that only some of the evidence is disclosed to you, and the defendant, the citizen, is committed to stand trial based on that, whilst perhaps other evidence not disclosed to you is then brought to the trial before the jury. Mr. Speaker, there are certain fundamental concerns that they are with what the Honorable Member says. And for those of us who actually practice at the criminal bar, the situation would be this, Mr. Speaker. Firstly, the obligation to disclose all evidence in the possession of a prosecutor is absolute. If the evidence favors the defendant, the obligation and the threshold raises. It can't be left out and brought later, because that would be misfeasance or malfeasance, depending on whether you bring it against the state or the officer. But you cannot conceal that if you have it. Now, it would be known at some stage that that evidence exists, and the consequences will follow. Now, presumably, the only other situation that exists is if there is even more credible and further evidence that demonstrates that there is sufficiency and points more towards the quote-unquote guilt of the accused person. That is all not brought to the court at the magistrate's level and is brought to the court before the jury. But the honorable member, Mr. Ramjitan, would know, having been a prosecutor, that by the time the indictment is done, and the indictment is made by the director, the indictment must relate to a deposition. And following that indictment and deposition, that's what you go to trial on. So from the time of the indictment, the defendant, the accused, would be well aware of what is the evidence against him. You cannot be indicted upon evidence that does not form part of that deposition. So, Mr. Speaker, it is not a carte blanche for the Director of Public Prosecutions and other prosecutors to ambush defendants at trial with evidence. It will not work. The indictment, Mr. Speaker, for those of us that actually practice at the criminal bar, you would know that once the committal order is made, then the director will have an obligation that the committal must take place and the indictment must be filed. You can't hold a citizen, notwithstanding whatever order is made for his committal, indefinitely without an indictment. You can't hold for an unreasonably long time based on just that committal order. Now, Mr. Speaker, the situations that would be envisaged where the evidence might not be produced at the paper committal may in many cases relate to reports. Post-mortem reports might not have been done. They might have been in the cases, I know, that in relation to matters that relate to poisoning and such, it takes a much longer time for those reports and those tests to be done. But they could be sufficient other evidence that you could proceed on. Mr. Speaker, it is important to emphasize that what this bill seeks to say is you have to put enough and you have to put sufficient evidence before a magistrate to obtain a committal. Mr. Speaker, as said before, if there is conflicting evidence, if there is evidence that points to the innocence and the prosecution has it, there is no way that that could be held on to for any reason. The rules and the provisions in relation to that are vastly different. If it is to further strengthen and emphasize that which is already there, it has to be disclosed by the time of the indictment, which will be long in advance of you actually being made to appear in a court before a jury. Of course, if all else fails, Mr. Speaker, the constitutional imperative applies, and the trial could not fairly take place unless, or in the face of a complaint of insufficient time, and insufficient time within which to examine materials. So respectfully, Mr. Speaker, it's not a carte blanche to do it. It only would apply to certain kinds of evidence which reinforces that which is already there. It does not apply if it points to the innocence, and it could not apply if it is insufficient, if it is an indictment is proffered, and that evidence is not yet part of the record. Mr. Speaker, this is not the first foray in Guyana with paper committals. The Criminal Law Procedure Act of 2008 attempted by an amendment to certain provisions of the Criminal Law Procedure Act by Section 71A to introduce a regime by which paper committals could be done. Mr. Speaker, the intention was that in cases where it was requested, the magistrate had the option of so doing. Regrettably, it did not work. It was well-intentioned and it did not work. It did not work, Mr. Speaker, because it is my humble opinion that it was misunderstood. Change, especially for judges and lawyers, is not popular and is not sought. Most lawyers and judges will tell you they like the familiar paths and the familiar routes. They know the rules, they know the cases, they know the procedures, and they would ideally like to continue that. As a result, though it was possible and it was a right that a citizen had to have a paper committal, magistrates increasingly exercise their discretion in favor of oral hearings. In fact, unless I am mistaken, the Honorable Member, Ms. Chandan, might have presided over the very first one that was done as a paper committal. I was then a prosecutor. But, Mr. Speaker, this matter of the 2008 and the conduct of the matters went all the way to the Caribbean Court of Justice in a case of Sugrim and the Attorney General, which I was involved with. And our complaint was simple. It takes too long for an oral preliminary inquiry to be heard. The Constitution guarantees you a fair trial within a reasonable time. Reasonable time should mean what time is reasonable for you to conclude the hearings and get to the trial. It would not be done if it was going to be done orally, since given the statements, the defendant was objecting to nothing. Now, Mr. Speaker, it got all the way to the Caribbean Court of Justice, and sadly, because of the intervening process of the pandemic, by the time the hearing occurred in the Caribbean Court of Justice, the preliminary inquiry, the oral one, had indeed been completed. The court, however, did make a ruling that in the interest of justice, whatever was the most efficient way of getting a preliminary inquiry done should be done. The argument is always the same. It is confusing, and the Honorable Member, Mr. Ramjadan, perhaps assisted in that, in the argument about relevant evidence and admissible evidence. It's a non sequitur to say that all relevant evidence is admissible. The rules of admissibility are one set of rules, statutory mainly, and based on the common law, and the rules that relate to relevance is entirely different. There are situations where relevant evidence is not admissible. For example, the evidence of a wife. is not admissible against the husband and she can't be compelled. So it's relevant. She may have seen everything, but the courts can't compel her to say what she is seeing. So, but the basic thing about it, Mr. Speaker, is the determination that this bill seeks to secure is sufficient evidence. Meaning a judicial officer, a magistrate, is going to sit down and assess the statements of all the witnesses and the exhibits and come to a conclusion that there is sufficient evidence here. The elements of the offense are made out, and there is good reason that this person should stand trial before a jury of his peers. Mr. Speaker, efficiency and speed are assisted by paper committals. Paper committals significantly expedite the judicial process by reducing reliance on oral testimony at an early stage. You can move swiftly through. You don't have to find all the witnesses. You don't have to bring them. They don't have to spend time in court. This also has the effect of reducing the burden on witnesses. Spending time sitting in courtrooms and court corridors, waiting to be called to give evidence, say their evidence there, and then come back in 2 years and have to go through that same process, repeating it. When on the first occasion, there was no reason why they should have been made to do that. Their statement and what they said is usually identical to the written statement. Even if it were different, it would be an issue of credibility. And except for in exceptional cases where the statements are withdrawn or recanted, Mr. Speaker, the credibility is not to be considered in that court. There is the reduction of costs, the cost of time, obviously, the cost of the paperwork, the records, the record keeping, inconsistencies, errors with oral testimony and written statements for which lawyers and magistrates spend days arguing over, it wouldn't arise. Accuracy, because the record that is produced there is the record given to the defendant. The defendant, if it is that he goes before a jury, is ascertained that that is the same evidence. So he receives it then. Now there is the very great possibility that what happens in many cases is the evidence just, there is quote unquote, and pardon me for using the words, flimsy evidence or evidence which really don't indicate much else other than a passing interest in a charge. In many cases, those matters could be weeded out at this stage because a judicial officer would have to consider, are all of the elements of the offense here? Is there evidence of all the elements? Are there proper defenses? Do those, all of those things have to be considered. So, Mr. Speaker, the introduction of paper committals through this bill is forward thinking. It reforms our criminal justice system and it promises numerous benefits. It enhances efficiency, fairness, and effectiveness of our judicial system. The ultimate beneficiary is the public, and the public's trust will be earned once the system moves as it is expected to move. It will mean that there are cases, as I said before, that would be weeded out. That in itself reduces the burden. This is a pivotal change, and it upholds the principles of justice and the rule of law. With those few words, Mr. Speaker, I do wholeheartedly commend Bill number 7 of 2024, the Criminal Law Procedure Paper Committee Bill, to this House.
Thank you very much, Honorable Member. Mr. Dattadin. Now for the honorable member, Ms. Geeta Chandan Edmund.
Thank you, Mr. Speaker. I rise to make my contribution to Bill number 7, the Criminal Law Procedure Paper Committal Bill Amendment. A bill entitled An Act to Provide for the Abolition of Preliminary Inquiries, to provide for the procedure in respect of paper committal proceedings in criminal matters and for matters connected thereof. As we've heard from the speakers before me, this bill has 20 sections. Part 1 includes the preliminary section, Part 2 includes the procedure in paper committals, and Part 3 deals with the general miscellaneous provisions. There are some aspects of the bills that I would want to touch on, but my honorable colleague, Mr. Ramjutan, has touched on those aspects, so I will not go into that. As someone who has had the experience at the bench and continues at the level of the bar, for me, this bill is extremely important. For decades, the backlog of cases has been with us, and it has remained a perennial problem, a challenge not only to witnesses, it remains a challenge to litigants and to the entire judicial system. Sir, the preliminary inquiry, or PI, has had its place in the jurisprudential process. Before I proceed, it is useful to remind us all that the original purpose of committal proceedings was an act to filter, and the Attorney General has mentioned this. It's an act to filter to ensure that unfounded criminal charges were not pursued to trial and that there was reasonable and sufficient evidence before the court. The rationale was that an accused person should not have to go through the expense and stress of a criminal trial in relation to charges that were wanton and misconceived and for obviously other purposes. On this consideration, the preliminary inquiry was the method which gave effect to the aforementioned consideration. Committal proceedings have had a long common law history predating the creation of organized police forces and independent prosecution services. They date from a time when criminal complaints were brought by private citizens. I don't want to go into the history of how preliminary inquiry came about because I think the Attorney General did that, and most of us here have an understanding of that. But as an attorney, a practicing attorney, I can tell you that preliminary inquiry has had its legal place, but over the years, the process, it has produced outcomes that have caused a bureaucratic mess, and it has resulted in the abuse in human rights of citizens. With that in mind, I hope to disabuse anyone of the notion because sometimes when you start speaking, members of the House do not know which way you're going. So I want to disabuse this notion that I am not against this bill. I am fully in support of this bill. Fully in support of this bill. We have had citizens who have been declared innocent after spending maybe 8, 9, 10, or 12 years on remand. We know that there have been issues. The process has been exacerbated the problem of overcrowding in the prison system, and that's where my concern is. Overcrowded prison population appears not only to be common in Guyana, but in the Caribbean. So this is not me throwing punches at anyone here, and for any member of the House to take it personally. I am going to quote now what was stated in the IDB report. The Inter-American Development Bank, they conducted a research between 2016 and 2019, and they targeted several Caribbean territories, particularly Trinidad, Suriname, Bahamas, Barbados, Jamaica, and Guyana. And the findings of the studies disclosed that prisons in those countries were overcrowded. And for Guyana in particular, this situation was associated with the lengthy incarceration periods before trial. So, to reduce overcrowding, the report proposed that the judicial system should place emphasis on rehabilitation of inmates and cut back on pre-trial detention. The World Bank brief database disclosed that Guyana's current prison population, inclusive of pre-trial detainee, stands at around 2,156,000. And so taking this figure into context with consideration to the Lusignan Holding Bay, which was not originally constructed as a full-fledged prison, the overall capacity should have been 1,323 prisoners. In March 2016, 17 prisoners died at a prison unrest and a fire at Camp Street Prison, while another fire was set at the same facility 1 year after. The latter destroyed most of the structures in the prison compound. So it is important to emphasize that a commission of inquiry into the prison unrest later disclosed that the incidents could have been averted if overcrowding was managed accordingly. So, sir, there should be no debate. We do have a problem here, and we have had this problem. The key question is, will the end of preliminary inquiries result in the problem disappearing? That's the problem of overcrowding. I hope so, but we have to also be very realistic. My friends on that side of the house must learn to embrace data-driven governance. The government and the Lord Attorney General have not, as far as my knowledge serves, commissioned any study that produced data which shows a definite correlation between the end of PIs and prison overcrowding, which I believe is the primary concern of the government. I have not been referred to a model that resembles any circumstance that tells us that there is deliberate or targeted policy making which has been tried and proven. And I'm speaking here from a position of experience, and I'll vouch for my colleagues in the judicial system. They do try their best with the available resources, both human, material, and otherwise. But the crux of the matter remains. The problem is, and we've seen in the system, which has mainly to do with the time that it takes for cases to go through the system. Despite legislation which compels the judiciary to produce decisions within a given period of time, and sometimes there is undesirable pressure from some political quarters, the problem remains. It remains because of the shortage of judges. And I know you're going to say there has been recent appointment, and I'm coming to that. But for years, the non-appointment of the Judicial Service Commission for political reasons has produced a shortage in the system. It is as well and good to lecture magistrates and judges about completing cases, but when a backlog is before you, it is almost inhumanly possible to read cases, check case law, apply a judicial methodology, and render a decision that considers fairness and justice and the evidence and every other thing that you have to consider in a matter. So you cannot decide on committing someone to life in prison for the sake of expediency or sentencing them. No legal authority can decide or should decide or ought to decide someone to be committed to prison or sentence for the sake of expediency. So there has to be careful consideration. Mr. Speaker, the core question should be, Will the abolition of PI, which I've said before, I totally support, but will it solve our problems? While it is a good idea, we have to consider that our problems are part of a whole. The paper committal might address one part. The key part that should be considered here is whether the lengthy PIs are the only reason for the backlog that has spanned for so many years. Immediately, Mr. Speaker, I can point you to the UN report. The Caribbean Justice states, and I quote, a needs assessment of the judicial system in 9 countries, and I state, and I quote here, another important conclusion of the report is that in all jurisdictions, the backlog of cases, particularly in criminal division, is one of the most challenging issues. The reason for the backlogs are multifaceted and include primarily the slow pace of investigations by police, inordinate delays in the production of deposition, and the lack of human and technological resource. The main consequence of the backlog is a failure to provide accessible, fair, and efficient justice for the people and the states of the Caribbean community. End of quote. Mr. Speaker, this report here, it is not based on hearsay. It is not based on political consideration. It is based on a needs assessment and a fact-based and data-driven. The report laments that change without any attempts to fix the system will not yield any major results. I will not question the government's motive on the matter. I believe, and I've said this from the inception, they are well-intentioned, but the method is flawed, and this is consistent with the problem with their approach to governance. They tout change, but they do not completely fix the system. We are not the enemies here. We are not your enemies here. At the heart of the matter is the early resolution of matter, and it is evident that the government is of the view that the abolition of PI, early resolution of matter at the lower court, will immediately kick in. But this is not a given, Mr. Attorney General. We must recall that the judiciary needs to be properly staffed, not just at the level of the bench, but at the supporting level, supporting staff, and the provision of appropriate technology and resources, etc. The worth of the bill has to be viewed in the larger context, and we welcome the recent appointment of judges, but there needs to be much more, and that's the point that I'm making. We must recall that committal proceedings have been viewed as an important element of the right to a fair trial, ensuring independent scrutiny of the evidence before an accused person faces trial. Their importance from the perspective of a fair trial rights has also been defended on the basis that there are key mechanisms through which an accused person obtains disclosure of the prosecution case, etc. So while we welcome this bill as an attempt to deal with the problems associated with PI, the government will be well advised to consider the system as a whole and work to improve the other areas that are connected with the backlog and the other problems in the system. I thank you.
Thank you very much, Honorable Member, Ms. Geeta Chandan Edmond. And now for the Honorable Minister of Education, Ms. Priya Manacha.
Yes, thank you very much, Mr. Speaker. Mr. Speaker, there are 2 truths we know. One, that victims find the system takes too long to address their matters. And 2, that accused people find that the system takes too long to deal with their matters. And we know that. What is a preliminary inquiry? Because we had a lot of legalese that came before us. It's really a preliminary hearing to determine whether there's enough evidence to where a judge can convict, can properly convict, having regard to the evidence. And how we did it in Guyana up to now, except for sexual offenses after 2010, was to have a full hearing. The magistrate would sit and call witnesses for the prosecution. They would be cross-examined, that is, questioned by the defense. The magistrate would write everything down. In 95% of the cases, the matters would be referred to the High Court for trial. So this was a trial within a trial, a long process. In most cases, it took very, very long, and it deterred persons from proceeding with their matters. And I'll tell you a story of a girl that is true. She was just finished high school, living on the west coast of Demerara, came and did an interview for a job at a business place in Georgetown on Saturday, got through with her job on Saturday, turned out for work on Monday, and on Monday, she was promptly raped by the owner of that establishment. The owner was represented by an attorney at law who kept delaying the matter. And if the record will show, the attorney was out of the country, the attorney was in the High Court, the attorney was out of the country, the attorney was in the High Court, the attorney could not make the matter. For her, better didn't come. That attorney, who was recently been successful at his party's leadership quest, for her, better didn't come. And that is very common for victims of various types of crime. We heard from the honorable member just now, Ms. Geeta Chandan, that there was a fire in, well, before I get there, so the purpose of having a relook at this was to prevent persons, both victims and accused, from waiting extraordinary long times, and then the natural consequences that would flow from that, one of which would be overcrowding of prisons. The honorable member read from a report that gave her statistics and gave her government and her party in government statistics. And she said there was a dastardly, deadly fire in 2017. And unfortunately, nothing was done by that party in government to change any of the statistics. And while there are many things that must happen, to change a system, and particularly a criminal justice system, it has to start with the law. There's no magic in that. This was a sit down across the table, around the table, start with a law that will make sense, and then try to implement that. The previous government did not even find it necessary to do that. I can't think of a single piece of legislation they passed that is being implemented now that has changed lives in this country. There was the tax measure to remove taxes from drones to shy paddy. I'm not sure how far that went, but that's the kind of measures we saw by the AP and UAFC. Nothing solid. Mr. Speaker, after we had case after case after case where victims were withdrawing from the process and accused persons were either incarcerated for lengthy periods or being unfairly treated, we, using statistics, using people's experiences, had a relook at how we could change preliminary inquiries from viva voce evidence, that is giving oral evidence in the court, to making it easier and using paper committals. And we went to the country with a document called Stamp It Out that was actually printed by the honorable member, Mrs. Cathy Hughes, which evidences the fact that those claims that we never used to give work to people who were from the opposition were always untrue. This document was the product of a contract with a member of the opposition for printing it, and it was well done. And so Mr. Speaker, the paper committals The preliminary inquiry is one of the main causes of the low conviction rate of sexual offenses. Once the accused has been charged, the preliminary inquiry is supposed to be a short initial hearing before a magistrate to decide whether there is a sufficient case to go to the High Court for trial. The threshold is supposed to be very low. If a reasonable jury could possibly convict on the evidence, the case must go to trial. The magistrate cannot make any decisions about the facts of the case, so the credibility of witnesses cannot be judged. Mr. Ramjatan has left the chambers, it appears. This means that in
He
other...
asks to be excused.
That's fine, sir. This means that in other countries, the vast majority of cases would get past the preliminary inquiry stage. For example, in the UK, before oral preliminary inquiries, that is the one we're doing now, were abolished, 90% of the cases would go to court for trial. Despite this, in Guyana, the oral PI stage, preliminary inquiry stage, frequently lasts for several years, like the girl that I told you about, with all witnesses called and intensively cross-examined by the defense. The whole trial is then played out again in the High Court. In 2000 to 2004, more than 3/4 of sexual offenses cases did not make it through the preliminary inquiry process to even begin the High Court trial because of the harassment I had mentioned in that one example. The purpose of the oral PI was thought to be to let the defendant know the case against him and her and to weed out weak cases. However, oral PIs are not necessary to achieve either of these aims and have never existed or have been abolished in many countries. As the English judge Lord Devlin said, what emerges at the end of the PI ceremony is a bundle of statements which could just as easily have been handed over to the defense at the beginning. In the rare cases where it is contended that there is no case fit for trial, the point could be determined by a judge or a magistrate on these written material. A Chief Justice in Australia has described the oral PI as a complete waste of time. The same information can be provided to the defendant in written form, and the police and prosecutors with limited resources are already weeding out many of the weak cases that do not have much hope of conviction. Cases are not falling away at the PI stage in Guyana because they are weak. Strong prosecution cases disintegrate due to the long delays as witnesses move away or lose touch, memories fade, and the victim repeatedly called to court only for the case to be adjourned or intensively cross-examined, knowing that the whole process will be repeated at the High Court, may decide that he or she cannot continue with the case where the victim is a child. The trauma of the process is even greater. Moving to paper committals instead of oral preliminary inquiries will address these issues and free up much magistrate court time, which is badly needed to deal with other matters and reduce the backlog of cases. These cost and efficiency savings have led to reforms in other countries. It is also recognized that in the justice sector reform strategy that the procedure must be streamlined. The legislation will introduce a system of paper committals for sexual offense cases. And I'm reading here from that Stamp It Out document. Paper committals have now replaced oral PIs in England, and most of the Commonwealth Caribbean has moved to paper committals, including Antigua, Barbados, Dominica, Grenada, Jamaica, and Trinidad and Tobago. The prosecution will give a bundle of written evidence to the defense 7 days before the hearing is to be held before a magistrate. At the hearing, only the prosecutor and the defense and/or the defendant's lawyer needs to attend. In this case, the magistrate will not read or assess the evidence at all, because in the vast majority of cases, the prosecution and defense should be able to agree that there is a sufficient case to go to trial. If the defendant has no lawyer, or if the defendant does make a no-case submission, then the magistrate will hold a limited hearing for the purpose of determining whether there is enough evidence. The magistrate will be required to give reasons for his or her decision that will be entered on the record of proceedings, and it's that record that will proceed. That paper, Mr. Speaker, resulted in the Sex Offences Act of 2010 as amended by Act number 7 of 2013. In that act, at section 4 to 3 of that act, prescribes for the abolition of oral preliminary inquiries and lays out in Schedule 1, almost verbatim, the act that we are passing here today. So Guyana, as you heard from the Attorney General, had in 2008 introduced paper committals. It never worked. We introduced it again in 2010 through the Sex Offences Act, and that has been the only thing that has been used from 2010 to now, and it has worked. The data shows that it has worked. But my learned friend over there said that we don't study what we do. We don't use data to determine how we should make our policies or how we should make our law. And the honorable member relied on the fact that she's a practicing lawyer. She may be interested in Justice Bulcan's Court of Appeal judge, who was reported at 96 WIR at 424 in the DPP versus Bacchus. And this is what he had to say. He said, having regard, therefore, to all of this, the Sex Offences Act can be viewed as an exceptional piece of legislation that represented a genuine and thoughtful effort to respond to weaknesses in the criminal justice system. It was the product of considered consultation and expert advice. It received unanimous support in the National Assembly, which I might add is a rare thing, and it was an effort at reform of criminal practice that many other jurisdictions have long enacted. It can also be seen as ensuring compliance with our own international commitments. And that was one judge, Mr. Speaker, that spoke on this issue. And so the honorable member standing in this House as an MP and an attorney at law who held a very senior position in the last government, standing here now saying that nothing is done when we find out their problems is bellowing in the wind. That honorable member had all the information she now has when she was in a place that she could have made changes, and absolutely nothing was done. Absolutely nothing was done. What we're doing here today, Mr. Speaker, is passing law that has to be implemented. And like any other law that has to be implemented, there is going to be a period of trial and error. And Kemraj Ramjitan, honorable member, said it. He said this is going to be tested. It's going to be tried, it's going to be tested, like happened in the DPP versus Ray Bacchus. And what happened here, Mr. Speaker, was that Ray Bacchus was charged for having sex with a child under 16. And it went before Magistrate Shardell Isaacs. And she did as she was mandated by the court, by the law. She held a preliminary inquiry, and she said that she referred him for trial. Through his attorney, he then went to the High Court, and he said that this preliminary inquiry, because it was just paper-based and it did not allow his lawyer to cross-examine witnesses, was a breach of his rights under the Constitution to a fair trial. And the court heard that through Justice Chang in the High Court, and he actually upheld those submissions. And he said, while there is no constitutional right to a preliminary inquiry, once a hearing was going to be done, that the defendant had a right to cross-examine. Sorry, sir.
Honorable member, just give us a minute. We want to ask Minister of Parliamentary Affairs to move that we continue our business for today until it's completed.
Thank you very much, Mr. Speaker. Under standing orders, I believe it is standing order 10. We'd like to ask that the House continue to complete the order paper until we conclude this evening.
Thank you, Minister. Those in favor? Aye. Those against? Ayes have it. Continue, Minister.
Thank you, sir. And so the High Court ruled that Mr. Bacchus his rights had been breached because he ought to have been allowed to cross-examine at the preliminary inquiry, as the country had become accustomed to for all the time that we'd been practicing in the criminal justice system. And the DPP appealed that matter, and it went to the Court of Appeal. And unanimously, all the judges there, Justice Yonet Cummings, Justice R.F. Bulkan, and Justice Roxanne George, they unanimously ruled that the High Court was wrong, that the defendant, the accused, in this case the respondent, Mr. Ray Bacchus, was not being denied any rights, because while he couldn't cross-examine at the preliminary inquiry stage, he would be allowed to cross-examine to his heart's content at the High Court, and so no rights were being breached. And they were very clear that, in fact, again, quoting from Justice Bulkan, he said, you know, progressive societies are expected to continually explore and implement new and better ways of doing things. We cannot be held hostage to antiquated procedures from centuries ago. Courts, and more importantly, legislators, are constantly looking on improving the delivery of justice. It is against this context that that act must be viewed. And they looked at the act as a whole and what it was intended to do, and all of them came down on the same thing. There was a procedural point that they all found the same way, but they all came down the same way, that the general good that this section of the act was aimed at, to reduce backlog, to make sure that the trauma that victims go through with the repeated hearings in the lower court and then the higher court, that outweighed any kind of comfort we had from the preliminary inquiries that we had become accustomed to. And they were very, very clear that, in fact, Justice Cummings went on to say, even if the act infringed the constitutional right of an accused, the objective which it is designed to achieve is of sufficient importance to warrant it overriding the constitutionally protected rights of the defendant and Justice George of the complainant. And Justice George said this: the paper committal provisions are to assist in safeguarding the rights of victims not to have to go through the trauma of telling their stories repeatedly. The paper committal system also allows for both accused and victims to have trials conducted in a more timely manner with less delays. This is now especially the case in the county of Demerara, where a dedicated sexual offenses court has been established. The paper committal system for the conduct of these cases results in better compliance with Article 144, which mandates a fair trial for defendants and accused persons. In other words, Mr. Speaker, this is going to be hard. This is going to be uncomfortable. It probably is most likely going to be tested. I'm not sure, given that we've had this since 2010 in the Sex Offences Act. But the greater good here is that we'll have less delays, we'll have less backlogs, we'll have less trauma for victims of crime, different types of crime, and we'll have a speedier move through the system. And so for those reasons alone, I encourage everyone in here to support this act and vote in favor of its passage tonight. The two important points, well, 2 points were raised by Mr. Ramchitan. One, and I want to put on record that the act as we see it now has timelines, and those timelines were not accidental. In the whole structure and architecture of what we're trying to do in the criminal justice system and the justice system, not only criminal justice, with the new civil procedure rules, with the new family rules, new being relative terms, with this new process here, it's to streamline and bring speedy resolution, speedy also being relative, resolution to matters before the court. And so I'm noting specifically clauses 6 and 7 of the Act, where there are timelines given. 4 to 5 days after person is charged, they must have these statements. 4 to 5 days after that, responses must be given. And those are deliberate attempts by all of us in this House, and I hope that's how it's seen by the people who will implement these acts. This as an act, the court as well as the police and defense lawyers, it's deliberately outlined here specific numbers of days so that we could get past the lengthy counsel is in the High Court, counsel has left the country, counsel has left is in the Court of Appeal, some of which is not always true. You hear those things and you see them walking on the road sometimes. And so this is deliberately set out this way so that we could make sure these matters are heard expeditiously to the benefit of the victims and defendants also. I do note that clause 7(4) has an exception that says the court may, for good reason, extend the time for filing and service of evidence on the part of either party pursuant to subsections 3 and 4. And I want to put on record here, because I know sometimes the Hansards are used to interpret what we meant. This was meant to be observed as an exception, not as a breach. So I hope that prosecutors and defendants are not going to be using this particular section more than any other, coming to the courts to ask for extensions of time, because it is our intention here that it's to be used in rare circumstances where parties really could not make the 4 to 5 day timeline. It is not to be used in the breach, where this is the section that everybody relies on and knows out of their head, because they're asking for that. Additionally, Mr. Speaker, Mr. Ramjatan raised the issue of the amendment that the Honorable Attorney General is going to lay before the House that says, that removes the word all. And I want to assure him and say that it is not our intention in this House to hide any evidence, and we can't hide any evidence from the prosecution, cannot hide any evidence from the defense, or vice versa, and Mr. Datadin went into why. It simply will not be allowed. What this section is intended to do is to cure what's happening now, because the Sex Offences Act says that evidence must be laid by a specific time, and all the evidence. What is happening if prosecutions ask the High Court to allow evidence that was not laid? It's being, that request, that application is being used to the detriment of victims and complainants, and this here will allow us to cure that. It's again to be used in the rare circumstances where evidence is discovered afterwards, or as Mr. Datadin said, tests went for something and didn't come back in time, but otherwise there's a sufficient case and there's no need to wait until those come back. So I don't think the concern, I understand the concern, but the idea here and the intent is not to hide any evidence or to say, we'll just spring it on you when you get to the High Court. It is to say that in the event that something was not picked up, especially in cases with children, where a child says something, a video is made, for example, that video was not discovered at the time that all of this was happening, it's discovered later on, you'd be able to use that as evidence if it is admissible, of course. And so this is more to cure something that, from experience from 2010 to now, we've seen the effusive effort to say all evidence must be laid, given our weaknesses in investigation, policing, and all of that, that has caused problems and has interfered with the delivery of justice, and that Mr. Nandlal is going to move for later on in this afternoon. That provision will be to cure that possibly happening again. With those few words, Mr. Speaker, I wish to commend the Criminal Law Procedure Paper Committal Bill, Bill number 7 of 2024, for passage in this House.
Thank you, Honorable Minister Manichan. And we'll have the Honorable Attorney General closing the contributions to this bill.
Thank you, Mr. Speaker. Mr. Speaker, I said several times in the course of my, first of all, sorry, permit me to thank my colleague, Minister Manik Chan, for an excellent presentation on the bill, and to thank also the Honorable Member Kemad Ramjatan, the Honorable Member Sanjeev Datadin, I'm so sorry, and the Honorable Member Geeta Chandan for their outstanding presentations. I did say during the course of my presentation several times that newness and anything that is innovative attracts suspicion, attracts challenge or challenges, attracts criticism. And so it was when we enacted the sexual offences bill, quite apart from the paper committal component of the bill was revolutionary in many respects. It abolished many of the archaic rules, evidential and otherwise, in relation to sexual offenses. So in sexual offenses, it's difficult to get a conviction if you don't have the virtual complainant's testimony being corroborated. It's difficult to get a conviction if the virtual complainant did not make her complaint early. And many evidential issues that were attendant to sexual offenses were removed. It was the first time in the history of our legal system that a witness, in this case a virtual complainant, would have been testifying in the absence, well, not in the absence, but not in the physical presence of an accused. First time that ever happened, we had to construct a new court. That did not sit easily with our population. There were challenges, as we heard. And our courts have, not our courts alone, courts across the globe have dealt with those challenges and dismissed them. And you heard Justice Bolkan speaking about an evolving society and that we simply can't be doing the same thing for 100 years and expect a different result. What happened to your elections? How a man come from nowhere and hijack the whole election? So let's get back to the bill. So Mr. Speaker, $4,800 man by the whole party. So, Mr. Speaker, so when the paper committal was introduced, because it abolished the right to cross-examine, it abolished oral testimony under oath, it deprived the magistrate from the benefit of observing the demeanor of the witness and witnesses so that the magistrate can make an opinion on whether the witness is telling the truth or not. All those things were removed. And they were viewed at the time as being invasive and offensive to the right to a fair trial. and the courts of the region and the courts across the Commonwealth frontally dealt with those matters and said very, very emphatically and in unison that those changes did not affect a right to a fair trial. I come to the objection raised by the Honorable Member Kemraj Ramjatan because he is in that very mold of being suspicious of changes and not being willing to approach the amendments with an open mind. So, Mr. Speaker, we have heard over and over again that the purpose of the preliminary inquiry is not to determine guilt or innocence of the accused person, but simply to determine whether a prima facie case has been established for the person to stand trial. Now, if that is the conceptual and only purpose of the preliminary inquiry, then why must there be a duty to lead evidence that is over and above that which is required to establish a prima facie case? If the only test is to determine whether a prima facie case exists, why are we required to lead evidence over and above that test? It does not make sense. That is why all that is required in every other country in the Commonwealth, including England, since 1967, is that you lead sufficient evidence, and that's why the test is called the sufficiency of evidence test, sufficient evidence to establish a prima facie case. You don't take a sledgehammer to kill an ant. That's the principle. Or a fly. And Mr. Speaker, unfortunately, our law required, or requires, because it's still the law, requires the prosecution to lead all the evidence. It is onerous, it is unnecessary, and it is not required. And that is why we have changed that position now to bring it in keeping with the rest of the Caribbean. And I challenge my learned friend, he's not here, I challenge him to find a jurisdiction in the Caribbean that has a requirement which compels a prosecution to lead all the evidence at the preliminary inquiry. Such a provision does not exist. It does not make sense. That was the common law position. We kept it in Guyana, unfortunately, and now we are changing it to bring the law in conformity with the rest of the world. And that is why, Mr. Speaker, Clause 20 of the bill, Clause 20 of the bill says this: any person whose statement, deposition, document, or exhibit was not tendered in evidence by the prosecutor or the accused during a paper committal may give that evidence at the trial of the accused person. So right here, the foundation is laid to lead evidence at a trial that was not led at the paper committal stage. Whether it was available or not is immaterial. A prosecutor exercising their deliberate judgment can make a judgment call. If I have enough evidence to put in the PI for a paper committal, I will put that. I don't have to lead all. And Clause 2 of the bill says, a party seeking to adduce such evidence, and let me pause, it applies also to the defense. So if there is any belief that it is lopsided or one-sided, it is not so. It applies both to the defense and to the prosecution. That is why clause 2 is phrased the way that it is. A party, meaning prosecutor or defense, seeking to adduce such evidence, meaning the evidence that you have not adduced at the PI by paper committal, shall serve the evidence in the form of a statement, deposition, or document which would be admissible under this part on the other party to the proceedings 7 days before the date on which that witness will give evidence at the trial, or the content of the statement, deposition, or document will be entered into evidence. So you have 7 days to give notice, serve the document, the statement at the trial of the witness that you intend to bring. And if, Mr. Speaker, there's a judge who controls the process, if the judge believes that the defense requires more time or the prosecution requires more time in respect of the days, then a judge will have the power to extend it. But a minimum of 7 days notice must be given. And what is wrong with that? What is wrong with that? That is the position all over the world. So, Mr. Speaker, Mr. Ramjatan is causing unnecessary pandemonium in his objections. Mr. Speaker, I come now to the Honorable Member Geeta Chandan. Well, Ms. Chandan chose to take the position of commenting on everything that is wrong with this. While she supports the bill, she then went on a panoramic, critical examination of the entire legal system of the country and say, why are you not fixing all of this? And that is the approach. Not very sensible, not very constructive, and critical only for criticism's sake. That doesn't lend anything to a debate, Madam, Your Honor, Honorable Member. Doesn't lend anything to the debate. You supported the bill, and you should have stopped there. And Mr. Speaker, the Honorable Member, you see, the Honorable Member may not have been a minister of the previous government, but she was very much part of the government in the very nucleus and the epicenter of executive power, ensconced in the office of the president, very closely proximate to the then powerful Minister of State. So I presume that she had access to the poles of power. But she was unable to cite a single recommendation that she may have made, having known of all the ills which afflict the system, which she recited for us. And she was a former magistrate, so she knows of the issues that she's speaking about. But she couldn't cite one single recommendation or initiative or advice that she tendered to cure all the deficiencies that she regaled us about. And worse, she was unable to cite, after 5 years in government, a single measure by that government, the Attorney General at the time, to fix any of the problems that she referred to. Not one. Mr. Speaker, we inherited a loan program that was being administered by the previous government, a support for criminal justice project. It was about to be shut down. It was about to be shut down. And we took it over for the lack of action. There was paralysis. It was suffering from paralysis. and we activated it into action. And I have a series of bills, all dedicated to improving the legal system of this country. Most of them coming from that initiative. I have excluded the non-legal bills. And let me put on the record for your information. The pre-bargaining bill, the family violence bill, the bail bill, the sexual offences amendment bill is going on now, the restoration of justice bill, the alternative sentence bill, an evidence bill is being worked on, a judge alone trial bill, the matrimonial causes amendment bill, the reciprocal judgment bill, the arbitration bill, the intoxicating amendment liquor bill, the amendment to the road traffic Act bill, the deeds registry amendment bill, the power of attorneys amendment bill, the civil law amendment bill, the summary jurisdiction amendment bill, a harassment bill will soon come, a firearms bill will soon come, the adoption of children amendment bill, the trafficking in person bill. You want me to continue? All of that from 2020 to now, all dedicated to address the legal efficiency or deficiency in the system. We appointed 10 judges, the largest number of judges ever appointed in the history of the English Commonwealth. All of that, Mr. Speaker. So, Mr. Speaker, when it comes to performance, when it comes to delivery, you can't compare the two, Mr. Speaker. There's another point that Mr. Ramjatan made, which I just recall, and I must correct it for the record. Mr. Ramjatan does not appreciate the difference. Well, he says that all relevant evidence is admissible. Now, all relevant evidence generally is admissible unless it is excluded by one of the exclusionary rules of evidence. Relevance is the North Star for admissibility. So relevant evidence will be admissible. However, there are relevant evidence that is rendered inadmissible by exclusionary rules of evidence. For example, you may have something good, very probative to say, very relevant, but because it constitutes inadmissible hearsay, it is not admissible. Right? Because you can have, as my friend is saying, admissible hearsay. Confession statement is admissible hearsay. And obviously it's relevant. But not all relevant evidence is admissible. So Mr. Ramjatan, with all the years of experience that he spoke about, in particular at the criminal bar, that rudimentary principle eluded him. Eluded him. That elementary principle. So, Mr. Speaker, with those few remarks, I commend this bill for passage, and I have some amendments that I will move at the appropriate time. Thank you very much, Mr. Speaker.
Thank you very much, Attorney General. That concludes our contributions to the bill. And now I put the question that the Criminal Law Procedure Paper Committals Bill, Bill number 7 of 2024, be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Criminal Law Procedure Paper Committals Bill 2024, Bill number 7 of 2024.
We will resolve ourselves into committee to consider the clauses of the bill. Honorable members, we have two amendments at clause 7 of the bill. And so I will now propose the question that clauses 1 to 6 form part of the bill. I now put the question that clauses 1 to 6 stand part of the bill. Those in favor say aye. Those against say no. Ayes have it. Clauses 1 to 6 now stand part of the bill. Honorable members, I now propose the question that Clause 7 stands part of the bill. Honorable Attorney General.
Thank you very much, sir. With your leave, I move that Clause 7 be amended as follows. A, in subclause 1, by substituting for the word credible the word relevant, and B, in subclause 2 and 3, by deleting the word all wherever the word appears.
Thank you, AG.
Thank you very
The
much, sir.
proposed amendment has been circulated. I now propose that Clause 7 as amended stand part of the bill. Honorable members, I now put a question that Clause 7 as amended stands part of the bill. Those in favor say aye. Those against say no. Ayes have it. The amended Clause 7 now stands part of the bill. Honorable members, I now put the question that Clauses 8. I propose the question that Clauses 8 to 26 stand part of the bill. Honorable members, I now put a question that Clauses 8 to 26 now stand part of the bill. Those in favor say aye. Those against say no. Ayes have it. Clauses 8 to 26 now stand part of the bill. Honorable members, I now put a question that the bill as amended be reported to the Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the Assembly resume. Honorable Attorney General and Minister of Legal Affairs.
Mr. Speaker, I rise to report that the Criminal Law Procedure Paper Committals Bill, Bill number 7 of 2024, has been considered in committee clause by clause and amended, and I ask that the bill be passed as amended.
That the bill be read a third time and passed.
And the bill be read a third time and passed as amended.
Thank you, AG. Honorable members, I now put a question that the Criminal Law Procedure Paper Committals Bill 24, Bill number 7 of 2024, be read a third time and pass as amended. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Criminal Law Procedure Paper Committals Bill 2024, Bill number 7 of 2024.
Honorable members, we now move to the Motor Vehicles and Road Traffic Amendment Bill 2024, Bill number 9 of 2024, published on the 15th of May 2024. Honorable Minister of Home Affairs, Robson Horatio Brinley Ben.
Thank you, Mr. Speaker, honorable members. I rise to move that the Motor Vehicles and Road Traffic Amendment Bill 2024, Bill number 9 of 2024, published on the 15th of May 2024, be now read a second time. Mr. Speaker, we have noted generally, and I think admitted on all sides, the growth and development of our country. Along with this growth and development of our country, along with the investment in roads, along with the increase in vehicles on the road, we still struggle with road traffic accidents and deaths. To put it in some context, and I have to note that the United Nations and the International Roads Federation have promulgated the decade of road traffic safety, and that from 2021 to 2030, there should be a reduction of by half of road deaths across the world. That is the intention in terms of promulgating the decade of action in respect of road traffic safety and the resorts to make improvements and to protect not only deaths in itself, but also injuries resulting therefrom. Mr. Speaker, if I could just go to 2020 in terms of our road traffic deaths. We had a spike in 2020 of 139 road deaths, of which 9 were children. In 2021 and 2022, our deaths reduced dramatically against 2020 to 99 deaths for those 2 years. And then 2023 was a very difficult year, a bad year. In 2023, we had 175 deaths, of which 6 were children. Year to date, our road deaths are 57, and that's year to date June. It is 57 deaths, of which 2 are children. While we talk about these reductions, because the reduction from this year to last year on the year-to-date basis is 26%, we are understandably too very worried about the situation, and we have been working fairly hard to bring the situation under better control for this year and going forward into the next years. We have had previously alive programs, projects to bring greater public awareness to the question of road accidents and deaths. We have now an initiative called Respect the Road, with prominent billboards and awareness sessions and white nights. We are working on a new initiative because we figure that a big part of the problem is that adults, and many of them young adults, are not doing the right thing in respect of road traffic behavior, use of the roads, greater awareness, providing better examples in respect of the problem. We note that one of the reasons which has been driving up our road traffic accidents and deaths, in spite of the increase in road infrastructure and bridges and all of these things, and efforts at making putting in place more and more road traffic signs, working with the Guyana Road Safety Association, trying to get social media more enthused in the matter and other forms of media, and also trying to get the private sector more involved. While there have been some progress along that way, we're still working on trying to get the insurance companies, the companies which sell motor vehicles and spares and parts, to get more involved in the direction of helping to reduce and support the effort to reduce road deaths and road traffic accidents. One thing we have to note, and it's visible, and I have to note that the Honorable Attorney General did say a few days ago that the whole country is a construction site. And it's evident in the number of trucks on the road fetching construction materials, the number and type of different construction vehicles dedicated to building things and moving things. And we note too the increase totally in the number of various types of means of transport on the roads. If I talk about lorries, we had 1,422 lorries on the road in 2020. Today, we have 3,606 lorries, an increase by over 120%, more than double. In terms of minibuses, in 2020, we had 533 registered operating. In 2023, we have 1,456, a 300% increase. In terms of pickups, we had 434 pickups registered and working. In 2023, we have 1,563 operating on our roads. If you are talking about direct production units, tractors registered, and perhaps not all, we had 273 in 2020. We have a doubling, 588 in 2023. If we talk about vans which carry goods and things for small commerce and other issues, we had 157 in 2020. We now have 340, a doubling. So in spite of more roads, more efforts and so on, we have a dramatic increase in the number of vehicles of all types on the road. And I haven't gone to specific construction equipment, excavators and so on. I wonder, looking back at 2020 and the years beyond, where the numbers were dramatically low in 2015 to 2019 and 2020, how come we have had this dramatic improvement in economic activity, in more and more people owning vehicles, cars, how we have basically moved from a minibus transport type economy for personal movement of persons to where there's a much greater increase of personal cars, people owning cars, and for all aspects of business endeavors. Where and why this dramatic improvement has happened since 2020 to now, more than a doubling. I would posit that it is the policy that the PPPC government has put in place over these years have given the impetus and the confidence over these years, which are now reflected in the statistics that we see. And I have to say that even though for some years where we have seen improvements, and I'm not looking at 2021, 2022, we had less than 100, for the first time since 2009, that in spite of an increased number of vehicles on the road, even at that time, in terms of statistics, it is actually lower in terms of the impacts, in terms of the vehicle miles being traveled, in terms of the utilization and the total effort, that it is actually lower in terms of vehicle miles, in terms of number of vehicles on the roads and so on. It is actually lower. It is nuanced in the statistics. But we continue to say that we have a problem. We continue to say that the loss of lives on the roads are grievous, that the persons who are usually impacted are young men between the ages of 14 to 30, our statistics show that those are the ones which are most severely impacted, deaths, injuries. We note the increases in motorcycles on the road of all types. We know the recklessness in terms of some users. In spite of our efforts of giving out free helmets, in spite of the efforts of the police too and others in giving road safety talks at schools and at social gatherings, we still have a problem, but we are committed to the global effort to halving the number of road deaths in our country by 2030, which is the decade, the UN decade in relation to action in respect of road deaths and injuries. If we look at our risks, if we look at our immediate response that we have been making, we note the difficulties in relation to the human aspects of managing or policing on the roads. We acknowledge that there is at various times rogue behavior. We acknowledge at various times charges of left and right. We in left and right. We look at and we note the questions of integrity. We have taken the position overall that we will impose as may be considered an imposition of bringing in technology which will remove the bias, perceived or not, in respect of the police and persons working on the roads. So the removal of bias, improvement of integrity, the question of bringing in body cameras too in terms of our work on the roads and engagements. We look at these measures. One of the big issues that we have is speeding on the roads. Speeding, according to the international road traffic experts, speeding is a particular issue beyond the speed limits. And speeding in our statistics, when they talk about accidents, relate to 75% plus of accidents of our road, on our roads. And there are also issues of impaired driving, issues of driving while distracted, whether it's a cell phone, texting or titillating or whatever people do with cell phones these days while driving. But particularly, which we don't see properly in the statistics, is the question of driving while under the influence, either of alcohol or drugs. And so we know that with the removal of bias, with the further encouragement of the use of seatbelts, that we would be able to make a dramatic improvement in the question of road traffic accidents and safety on the roads. While we have put in place new roads, the new highways, the Heroes Highway, the interlinking roads in communities, many more communities have roads which they never were or even properly maintained. We still have the problem of speeding. We have the problem of people seeing the open road. We have the problem of particularly at the weekends where there's drinking and driving. And so the resort is the amendments of the Motor Vehicles and Road Traffic Act. Having the amendments which we're speaking to now, which will allow to have the technological interface to help to bring better control on the situation. And so we have this document here, this bill, and it is intended to put in place an intelligent electronic road interface system, an electronic system which will allow for the capture of those who are careless or delinquent or those who really don't care perhaps at all in respect of the matter. We, we believe, again, that the amendments proposed to the Motor Vehicles and Road Traffic Act, amendments to the Principal Act will go a long way towards improving the situation and would go a long way towards helping to rebuild public trust and confidence in respect of what we do in this particularly difficult area. And if I go to Part 6B, the requirement is that at 45G1 is that the minister may, in various locations of public roads, so that is declared public roads, install an electronic system consisting of A, cameras to capture photographic images and videos of vehicles and persons in the vehicles, and B, radars to detect the speed of vehicles. Data captured by the system shall be automatically stored in a specific database established and controlled by the National Data Management Authority for that purpose. Notwithstanding any other law, at 3, the data stored in the database shall be accessible by a member of the police force, assigned under the specific subsection by a web application established by the NDMA, and may be used as evidence to charge persons for the commission of offenses to which this part applies, and to prosecute the persons charged. The traffic chief at 4 shall, of course, assign members of the police force who shall access the database. And at 5, the NDMA shall give every magistrate's court access to the database by web application and provide a facility in the system for payment in lieu of prosecution. Payment in lieu of prosecution to be made at a magistrate's court in the magisterial district in which the offense was committed. So, the offenses relate to speeding, relate to the improper use or non-wearing of seat belts. Offenses are against Section 34, against Sections 45D and 45E. And at 2, the minister may by order amend this section to add other offenses to the subsection. So it allows for, as we go forward, that amendments can be made by the minister for the amendments to add other issues in respect of promoting safety on the roads beyond speeding and seat belts. So this is the first resort which we're working at. In respect of the procedure, under the Summary Jurisdiction Procedure Act, the police force finds a camera has captured a photographic image or video recording of a motor vehicle driven by a person which discloses that an offense to which this section applies has been committed by the person, the member of the police force shall A, send a short message service, SMS, to the mobile phone of the registered owner of the vehicle, informing the owner of the commission of the offense and of an electronic notice to be served on him by email. This resort will be new here, but for those of us who have had the opportunity to travel in other jurisdictions, overseas, would have been made aware of the presence of this type of system. It's well tried, it's true and trusted in those jurisdictions, and it will be no less here in Guyana on our declared public roads. At B, the police shall serve on the registered owner by email the electronic notice charging the owner with the commission of the offense and notifying that owner that a complaint has been made against him in respect of the said offense at the magistrate court. I know that at B we have two trees and things, so the first, the notification should be 2, and then the next one is 3, requiring that owner to appear at the magistrate court specified in the notice on the day and at the hour stated in the notice to answer the said complaint. And of course, for the purposes of the proceeding to be taken in court for any offense, they were deemed liable for the offense. So the registered owner at the time of entering his or her plea at the hearing, if he alleges that he or she was not the driver of the vehicle at the time when the alleged offense was committed, the court may cause a summons to be issued by the person, who was alleged to be the registered owner, to have been the driver or the person in charge, making him a co-defendant in the proceedings. And the court may, after hearing the evidence and witnesses, if any, of all parties, make such order as to the payment of any fine and cost as to the court may seem just. A person upon whom a member of the police force observed the notice under subsection 1B may, in lieu of being prosecuted for the alleged offense, pay to the clerk of the magistrate court specified in the notice within 7 days of the date of service of the notice. Such penalty as prescribed for the offenses on section 8, 2, and 3 of the Summary Jurisdiction Procedure Act, and by the minor offenses penalties ordered made under section 8, 2, and 3. And where the owner is not the driver of the vehicle at 4, the owner shall be responsible for ensuring the payment of the penalties stipulated in the electronic notice served under this part. So a printed copy of the electronic notice will be posted by registered mail to the owner after the electronic notice has been served. The electronic notice, of course, shall state the date on which the alleged offender is required to appear at court, which date, and those dates shall at least be 14 days after the date the notice was served by email. Where, of course, there's more than one owner of the motor vehicle return reported in subsection 451, 451.1, the owner shall be jointly responsible for ensuring the payment of the penalty. And where at 8, an owner pays a penalty under this part, the owner may recover the sums paid from the person who was driving the motor vehicle at the time the photographic image or video recording referred to in subsection 1 was captured. And of course, the electronic notice shall be in the form set out in the third schedule. The service of the notice by email is deemed effective at 45J1 on the date shown in the email, or if the email shows that the notice was served after 4 p.m., Service shall be deemed effective the following day. If the email has not been received, service is effective on the 14th day after the copy of the electronic mail notice was mailed by registered mail. And service shall be done personally as provided under section 8, 4, 12, 13, and 14 under the Summary Jurisdiction Procedure Act. So, of course, the provisions under section 8, 5, 6, 7, 8, 9, and 13, and 25 of the Summary Jurisdiction Procedure Act apply mutatis mutandis to proceedings for traffic violation in respect of which a notice was served. In respect of the responsibilities of the LDMA, the system is linked to the Guyana Revenue Authority, established under the Revenue Authority Act, to upload the system particulars of every vehicle registered in every license. And so payment shall be made to the clerk, of course. Every person with a driver's license is required to update his information with the license authority. I'm reading it because I want us to all be clear about what the provisions of that. Well, I'm glad to know that you can read, but understanding is another matter when we start to talk. I'm glad you're emphasizing. I'm glad you're emphasizing that you could read and that we're reading together and that we don't go back to the kind of negative skirmishing we had before when I was on the floor in respect of the fourth amendment. So, the e-ticket, of course, shall include the date, time, and place of the offense, the law which created the offense, the registration number of the motor vehicle involved in the offense, the penalty that is to be paid. Mr. Speaker, I am not debating, I'm presenting for the debate. So, there's a question of evidence and the question of everything being collected by the electronic system, the fact of the motor vehicle which was used, the fact that the information shown on the image is accepted as true and accurate record of the registration number of the motor vehicle, and of course the speed recorded by the system is a true and accurate record of the speed of the motor vehicle. Of course, the MDMA is required to make sure there's proper maintenance of the system, and the system's accuracy shall be certified quarterly by the Bureau of Standards established under Section 3 of the Bureau of Standards Act. Mr. Speaker and honorable members, in proceedings for the violation, the condition of the road intelligence system or the manner in which it was operated shall not be required unless that it was not in proper condition or was not properly operated at the time of the traffic violation has been adduced. And we know we have our problems with this issue. There is a person who was a senior member on the other side who struck down a national motorcyclist, and there were issues in the court as to whether what was the speeding, what was the situation when that young man was struck down on the road. And frequently there are issues when the police put the speed gun on people and show them the number, they claim that it was the other vehicle behind, not their vehicle. And as recent as this weekend, there was a big consult on the road, and a challenging of whether the police had recorded the proper information by means of the electronic device. Yes, we're having that. We're having that. And I'm going to make sure that every time they come to you, it will be on. Notwithstanding at 45R2, any law to the contrary in proceedings for a traffic violation on this part, the court does not necessarily require a complainant, or this shall not deter the person receipt of the notice from summoning any person in his defense. And of course, in relation to the new schedule, the principal act is amended by inserting the following as the third schedule, and it is appended here, which we can review. Thank you. On the page before my signature, on the explanatory memorandum. So you have, honorable members, the opportunity. I have gone through it in some detail, and I am asking for your support. I want to pay attention to the fact that issues relating to road traffic deaths goes all across our national spectrum. It impacts all persons. There's great loss and grief. Every life is more than an economic loss to the family and to the community. It is also a psychological loss and a loss to the nation as a whole. And so I want to crave your indulgence and support in respect of the amendment to the Motor Vehicles Road Traffic Amendment Bill 2024. Thank you, Mr. Speaker.
Thank you very much, Honorable Minister of Home Affairs, Honorable Brindley Bend. And now for the Honorable Member, Ms. Amanza Walton Dizzy.
Thank you, Mr. Speaker. Madam Speaker, thank you. Madam Speaker, I rise to give my support to the bill before us. I will hasten to say that it is conditional support for reasons that I will highlight as I go along. Mr. Speaker, I agree with my colleague on the other side that went before me that the issue of road safety is a concern to all of us. The carnage that we are seeing on our roads and the grief it occasions to families who have lost their loved ones is something that we take very, very seriously. And I believe, Madam Speaker, it is important that we work together to transform our roads from, deadly hazards, as it were, into a safe passageway. I am happy that we are leveraging technology to aid in the detection and prevention of crime. But I want to add, Madam Speaker, that we have to balance the benefits of technology with the need to protect individual rights and to ensure equitable application. Because this is indeed, as highlighted by the member before me, a challenge as we go along. And the honorable member before me, Madam Speaker, spoke to the issue of making sure that there is impartiality But what the speaker before me did not go into, which I had hoped he would, or maybe the speakers after him will go into, is this issue of data privacy. Because it's one thing to have a problem. We agree that there's a problem. We are leveraging technology to solve the problem. But there are some important prerequisites to leveraging technology. And he alluded to the fact of other jurisdictions applying this successfully. And it begs the question, what is it on the back end that allows those jurisdictions to apply these types of technologies successfully? And do we have those on the back end here? Because unless we do, we are creating a whole other set of problems. And let's begin first by looking at the overarching paradigm. It has to be the balancing of privacy concerns. And I know that in every jurisdiction that this type of technology has been used, the issue of data privacy has been on the forefront. I know earlier this year we passed a bill or an act related to data and the processing of data. The applicability of that to the current context is something that we need to discuss. So the overarching paradigm has to be balancing private concerns of privacy and holding violators to account. The member before us went through in great detail the provisions of the bill, but we always understand on this side of the house the devil really is in the details. And so the first point that I want to emphasize for our consideration is the issue of public education. There has to be a robust public education program. The minister who tabled the bill did not speak to this issue of a robust public education program. You know, when you look at the bill, what it does is that it has a provision that within 4 months from the commencement of the amendments, that every holder of a driver's license has to submit a phone number to GRA. The question is, how is that done? What is the actual mechanism? Are we all to crowd at the GRA office, wherever they may be around the country, to provide that information? Can you see how that could lead to serious congestion and loss of time and confusion? And so, whilst the amendments are, for all intents and purposes, good, what is missing is how we are actually going to implement this and roll it out. How do we operationalize this is the issue. And so, you know, these are serious concerns, because we need to have our members of the public understand how exactly are you going to do this. And then, for example, we know that phone numbers are recycled frequently. So what is the mechanism to make sure that there is an update? So these are the, you know, and my colleagues on the other side may believe that this is a time for jesting, but we're serious here because we're talking about the safety of our roads and lives. Right. So they could joke and jest how much they want. We on this side of the house are serious about implementing laws that actually are implementable and that work. So, Mr. Speaker, Madam Speaker, rather, that robust education program is mandatory. Mr. Speaker, what else? One other issue that we have to consider is the coming into effect of this piece of legislation, because it appears to me that we will need some time to have the compliance in place. And so that is another consideration, whether it will come into effect upon it being passed here and assented, or whether there will be a time frame given for implementation. So these are some considerations that we have. And then, Madam Speaker, we come to the issue of data security. And you know, for all the heckling over the other side, that is the government that had a PS with a cell phone attached to all of the cameras around. That is the government, the PPPC administration, that had a PS with a Motorola, I believe it was, Mr. Maipal, cell phone that was connected to the camera system. So when you talk about the issue of data privacy, this is why it is important, because the integrity of data is important. So we have a situation here, Madam Speaker, where we will need to store large amounts of data, where we will need to manage large amounts of data. And so the question necessarily arises, how are we mitigating against breaches and unauthorized access? These are considerations. They could be noisy over on the other side because it may be that they have not addressed their minds to these issues. So how do we deal with mitigating against those breaches and against unauthorized access? These are questions that we have to answer. Mr. Speaker, Madam Speaker, we talk about data minimization. How are we ensuring that the data that is collected, because of course data minimization is a very fundamental principle as it relates to the collection and processing of data. How do we make sure that the data that we collect through these systems is exactly what is needed and for the purpose that it is needed, and that it is securely stored and handled? I believe in supporting these amendments. These are matters that my colleague on the other side, Minister Ben, has to, one, address his mind to, and two, these are answers that should be provided to the people of Guyana. So, Mr. Speaker, Madam Speaker, we talk about the issue of, and we're talking about data here because the images, etc., that are captured and processed is data. We're talking here about the anonymization and encryption of data. When data is transmitted, is it encrypted? Will it be encrypted data? These are all questions that have to be answered. And will it anonymize data where, as far as possible, it is important to protect the identity of the particular individual along the process? Because, Madam Speaker, for example, in some jurisdictions, what they do, and maybe the learned Attorney General will do well to listen and learn, what they do is that if, for example, a license plate, let's say PPP1, is captured as speeding, what some systems do is that they capture it, but they immediately encrypt it, because everybody knows who drives PPP1. You see the point? So is that how the system will work? And these are all questions that have to be answered. So, Madam Speaker, the issue of anonymization and encryption. When the data is being transmitted, for example, the honorable member spoke about the NDMA having to provide access to magistrates' courts to this system. In terms of the data transmission, is that data going to be encrypted throughout the process of transmission, or will it not be, and therefore susceptible to being interfered with by people with less than honorable intentions? So, you know, Madam Speaker, this is a serious issue, and I am assuming that we are a serious house, and I am assuming that we want to pass legislation, one, that we could explain to the people of Guyana, and that is actually implementable. So I'll move on to, for example, data retention policies. Could the minister say to us, what is the policy? How long will you keep a record of the infraction? Is there a policy that has been set out to govern this? Because there are policies, the way this works in other countries is that there are clear policies that this data is kept in a certain format for a certain period of time. In a certain format because they may need it for statistical analysis at a later date. So my question is there a policy? And the way my colleagues on the other side are behaving, I'm beginning to suspect that there mightn't be. Because they rabble-rouse when they do not have answers to very important questions. But Mr. Speaker, I will press on. Mr. Speaker, is there a plan, whether by the NDMA, by the minister, the subject minister, or his ministry, to do what we call privacy impact assessments? Do we have that? And how regularly will they take place? Madam Speaker, the bill proposes to send tickets along with violations to cell phones and emails. And yes, this obtains in other jurisdictions, but I hasten to make the point that those jurisdictions have on the back end very robust data protection and transmission regimes. Do we have that here? And it is important that the government be able to satisfy the citizens, that they be able to satisfy this House, that these important prerequisites are in place. This is a serious time for serious people, because we are talking about important legislation with far-reaching implications. And so we are proposing to send tickets with photographs to cell phones and to emails. And this, of course, Madam Speaker, introduces additional risks. So, for example, sensitive information, photographs, personal details, could be exposed if the communication channels are not secured, or if, for example, the recipient's device or email is compromised. What about tickets sent to the wrong email? What about sending it to the wrong phone number? Are there systems in place to make sure that the person who receives it is really the intended recipient? And what are the mechanisms in place to allow them to access it in a manner that they know for sure that this is a ticket generated by our system? Because you see, the minute you talk about SMS and emails, you come into the issue of phishing and scams and email scams. And so, Madam Speaker, these are all very important considerations. So what we have is, in essence, a number of questions that if this government is really serious, if they are really serious, that they will answer and they will assure the people of Guyana that we have all of these systems in place. Madam Speaker, the issue and the presumption of regularity could have applied, save and except over the last few weeks. The public trust and confidence in our enforcement systems have been severely shaken. And so I am raising these questions, Madam Speaker, because it is important that answers be provided. And I would be happy, and I would be the first to support if these questions and concerns are assuaged. And so, Madam Speaker, for example, I raise again the question of whether we want to use encrypted communication channels, right? In some countries, in addition to sending it to the registered address of the individual, when it is sent to an email or it is sent to through SMS, there are two-factor authentication mechanisms that are put in place to ensure that the person that is receiving it is the person that it is intended for. And so the question arises again, what are the systems that are being put in place to make sure that this is happening? And so, Madam Speaker, what we are emphasizing on this side of the House is that it is important to hold violators accountable. If the law is broken, violators must be held accountable. But we will proceed in error as a House if we decide that we are turning a blind eye to the rights of our citizens. The question of data privacy, Madam Speaker, is something that has occupied extensive deliberation. The European Union passed the GDPR. Earlier this year, the Attorney General, when he passed the Data Protection Act, was waxing eloquently about the importance of privacy and protection. And he is sitting there and he is saying to us now that it must be treated casually. This is why I asked, and I have not heard from the Honorable Minister, and maybe if the Honorable Attorney General will speak, he could indicate to our citizens the degree and the extent to which that act applies to the present circumstances, if at all. So that is what they must spend their time doing. Mr. Speaker, so for us, we want to support this legislation, but I think it would be remiss of us not to raise these concerns. And so for us, if the Honorable Minister and the speakers after could adequately answer these questions, we have no difficulty in supporting this. And whilst I'm on my feet, I will ask the Honorable Minister, because I'm happy to hear that he said that they will be making sure that traffic police especially use body cams. It is something that has to be commended and hopefully enforced. So I was quite happy to hear him say that. I want to encourage that whilst we are at it, let us fix this issue of civilian vehicles being fitted with emergency lights. It's a problem, Madam Speaker. And it is becoming, it's out of hand. You see certain ministers zipping and zooming and so on, and even people who are not ministers of government. Honorable Anil Nandlal. He said name the ministers, and I just did. But the point is a serious one, Madam Speaker. It is something that has to be addressed. Because you see, what it does is that it trivializes the meaning of those lights in the congestion, etc., that we have to deal with here as a country. And don't let me get started about the metric that the honorable member used, that the ownership of private vehicles is by itself a metric of economic development. He should consider that what it indicates is an unreliable public transportation system and fix that. But I digress. Madam Speaker, I want to add two other points. One, we have to address as well, as we're talking about road safety, the trucks on the road. I will commend the Ministry of Public Works. They have been making progress in terms of the enforcing the weight limits. And so, Mr. Speaker, I want to ask that they hasten the weight limit regulations that we were told earlier in the year are under development, because it is the behavior of truck drivers on our roads is a problem. And it is a clear and present problem for all road users, fellow drivers and pedestrians alike. So I want to encourage the hastening of that legislation, including, Madam Speaker, regulating the way loads are carried. it is the most terrifying thing to be in a vehicle next to a truck that the load that it is carrying is exceeding, so protruding so far above the capacity of the truck. And so these are things that we have to address speedily. So, Madam Speaker, I hope that my comments are taken in the light in which it is intended, and that is that if we are going to pass legislation in this House, that it be robust, that it be comprehensive, and that we have to have a well thought out piece of legislation. And not only that, I want to strongly encourage, Madam Speaker, a robust education program to go with the rolling out of this legislation. Thank you, Madam Speaker.
Thank you, Honorable Member. I now call on the Honorable Bishop Wang Ezio, Minister of Public Works.
Thank you very much, Madam Speaker. Madam Speaker, I rise to support my colleague. As he presented Motor Vehicles and Road Traffic Amendment Bill 24, Bill number 9 of 2024. And let me say from the onset, Madam Speaker, I don't see any bush, so I can't see Jumbie behind the bush. This is a straightforward, this is a straightforward piece of legislation that will strengthen the enforcement of our road laws and would ensure that we get better compliance. Madam Speaker, as the Minister responsible for transportation, I have expressed concern many times and in many places about the recklessness, the carelessness on our roadways. So when legislation like this comes to the National Assembly, we must see it as government doing what is right and not just merely describing the problem. The difference between those of us who sit on this side of the House and the other members who sit on that side of the House, we identify the problem and we come to the House with solutions. They come to the House with a problem and want to make the world to believe that the problem is insurmountable and cannot be solved. So, Mr. Speaker, Madam Speaker, this is what happens in every part of the world. Members on the opposition go to various jurisdictions. They don't know about the back room. They don't know about data protection. They don't know about all the other things that they're asking for, but the cameras are there and they take their time and drive, or whoever is driving them, to ensure that they obey the rules. So, this Monday night, we should not use something that is progressive, something that removes subjectivity, because that is what the minister is talking about. He is removing subjectivity by putting in place an electronic system, intelligent electronic cameras that will capture the human element of putting the speed gun and somebody arguing that there's another vehicle that is not there. All of that is gone, because the footage that will be available if you want to contest your ticket in the court of law will be visible for the magistrate and every other person who have to adjudicate on the matter. That's all we're saying. So the issue that we are talking about what's going to happen with the back room and who is going to interfere with information, Madam Speaker, without the electronic surveillance system that is in place, members of the opposition video vehicles and put it on their Facebook page. And some of them actually use it in their talk shows. Where is the protection of people's privacy there? So we have to be very strict when we are addressing our minds about right and wrong and abuse. And I'm not saying something that the world is not seeing. Every Guyanese that is listening to me now know that members of the opposition video people's vehicles, whether they're saying it's a wrongdoing or not, and put it on Facebook, and some of them actually replay those images and have commentary, and people are commenting on it. What the police force will be empowered to do through this piece of legislation is to utilize their personnel in a more efficient manner, deal with crime fighting, controls, managing major activities and intersections, while the cameras, day and night, rain or sun, will be there to be able to curb and prevent the excessiveness and the lawlessness that is taking place on our roadways. While at this particular time, this piece of legislation will be able to address two road offenses: speeding and the use of seatbelts, or the lack of use of seatbelts. This legislation specifically will be able to address those two traffic offenses. But the fact that we have cameras, intelligent electronic devices, strategically placed in itself is producing safer communities. Safer in the sense of better enforcement. People who know that the cameras are there will start behaving in a more responsible way. So the cameras of itself serves as a deterrent to people who would normally, in the absence of a policeman or in an area where there is not enough policing, they will perform with their recklessness and carelessness. They will be in greater compliance because whatever they do will be captured, recorded, offenses will be made known, fines would have to be paid, or you appear in a magistrate court to contest if you disagree, and the matter will be adjudicated based upon particular judicial criteria. So this could only be in Guyana's best interest. This could only be in the interest of all of us. We should never ever in this honorable house stand on the side of those who want to be reckless. But I'm sure the honorable member who presented this bill, Minister Ben, of who I stand in support, while we initially can get images, prosecute offenses of speeding and the lack of use of seat belts, there are other positive things that could happen just with the mounting of these cameras and putting in place the legislation that will accompany its use. Number one, better traffic management. Right now, in the lead up to the Demerara Harbor Bridge, and on the Demerara Harbor Bridge, cameras are used. And you know how effective those cameras are? If a vehicle is immobilized on the bridge, traffic congestion, in any 2 minutes of a vehicle being defunct or unable to continue its journey, you could have traffic backed up for more than a kilometer. We see that in just 2 minutes. If you have to go searching to find where the vehicle is, that takes a number of minutes too. Then by the time you move it, the traffic is backed up to 5 kilometers. People's frustrations are going up. With the use of the cameras right now at the Demerara Harbor Bridge, we can minimize that because we see almost real time. People can see on the images what is happening. On the East Coast right now, we have cameras that are providing some amount of assistance to motorists to show what's happening with the traffic flow. It helps people to direct themselves which route to use. So there are some other benefits that I would like to highlight, and we would be able to together. The honorable member, Miss Amanda Desir, just now spoke about trucks. Let us make it very clear. Trucks are needed in Guyana for Guyana's development. The trucks are not the problem. The drivers are the problem. The camera will tell us who is driving the truck, and that person will be charged. We're not about taking trucks off the streets or trucks off the highways, because we need the trucks to move the sand, to move the loom, to move the steel, to move the cement. We need the trucks to move the cassava and the pumpkin and the watermelons. And we need the trucks to support development that is taking place in various sectors of Guyana.
We need impartial cameras.
But, so when we see the recklessness on the trucks, the drivers will be identified. The bill specifically speaks, and Minister Ben read it, but some people were upset when he was reading it, that the owners of the trucks can be identified, and they can be charged, and they could be able to identify who was the reckless driver, so we could get to the errant person. But it is true that we have trucks that are moving construction material and other items that sometimes there's spillage. And the spillage on the road in itself can become a traffic hazard. Whether it's liquids, whether it's slush mud, whether it's sand or loam, or bricks flying while they're driving because it's not properly covered. The system that the Honorable Minister is asking us to adopt tonight will eventually be able to bring us into a place where we'll be able to identify these trucks, get them in, talk to them, get their covers in place, get their tailgates properly closed, so that that banging and sound that jump people out of their sleep and scare people on the road when they brake will be able to come to an end. These are things that we've been talking about. Motorcyclists without helmets is also another big issue and concern for me. And I'm sure it's also a concern for all of us in this house. Yesterday afternoon, I witnessed the young and daring riding in groups and motorcycles, and while they're riding, they're lifting their front wheel in the air to entertain in full view of everybody, which they believe it's a good show, but it's putting a lot of people at risk, and none of them are wearing helmets. And some of them actually have companions on those motorcycles. We need to get into a culture where we'll be able to get those numbers. I have seen Minister Ben, whether late or night or in the rain, as the minister responsible for the police, working with the traffic department of the police force, handing out helmets, talking to people about road safety. If he wasn't doing it, it would have been criticized, but he's doing it and he's not being commended. And all we are doing through this is, after we finish all the public education, the moral suasion, the asking for voluntary compliance, when you break the law, we have airtight evidence to prosecute. And you can't say the policeman didn't like you or the system working against you. You were there, or the camera is impartial. The data is there. The issue of undertaking and improper driving on laned roads is something that we have to improve on in Guyana. There was a long time ago where we had 2 lanes. And even when we had 2 lanes, people were undertaking. Now, undertaking is becoming a big issue, especially with our buses and the hire cars, who seem to figure that they have to get to their destination. The cameras will pick up all of that. Their number plates will be shown. The driver's image will be there. And these are things that we could start curbing. Right now, we're dealing with 2 offenses, but these are things that we could come down the line and start dealing with. The cameras could help me and the Ministry of Public Works to deal effectively with those unlit, articulated vehicles that are now parked in areas that could really endanger people's lives. We have a number of articulated vehicles that are now in country, and I guess we will end up having more to service those lay-down yards, the oil and gas sector. There'll be more containerized traffic as we build the road through to Brazil, as we develop the deep water harbor. Articulated vehicles and movement of container trucks will become more pronounced on the various highways that we are developing. Parking of these articulated vehicles and their trailers at night has caused the lives of many people on the Linden-Soesdijk Highway. We've had a lot of near misses on the East Bank, and now I'm seeing that it is becoming a phenomenon on the East Coast. The cameras will be able to identify. The cameras will help us on something that I'm sure every member of this House would like to support. Identifying who is destroying public infrastructure. A lot of times when we have accidents, it's not just the 2 cars or the 3 vehicles or the minibus and the canter that is involved. Bridges are destroyed. Traffic lights are smashed down. Electric poles are damaged. And even people's private property sometimes are damaged. A settlement takes place between the 2 people and they're gone. And the state is left with the burden to expend additional millions to repair infrastructure. A lot of the vehicles that are using smaller streets that don't have the width and capacity for turning, when they're turning, they're now destroying the head wall of bridges and culverts. You go around Georgetown and you will see how many head walls of bridges are destroyed. At Robb Street, there was an iron side fencing to the bridge. All of that iron was destroyed, broken out by container trucks. And bad don't have owner, so nobody never knows. The police will be able to help us with information and will be able to slow down that kind of recklessness and help us to get the money, because civilly they will have to be sued to compensate for damage to public property, which is something that we are helping about. When we're talking about damage to public property, it also deals with people who deliberately light fires on roadways. And I'm wondering if that is the reason why some of our colleagues have all this thing about data protection and protecting image, because when people do malicious things that damage roadways, we must be able to find them and prosecute them. So that's a different ball game that I think they're very concerned about. Madam Speaker, one of the other things that I believe all of us in this House should agree on, the government of Guyana is perhaps the largest owner of vehicles in the country, whether they be ambulances, pickups, special vehicles for public servants and agencies who operate. And a lot of times, government vehicles create some of the recklessness on the road. And when I say government vehicles, I don't mean the PPPC government. I mean government vehicles. Because this happened even under the APNU AFC. State-owned vehicles, we should probably say. And there needs to be a higher standard. And drivers who work with ministries and agencies who do reckless things on the road should be pulled in, not just charged and pay a fine, but they should be put to sit and go back through classroom training, get a new orientation about road usage, because the state is losing by such errant behavior. When they crash them, they have to be repaired. When they destroy people's property, the state have to come and pay for those people's property. We need a new culture on our streets. I know the honorable member, Ms. Zeras, departed as usual after speaking. She spoke about weight restrictions. We could have had legislation and regulations in place to deal with weight restrictions a long time ago, had the APNU AFC fulfilled their commitment with the purchase of the motion scales, and had it been delivered. So I would not suggest that we have that conversation tonight, because it would be very brutal. It would be very brutal. But I can give notice to the House that the Ministry of Public Works have already obtained and is in possession of motion scales, which will be rolled out to deal with weight control on the roads. And these are not the ones that were bought and paid for upfront 100% that has not yet been delivered.
But is the notice going to the right SMS?
So I would like to give notice to the House that this is a direction that we will have to be going. You know, while we were preparing for the good successor to Mary expansion, which everybody knows that we're going ahead, it's been funded by the IDB, a contractor for the actual project, and the consultant for supervision is already in place. They were doing the studies. On a daily basis, I think the number they gave was in excess of 25,000 vehicles traverse the East Bank thoroughfare. 20%, I think it's the figure, of those vehicles are trucks. And if you ride or drive on the East Bank, you will notice the eastern lane, you get through very quickly, but the western lane, which is when the laden vehicles are coming into the city to go to other places, you have the bulges, you have the breakage because of the weight. We will be able to move in that direction. I know Minister Ben is very strong on this, and I stand here tonight to support him. Part of the problem we have with traffic controls are vendors who operate at very important intersections and create congestion. Somebody stopping to buy dog food, and there's 500 meters of traffic backed up because one inconsiderate person would like to buy dog food at a particular roundabout or at a particular location on his way home or her way home. The cameras would be able to identify what is going on, so we could come on the ground, what you like to call boots on the ground, talk to those people. I know you want to do business. Government is not about putting people out to business, but you can't just show up and sell here. So there are a lot of advantages that we are talking about and that we could benefit from this. So, Madam Speaker, at this late night on a Monday night, the only thing that I can say to the Guyanese people, Guyana is modernizing. We saw when we traveled, people swipe their passports and they're gone. And we're in the line for somebody to take our passports and stamp it. We have been able to bring in machine-readable passports. Processing of people at the airport has become swifter. That is a good thing. The Ministry of Home Affairs and the Immigration Services and the platforms that they've put in place is working well. And we congratulate them for that. We put in place smart city arrangements, which has helped with intelligence gathering, proper policing, tracking down people who commit crimes. It helps the police to be able to position roadblocks based upon the images that are coming into them to do with crime solving and crime prevention. Now what the Honorable Minister is asking the House to do by way of this amendment is to strengthen his arm and the enforcement arm of the state, which is again a police force, as it deals with traffic violations by putting in place this amendment that empowers them to get this done and get it done very efficiently. It has proven to work in many parts of the world. We don't have to discuss that. Don't let us see a Jumbie behind every bush. Systems are as good as the people who operate them. Systems are as good as the people who operate them. And while many would like to criticize our men in uniform, and yes, things have happened that criticism should go, but we shouldn't paint everybody with a broad brush. Some of these men and women who operate these systems are our sons and our daughters, our brothers and our sisters, our neighbors, our villages, and I dare even say some of our political party supporters. But they operate in highly professional manner to ensure that the state remains safe. Those of us in this house who think we are exempt from the cruelty and the carelessness and the marauding on our streets, we don't want to see any of us being cut down in an accident because of some careless driver. Let's put systems in place and everybody start towing the line. Our children will get home safe from school. Our grandparents will get out to get their pensions or to go to the bank or go to clinic and get back home safe. Our young people must develop a culture that is called follow rules. Law and order is not something that you should hate. It's something that you should appreciate because it exists for the good of all. So when I stand here tonight to speak in support of this bill, it's because of the good that I can see coming out of this and not just another Jumbie behind another manufactured bush. It's not about illusions. It's about doing what is right and what is good. So I call upon all honorable members of this House to vote in support of this amendment. And let's give Minister Ben and the enforcement arm of the state another tool to help to make our country safer and more secure. Thank you very much and God bless you.
Thank you, Honorable Minister. I now call on Honorable Annette Ferguson.
Thank you very much, Madam Speaker, for the acknowledgement. I'm grateful to have been given the opportunity to participate in the debate on the Motor Vehicles and Traffic Amendment Bill, Bill number 9 of 2024. My colleague preceded me has set the stage for myself and those coming after that we on this side will give our support to the amendments being proposed. I believe, as a growing nation, with increased traffic, it is necessary for a new and modernized legislation to be enacted. However, in my view, we still have a far way to go. Madam Speaker, I trust that this is not just another legislation. When passed, the government will do its checkbox to say, we have completed a robust parliamentary agenda by passing several pieces of modern legislation. What is equally important to me, Madam, and I guess many of my colleagues in this House will agree, is the enforcement of these laws. When, with your permission, Madam Speaker, may I remind the House over a year ago, to be precise, May 9th, 2023, this National Assembly unanimously passed the amendment of the Motor and Vehicle Bill, paving the way for legislation to license e-bikes, prohibit under 16 use. I recall during the debates, the emphasis was placed on the number of persons who were killed using the bikes. Madam, without much public awareness and sensitization, this law took effect from December 31st, 2023, allowing persons to get themselves oriented with the amendment and also to ensure that they become compliant. Today, many of our citizens, including underage 16 years old, are still using these modes of transportation without registration. I have been an advocate in my own right, encouraging persons to visit the license office at GRA to get those bikes registered. This is just a drop in the ocean when it comes to laws of our country. The major bugbearer, Mr. Speaker, is the enforcement of the laws. Who are there to monitor and ensure our people are compliant? But I guess the police are busy doing other things than police work. Over the past few days, many of us in this House read with interest and concern stories of senior officers and ranks deeply engaged in extra policing activities, which are likely to bring greater benefits to them as individuals. Mr. Speaker, while I welcome the amendments to the Principal Act of the Motor Vehicle and Traffic Laws, I believe what should be of significance to us as legislators in this assembly is the continuous loss of human lives on our roadways, which occurs practically every 72 hours. Today, with the many options explored by the traffic department, we just heard about what Minister Ben is involved in and what the Road Safety Council is also involved in. The traffic department of the Guyana Police Force, to curb the recklessness on the roadways, the culture remains unchanged. I believe the time has come for stringent measures to be explored in order to minimize carnage on our roads. I also believe once we put our efforts together, we can achieve the end results. Let's cease the rhetoric and exercise political maturity. I recall, Mr. Speaker, in his New Year's message, His Excellency announced the need for a robust road safety and management plan. This is basically to reduce road deaths. And, you know, I'm referring here to the Demerara Waves article carried on 1st of January 2024. And I'm quoting from what His Excellency said. I intend to have a national conversation on this issue within the coming days. Out of that conversation, new laws, regulations, and technology will be implemented to stop the carnage on our roads, he said. And I unquote. But you know, Mr. Speaker, I thought what the government should have done first, they're actually doing last. His Excellency was clear when he said he needs to have a national conversation on the road deaths in our country. We should have had this national conversation and coming out from the national conversation where you have stakeholders, religious bodies, NGOs, everybody meeting to put forward suggestions and recommendations, I believe that those suggestions and recommendations should have formed part of this legislation. So, Mr. Speaker, we're in the 7th month in the year 2024, and we're yet to have that national conversation. But what we have before this House as of July 8, 2024, is an amendment to the Motor and Traffic Amendment Bill. Mr. Speaker, I now turn my attention to the bill before us. However, sir, in the first instance, I wish to express my disappointment with those in authority who continue to fail our people. I am reminded in the book of Hosea 4:6, and this is what the first sentence in chapter 4, in chapter 6 of that book. My people are destroyed for lack of knowledge, quote and unquote. Just not so long ago, my colleague before me expressed that we should have had consultation and education, awareness, where this particular bill is concerned. Because if we to conduct a survey currently out there, many of our citizens are unaware of such a bill or such an amendment to the Motor Vehicle and Traffic Act. In this regard, as I said before, sir, not much public awareness and education were done. I have done extensive research and only found an article published by Guyana Times dated May 21st, 2024. And this is after the tabling of this piece of legislation. And this is what it states, the headline stated. Now official for smart camera system to be used to nab, take action against errant drivers, quote and unquote. Now, Mr. Speaker, the big question I have here is whether enough has been done to educate our people on this piece of bill. Mr. Speaker, you know what I find very interesting is that every Thursday, you have my goodly friend who is not present in the House this evening, will sit for 3 hours at a press conference. And rather than him saying to the general public, this is what your government will be passing in the National Assembly, and explain to the people of Guyana, he's busy running and telling a whole lot of, spreading a whole lot of propaganda about us in this National Assembly. Also, my goodly friend, who's also not in this House, Kwame McCoy, who has responsibility for public affairs. This should be his responsibility, sir. Whenever legislations are tabled in this National Assembly, it is for the honorable member to go on NCN, go on DPI, do pamphlets, have flyers, have educational sessions in the schools, in the communities, so that we can have our people become aware of what is going to pass and not be caught by surprise. In examining the amendments to be made, I believe they are reasonable. However, what is noticeably absent is provisions regarding to decease. And let me just get the bill, Mr. Speaker. As I said before, I read the bill. I understand everything that the bill is seeking to address. But what my concern is, and I trust that the honorable member and the government by extension can consider perhaps an amendment to the bill based on my concern. Okay, we're talking about owners of vehicles, and once they're captured by this new technology and they're charged, My concern, Honorable Roxanne Ben, let us say, for instance, an owner who has a vehicle registered in his or her name that is currently deceased, and a family or a relative is driving that vehicle. No, would you listen to me? The person is driving. The person is driving. But the person to whom the vehicle is registered is deceased. So I am a relative of that deceased registered driver. I commit the act. It so happened when the information is now transmitted to GRA, it reveals that the vehicle number is registered to Tyrone Ferguson, who is deceased. But it is Annette Ferguson who is driving that vehicle. How do we treat with such instances? You also have cases where persons might, be overseas, and at the time of them being overseas, relatives are using the vehicle. They commit the crime. How do we treat with those persons if they're not here? So I recognize a clear absence of that from the bill, Mr. Speaker. My other concern, Mr. Speaker, when I look at section 45G2, when I look at 45G2 of the bill, this is what it states. Data captured by the system shall be automatically stored in a specific database established and controlled by the NDMA for that purpose. It further goes down to 3. It speaks about notwithstanding any other law, data stored in the database shall be accessible by a member of the Guyana Police Force assigned under subsection 4 by a web application established by the NDMA and may be used as evidence to charge persons for the commission of offenses to which this part applies and to prosecute the person's charge. But what is of interest to me that is not clear is in section 4 of this very subsection 4 of this very section. The traffic chief shall assign the members of the police force who shall access the database. So, am I to understand, Honorable Member, that when NDMA set up the mechanism, they will able to have the police access the information on spot based on the crime committed by the errant driver, and then that police will be able now to have another officer, a subordinate, access that information. Am I clear on that? Because this particular subsection is not bringing that out. So that is something that you can respond to, sir. Mr. Speaker, the other concern that I have that the Honorable Minister perhaps can consider or respond to during his wrap-up has to do with, let us say, for instance, these cameras are on a main access road. And at the set time, a vehicle approaching, there's a police officer standing who comes out with his radar, stops you and say, well, look, you have been driving at 100 km. So I got a ticket that I have to go to the court and pay. But further on, Mr. Speaker, as I continue with my journey, there you have the cameras that will capture my information. Again, I will receive an e-ticket. But when I receive that e-ticket, Mr. Chairman, Mr. Speaker, it might say that I was driving at 8 km. So therefore, no, the same area, it might just be yards or miles away, right? But it's the same area. So therefore, which information will be accurate, Mr. Minister? So that is my information. So therefore, I'm going to be charged twice, one by the policeman and the other by the camera. All right. So, Mr. Speaker, as I said, I believe that we have to look at subsection 45M. Every person with a driver's license is required to update his information with the licensing authority and submit a contact telephone number and electronic mail address within 4 months of the commencement of this act. Mr. Speaker, I believe we will have some issues here. So perhaps the government, the minister, can consider giving probably a 6 months to 8 months or a year extension, because you have to cater for many persons who are not in Guyana at the time they're required to go to GRA and update their information. So for me, there is need for some degree of flexibility where this particular clause is concerned. Mr. Speaker, the other section I have a concern with, and I guess the Honorable Minister will address that in his wrap-up, has to do with 45GB. Cameras to capture photographic images and videos of vehicles and persons in the vehicles. Mr. Speaker, again, I see problems here because you have many vehicles. Sometimes I do drive tinted vehicles. Yes, I'm being honest. I do drive tinted vehicles, but I'm trying to understand, Mr. Speaker, how effective the cameras will be able to capture that image in a heavily tinted vehicle. Because, Mr. Speaker, I will tell you this. I try putting one of these cameras, these mini cameras in my vehicle. And when I went to the guy to have it installed, we were seeing very blurry. He said, Miss Ferguson, this thing can't work because of the darkness, the tintness of the vehicle. It is causing blurriness in the camera. So I had to, so that is something that the minister should take consideration of. So, Mr. Speaker, I trust, as I said before, the bill, for me, it is a non-contentious one for me. And I would have stated my concerns in several clauses, and I trust that the honorable member will be able to see the wisdom and have these considerations or my views, right, considered before we pass this piece of legislation. I also would like to, before I take my final leave, to remind the minister that the recommendation suggested by my colleague, of which I just shared, because I had that as a point, I had this at a point. So I believe, sir, that when this document is passed, we see a robust education awareness rolled out, whether by the Ministry of Home Affairs, or you have Mr. Kwame McCoy, the honorable member, who seems not to be doing nothing much in his ministry. So I trust that he would be able to help in this regard to bring the necessary awareness. Because, sir, as I started, we do not want our people, the ordinary people in this country, to be caught with the element of surprise. As lawmakers, it is our responsibility, whenever we pass in laws, to ensure that our citizens are made aware as to the implications, the impacts, and the positives and negatives these laws will have on them. So, Mr. Speaker, with that being said, I want to commend the Honorable Minister for bringing this piece of legislation, and you have my full and unwavering support. But please, I request of you for the sake of my people, the ordinary people, to consider rolling out an education awareness program. So with that being said, sir, I thank you very much for the time. May God continue to bless us, and may God continue to bless our dear land, Guyana. Thank you.
Amen. Thank you, Honorable Member. And now for the Honorable Minister of Culture, Youth and Sport, the Honorable Charles Ramsey.
Thank you very much, Mr. Speaker. I don't often get the privilege of following Annette Ferguson. After a parliamentary debate, and I couldn't help but notice, after I've been paying attention to, over the years, Annette's predilection for death and funerals and campaigning at funerals. And I expect you to come at my funeral, but please call me by my right name. And so while I was up there and I heard about the question that the honorable member had asked, and I noticed her morbid obsession with death and funerals, one of which that was displayed at Brother James's funeral. I took the liberty, and with your permission, I took the liberty of finding the definition of the word morbid. And if I can read it for this House, I would love for the House to be acquainted with the definition of the word morbid. Characterized by an unusual interest in disturbing and unpleasant subjects, especially death. Mr. Speaker, I am very pleased to stand here in this House to support the government's initiative that is a series of measures that is being introduced to this honorable House to introduce something called in this bill, this Motor Vehicles and Road Traffic Amendment Bill, something being introduced for the first time called a road intelligent camera system. That is what it's referred to in the bill. But it's not a new system that has been in the way in which countries organize themselves and governments place into the structure of governance. It's been around a while, which is a camera system to aid in the way in which policing and compliance is done, deterrence as well. And this bill seeks to add to the measures of a problem that exists in this country, which is like a plague, that causes the loss of life for hundreds and even thousands over the years of our people, Guyanese people, through road carnage. And this problem that exists particularly plagues young people who use our road. And if you check a lot of the data, whether it's in Guyana but around the world, it shows that they are the category that are most at risk. And it's a huge loss for the country. And it's important that I want to share with you some of the stats for fatal accidents over the years. And even though 2023 was a very serious year, a spike in the number, over the years, the numbers have been high. In 2015, there were 126 persons who died from road fatalities. In 2016, it was 128 persons. In 2017, it was 115 persons. In 2018, it was 119 persons. In 2019, it was 122 persons. And then in 2020, it was 139 persons. 2021 and 2022 were particularly low with 99 persons. And then for 2023, it was our highest recorded year in the last 9 years or so, with 175 persons. So it's important that the country understands the stats over the years. And why should government take action? And it's not just that government should take action now, because I heard the Honorable Member Amanza speak about they are serious on this side. But in the period that I just described, with the stats showing similar numbers and higher numbers with the exception of 2023, there were no efforts that were made. No efforts that were made from a legislative standpoint that could have helped to change the way in which our legal framework is organized, but we are doing it now. And what's also important to note is that we have truncated the process. We've truncated the process because a lot of the cameras and camera systems have already been installed and have already been tested and functioning well. So this part of the legislation is not just the segment where we put it into law. This is now moving into rapid operationalization. But why should government take action? First of all, the loss of any Guyanese is a loss to all of us. No matter who you are, which side of the political divide you stand on, the loss of any Guyanese is a loss to all of us. And government and the entire country makes an investment in every single Guyanese born on these shores. Every single Guyanese born on these shores, government makes significant investments, whether it's in education or in health or in public infrastructure that we use, all of us use, or public security that we benefit from to keep us all safe. All of that comes into the investment that government and the country makes, even at a community standpoint, and public spaces and markets, etc. All of that, personally, government makes that kind of investment. And since every life is of equal value, and also because every single Guyanese has an important contribution to make in this country, it is important that government takes measures, when at times firm, sometimes even to the resistance or the chagrin of citizens, measures that have to be put in place so that citizens can be protected. I remember in 2002, when in this very same act, the Motor Vehicles and Road Traffic Act, when Minister Ronald Gadraj, under the previous People's Progressive Party government led by President Jagdeo, the amendment was made for the introduction for the requirement to use seatbelts. And that was met with some initial resistance and change of habit. In fact, many of the cars that were being imported at the time, the provision had to be included for those vehicles to be retrofitted with seatbelt equipment, because it did not include seatbelt equipment at the time. And then that's on the fatality side. There's also injury. When vehicular accidents occur, it's not just that people die, they're also during the time when, if no deaths occur, but injury occurs, there's a long time of convalescence, and loved ones have to put their energies towards their care and getting them back, if even at all they can get them back to their original state. But the studies have shown that the importance of placing emphasis on speeding or reducing speeding, and also the wearing of seatbelts. And this is not just conjecture. There are two studies that I will share with this House. First of all, the effectiveness of seatbelts in reducing injuries. And this was a study that was done in 2007 by Professor Sunanda Desananke, and this was out of the University of Arkansas. And in there was a meta-analysis, but specifically they found that seatbelts, the wearing of seatbelts, reduced fatal injuries by 56%. 56%. And even though it is understood and widely understood that what is the purpose of the seatbelt and how important it is still not a universally applied practice. Many of us, even in this house, may also be the ones that are not applying this important life-saving techniques. It also found that for other passenger vehicle group that included vans and pickups, seatbelts were found to be 61% effective in preventing fatalities. 61%, Mr. Speaker. Then we have the importance of reducing speed. This is from a study from the National Transportation Safety Board, a study out from the United States. This was in 2017, where they found that from 2005 to 2014, crashes in a law enforcement officer indicated a vehicle speed was a factor resulting in 112,580 fatalities, representing 31% of all traffic fatalities. And then the danger doesn't only exist for the persons who are in the vehicle. It's also for the persons who are pedestrians. So if they are struck by a person who is speeding, it affects by multiple factors their ability to live, and it increases as you go faster. So and the stats are significant. It says here that the likelihood increases, it's speaking about fatalities, the likelihood increases to 45% at 30 miles per hour and 85% at 40 miles per hour. 85% at 40 miles an hour. So it is clear and quite commonly understood, and one would expect too, that given how common this position is, this understanding is of both wearing a seatbelt as well as reducing speed, that members on the other side would not give qualified support, that they would just give support. And I've heard members on the other side speak about support, but list a long barrage of reasons why they should not support, as though that in any way shapes the direction at which this can go if they do not present solutions. If they do not present solutions. Let's take, for instance, and I didn't feel that it was necessary for me to come with information to seek to mollify the concerns. Don't look too confused, Mr. Mahipal. Mollify comes from the Latin word mollificare, means to soften. I didn't come to address those things, but there were some points that were raised during the presentation. Let's say, for example, what happens when it's sent to the wrong phone number? There is a particular section in the very bill that addresses this point. Here is what it says in section 45J 3, it says, service shall also be done personally as provided under sections 8(4), 12, 13, and 14 of the Summary Jurisdiction Procedure Act. Now let's go into what the Summary Jurisdiction Procedure Act says. Section 8(4). A notice under subsection 1 shall be served on the alleged offender personally, and the date stated in the notice as the day on which the alleged offender is required to appear in court shall be at least 14 days after the date of the issue of the notice. The very same bill for which the Honorable Member, Ms. Desir, raised questions on about what happens if it goes to a wrong number. It is already addressed in the very same bill. In addition, it doesn't change the fact about whether the offense was committed in the first place. And the information about how persons can get this transmission via phone or via email, etc., speeding and the use of seatbelts are already part of the law. So it's not something that is new. It is just the way in which compliance is going to be enforced. So it's not going to require a change of behavior that the law is going to be putting into place. This is better compliance and better monitoring, so that when persons know, for everybody knows that they should not be speeding in the first place. They know that. They also know that they should be wearing their seatbelts. So it also means that, with the exception of particular categories, but it also means that if we are going to implement a new system by which you would be notified, it doesn't change by what is the new crime. There's no new crime here that is being created. There's no new requirement other than to have your phone registered, which is already done anyway. Let's take, for example, somebody who is not the owner of the vehicle, which my friend raised in her presentation. If you check the very same bill, check 45(1) or 45I, I should say. Three. If the registered owner at the time of entering his plea at the hearing of the offense alleges that he was not the driver at the time, that's already part of the contemplation of the bill. So you have to go in to get into that level of detail. And it allows for any person who is driving, if they are notified, they get the opportunity to come to the court to say that I wasn't the owner or that I wasn't the driver. The court will make that adjustment and then get the proper notice to the individual. So those are not the concerns that really should be highlighted here as reasons for not supporting or for conditional support. Let's take another issue that was highlighted about privacy. Right now, you have cameras by private persons displaying, taking recordings of the public, the road, right now in 24 hours a day. If you have right now by the Demerara Harbor Bridge a traffic camera set up, that is, we can pull up on our phone right now and see what's traveling right there 24 hours, almost in real time. This is not something that is a concern anywhere in the world in relation to whether persons should be speeding and what efforts government should be taking in order to help to reduce speeding and enforce compliance, and at the same time save lives. The importance of saving lives in any country is of paramount concern for every government. The other important factor about, and contrary to the concerns raised by Ms. Desir, Honorable Desir, that the cameras might be impartial. The cameras might be partial, forgive me. Now, the fact that they run and operate on a mechanical or in a mechanical basis, it means that it reduces the opportunity for one, human error. It also reduces the potential for corruption, so that when somebody stops you for speeding and they said that they're going to give you a ticket, all of those things are now reduced because this mechanical function comes into play. So I want the public to know that this is a very serious issue that the country faces. And in many instances, when accidents occur, first of all, accidents do occur. There's no way in no place in this world that exists that accidents don't occur. But governments have to take every single measure that they possibly could take without slowing down the wheels of the economy and the productivity for people, that they can take all measures so that they can keep people safe. And this is one of the measures that we can take. And it's important to note that the support coming from the opposition here, and in the persons who spoke, they started off by saying that they support. But when you check the seats on the opposition here, their support is the support by absence. That's where their support is, by their absence. They consider the subject matter of the legislation to be so important that they would be absent, as usual. So this government of Guyana is going to continue to modernize the legislative framework in the country and to take every single measure that we could take to help to save the lives of Guyanese people. They are Guyanese, and especially young people, are the future for our country, and a lot has been put into their welfare. That is the reason why this bill should enjoy not qualified or conditional or concerned support. it should enjoy universal support from this House and from this country. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Minister. And now for the Honorable Member, Mr. Devin Sears.
Thank you very much, Mr. Speaker. Mr. Speaker, members of the National Assembly, parliamentary staff, guests, well, they left, members of the media and Guyanese. Between 2020 and 2024, speeding has been a significant factor in road accidents in Guyana, contributing to numerous fatalities and injuries. In 2021, there was a notable increase in traffic deaths attributed to speeding and reckless driving. Despite various campaigns and increased enforcement efforts, speeding remains a critical issue on Guyanese roads. From 2020 to 2023, Guyana experienced a consistent struggle with speeding-related accidents. In 2023, the Honorable Member, Minister Rupson Ben, emphasized the need for intensified measures to combat rising fatal road accidents. The Guyana Police Force, GPF, and the Ministry of Home Affairs launched a Respect the Road campaign to address these concerns. It is yet to be determined how effective that campaign is, since according to Kaitro News, of which the Honorable Member Charles Ramson would have mentioned, that in 2023, we had experienced 175 road fatalities. What the Honorable Member Charles Ramson should have mentioned is that that increase between 2022 to 2023 rose by 76.8%. 76.8%. To address these issues, the installation of intelligent camera systems to monitor and prevent speeding could be a valuable measure. Such systems have been implemented in other countries with varying degrees of successes as well as challenges, such as high costs, maintenance issues, and public resistance due to privacy concerns. However, when effectively deployed, these systems have proven to be significantly reduce speeding and enhance the overall security on our roadways. By adopting advanced technology solutions and continuing rigorous enforcement of the traffic law, Guyana can work towards reducing these incidents of speeding-related accidents and saving many lives. Mr. Speaker, allow me to continue my contribution to this important amendment that has the potential to save countless lives on our roadways. The installation of road intelligent camera systems to monitor and prevent speeding. As we navigate through our daily lives, the safety on our roadways is paramount. Speeding remains one of the most significant factors contributing to traffic accidents, often resulting in devastating consequences. But here are the benefits, Mr. Speaker. Firstly, the intelligent camera systems are highly effective in monitoring and detecting speeding in real time, unlike traditional enforcement methods. And rightfully, the Honorable Minister would have mentioned you either right or left. Secondly, the data collected by the cameras is invaluable for traffic management and accident prevention. By analyzing patterns and trends, authorities can identify high-risk areas and take proactive measures to improve road design, implement targeted enforcements, and launch educational campaigns, of which the opposition has emphasized a lot about. Moreover, the installation of the intelligent camera system promotes a sense of fairness and transparency in law enforcement. Unlike traditional methods that may be perceived as arbitrary, the automated system ensures that all drivers are treated equally, reducing the likelihood of bias enforcement and fostering a greater public trust in the traffic regulation. Despite these compelling benefits, it is important to acknowledge that the implementation of an intelligent camera system is not without challenges. And some of these challenges are: one significant challenge is the initial installation and maintenance. And I know the government might argue that we have oil money now, so that should not be an issue. High quality intelligence systems require substantial investment, and securing the necessary funds can, in some cases, be a hurdle, of which I'm sure in the 2025 budget, the 1.6 or $2 trillion will suffice. Another challenge lies in public perception and acceptance. In some countries, there have been a resistance from drivers who view the system as being invasive and punitive. To address this, it is essential to engage a transparent communication and public education campaign that highlights the primary goals of the system to protect lives. Data privacy and security concerns also pose a challenge. The collection and storage of vast amount of data raises questions. One of it being, is the NDMA capable at this point to handle such data? So, Mr. Speaker, according to the amendment of the data, in this amendment, the National Data Management Authority, NDMA, will be charged to store and grant access through a web application. Let me say this here and put it in record that we must have extensive training for the staff. We will need increase in staff and also provision of the necessary resources and redundant backup. Finally, on this matter, the integration of an intelligent camera system with existing infrastructures can be complex. Ensuring compatibility with current traffic management systems, addressing technical issues, and training personnel to operate and maintain this new technology must be executed in a careful and well-coordinated manner. Mr. Speaker, I have some concerns with regards to some of the clauses in this amendment. One of it being, in Clause 5, the NDMA shall give every magistrate court access to the database by web application. Traditionally, the state prosecutor would present his or her case accompanied by evidence, of course, which was granted by the NDMA and presented to the magistrate. But in this case here, the magistrate, I don't see what is the need for the magistrate court to have access to that sensitive data unless it's presented in court by the person. Well, I stand correct. I'm not the learned lawyer here or the attorney, right? Good. Going ahead, in clause 45I, 1, notwithstanding other law, the procedure set out in section 8.1 of the Summary Jurisdiction Procedure Act, where a member of the police force assigned under the section 45G4 finds a camera has captured a photographic image or video of the motor vehicle driven by a person which discloses that an officer or office. Anyway, the point I'm getting at, I got a little tongue-tied here, right, is whereby it says here, the member of the police force shall, and we have to be careful with our language that we use, the member of the police force shall send a short message with regards to the offense. The challenge with this here, if we're implementing a smart technology, why is it that we have to now rely on a person to send that message? This is my contention with this here, Mr. Speaker. Now, with regards to this smart system, in real time or almost immediately, a text message should be sent to the registered owner that an offense has been committed. Like take, for instance, with me traveling from Linden, maybe we might have several, I'm running late for a meeting, several of these systems in place along the highway on the east bank into Georgetown. I'm speeding. Do you know that that can actually save my life by just getting a message that says, hey, you know, you committed offense at X, Y, and Z. Right away, I become conscious. So I'm saying that this system here can be improved. And I'm hoping that the Honorable Minister considered this here as part of his plan. I'm not saying that the amendment is perfect, but I believe it can be strengthened. So don't ignore our recommendations here today, right? the other thing is the notification can be, like I said, be done automatically as soon as the offense is committed through various algorithms, which informs the registered owner through email, WhatsApp, or SMS. This then prompts the driver to slow down, or even the owner be aware of the said offense. With regards to clause 445I3, speaks to registered owner entering a plea in the case where he or she is not the driver. The said driver becomes the co-defendant in the proceedings. At the end of the day, the owner is responsible for the payment of the fine if the driver does not pay. In cases where an individual owns several vehicles, let's say for instance, and this is where we need clarity, several vehicles, like take for instance a rental company, does this put the owner's license in jeopardy, which leads to maybe suspension or being revoked based on the Motor Vehicles and Road Traffic Acts? What I'm saying here is that you have one owner with several vehicles, and we're doing pretty well. I'm sure the honorable members on the other side have several vehicles that they're proud of, and they have persons driving them. Does that mean that the owner of those vehicles is going to face the wrath of the law? In the case of emergencies, how will the system distinguish between an ambulance and police patrol cars or even state vehicles? I suggest that a digital exception tag be administered for state-owned vehicles, whereby they can drive along freely in the case of emergency. Because I'm pretty sure that a lot of digital fines will be sent to state-owned vehicles or the various ministries in this regard. The other thing I want to mention is regards to how important this here becomes. In the case of when a police officer or traffic rank stops a vehicle, normally they would ask for three things: license, registration, and fitness. Now, to improve this system, what I suggest that the government considers is that with those same license, given the fact that many, in some cases, they might not see the notification of the offense or check their emails, with simply scanning that same driver's license card, those information can pop up there, and of course, bringing the offenders to justice. Mr. Speaker, installation of road intelligent camera systems to monitor and prevent speeding represents a transformative step through enhancing road safety. While challenges exist, they are not insurmountable, since we cannot put a price to life. But learning from the experiences of the other countries, engaging in transparent communication and prioritizing data privacy and security, we can successfully implement these systems and create safer roads for everyone. Let us commit to this initiative with the knowledge that every effort we make brings us closer to a future where our roads are safer and lives are protected. Unfortunately, Mr. Speaker, this was not the case for several persons throughout the year so far, like Shemroy Henry, 27 years old of my county, or Dioraj Baldio, 33 years old, who died in a minibus accident in Orangestein Public Road, East Bank, Essequibo. Mr. Speaker, we must not forget Rochelle Leacock, Edo Leacock, Urani Hall, Clinton Patterson, and Waylon Farrell. 5 lives that were lost along Long Creek there on May 13th of this year. Or Keon Harvey, 38 years old minibus driver who died on May 26th. Or just last evening, I was in Marbaruma, and a young man lost his life. Zayden Calistro, 24 years old. Pardon? Please, Calistro, who lost his life as a result of a speeding motorcycle. Mr. Speaker, these are unfortunate incidents that happen. But voting on this law and implementing it, it will definitely save a lot of lives. Mr. Speaker, smart city solutions for the nation can significantly improve urban life by improving infrastructure, governance, and overall quality of life. I can assure Guyana that our movement through the party I represent on this side of the House embraces a modern Guyana and will do more than just supporting this amendment. When we win the next election, this is our vision for a modern Guyana. We are looking at an intelligent traffic management system, smart traffic signals, traffic monitoring and analysis. Two, we'll be looking at smart public transportation, real-time public transport information, integrated payment systems. We'll also be focusing on power management, smart grids, and smart metering. Mr. Speaker, under the new government of which my party will lead, we will focus on waste management, smart waste bins, recycling initiatives, public safety surveillance system, emergency response system under the new government, water management, smart water meters, flood monitoring systems, digital governance, e-government services, open data initiatives under our new government that is led by the party that I represent. Smart buildings and infrastructure, energy efficient buildings, infrastructure monitoring. We'll be focusing on smart health services, telemedicine, health monitoring systems, environmental monitoring, such as air quality, and also green spaces. This is the vision of the party that I represent. And of course, better will come. But for successful implementation, it is essential to ensure strong collaboration between the government, the private sector, and local communities, communicating with doctors, ensuring good campaign and educational approaches, and also take advantage of the educational system for instruction from an early age in road awareness and civic and public rules. Furthermore, investment in digital infrastructure and capacity building initiatives are crucial to supporting smart city solutions. Mr. Speaker, having said all of this, I submit some of those recommendations, and I trust that the Honorable Minister, Rupert Zumben, will consider them as part of this amendment. Mr. Speaker, I can safely say that while there are some loose ends with this bill, this amendment, I believe over time we can improve it so that it reflects the needs of the folks and the beautiful residents and citizens of Guyana. With that, Mr. Speaker, I support the amendment to the Motor and Vehicle Traffic Amendment Bill number 2024, Bill number 9 of 2024.
Thank you very much, Honorable Member. Mr. Sears. And now for the Honorable Member, Ms. Kathy Hughes.
Thank you, Mr. Speaker. Mr. Speaker, I'm happy to have the opportunity to provide some consideration on the Motor Vehicle and Road Traffic Amendment Bill, Bill number 9 of 2024. Bill described as seeking to provide a road safety technology known as the Road Intelligence Camera Enforcement System, which will provide 24-hour surveillance for drivers who are detected speeding or persons failing to wear a seatbelt. Mr. Speaker, in July, this exact same month, in July of 2019, I stood in this very compound as Minister of Public Telecommunications, and along with my colleague, who unfortunately is not here at the moment, former Minister of Public Security, Kemraj Ramjatan, together we successfully launched Guyana's first Safe City project, started under the Granger administration in July of 2017. This was a key component of our national broadband project, funded by the Chinese government to a tune of $32 million US. I mention this for two reasons. In fact, earlier I heard a suggestion that this did not even take place. But however, any simple Google search will verify that it took place, this event, the launching of this Safe City project, took place in the compound just behind us. The other reason I want to mention this is because this proposed legislation is really a natural progression and expansion of this vital infrastructure, implementing new technologies as they became available, all with the goal of ensuring order and safety on our roads. To remind many of you who may have forgotten, at the time under the project, over 119 CCTV intelligence surveillance cameras were strategically placed in the city. This was not done ever in any time before 2017. And I also want to say that another 17 cameras were placed at very strategic locations that impact on our safety and security as a country. And of course, here I'm talking about them being placed at exit points such as the Chedijagan International Airport and the Eugene F. Correa Airport in Ogle. The high-tech system can perform face and car license registration. Several police vehicles were also equipped at that time with cameras and radios that can be traced and accessed at any time. From the security control room, equipped with a band of massive TV screens. Again, the command center is just behind us, right? And at that launch, we demoed the video internet-ready radio sets and body cams that were part of this project. I do not know if those are in use today. The system at the time was managed by the National Data Management Authority. And interesting, at that time, the committee that provided oversight had representation from the NDMA, the Guyana Police Force, the Army, and the Guyana Revenue Authority. The command center, as we know, is located in this compound, and the highly skilled operators of the center had access real-time to over 100 cameras across the country that they can pull up on a big screen as they keep watch. The only challenge with this system, as we know has taken place on one or two occasions, is when instructions have been given for cameras at strategic locations to be switched off. But at least in terms of the technology, we know the capacity exists. So I really want to say that what is most important about this system is that the control room was connected to all stations in Georgetown, making the system the most effective instrument in monitoring incidents of crime in the city. Now, the success of the system has been hailed by President Ali in November of 2021, when he highlighted its expansion into a safe country program, which would operate across the country. And certainly, if that were to take place, we would be in full support of that. The intention of the Safe City program was always that it would start in Georgetown and go to several strategic locations, providing safety and security to all Guyanese. Since those early days, the National Data Management Authority, the NDMA, has responsibility for managing the technology and the program. And in fact, the first part of this bill gives an amendment to the definitions in terms of making it very clear who and what NDMA is. Mr. Speaker, on the onset, I want to state categorically that I support this bill. And I am happy that it has come to this Parliament and we are debating it today. I, however, have some very, what I consider positive contributions and also things I've noted with the bill that I put out for consideration. So the first thing is that, of course, Clause 3, the first page in terms of the definitions, one of the things that we noticed in the substantive principal act at Article 53B is that it makes reference to violations in relation to traffic. And of course, this, for example, is in relation to signs where quite often traffic signs are ignored, they're not adhered to. And so one of the amendments I would have liked to have seen is in terms of adding to the definition at the very, very first part of the bill that we include traffic directions in relation to the use of signs and signage and violations of not following a sign. Right now, we're looking at seat belts and we're looking at speeding, but it's easy to incorporate the fact that we should be prosecuting persons when they deliberately do not follow the signs that are required to ensure the safety. So, in addition to that, at Article 545G, notices of signage for cameras should also be placed where cameras are erected. I think it's important to say to the public, you are being monitored. It actually, in fact, I think would strengthen the legislation, because if and when you were to get into a court, you would be able to say that you knew, because you would have passed strategic signs every now and again that informed that you were being recorded. In Article 45H1, and it talks about an offense against Section 34. I do want to suggest that I think that is a typographical error. And why I say that is because Section 34 actually deals with driving and the requirements of young drivers and not speeding. So I think there's a typographical error because Article 35 is the one that deals with speeding. When we get to Article 45H1, and again under C it says offenses against Section 53B. As stated at number 1, without including this article, and that here I'm referring to the offenses under Section 53B, I think that without including that aspect, the bill really doesn't have as much oomph, as much strength as it could have. As we're saying, we know that there's so many street corners where the traffic light signals, the speeding, and also traffic signs are totally ignored. Article 45I1 refers to sending SMS to a mobile phone of the driver. And I really want to say that in many respects, if we consider the time it will take, the public funds, the resources, to police the passage and the delivery of SMS, I think that it would be borderline to almost a waste of time. The reality is that today several persons have multiple phones, but persons also have several persons have prepaid numbers, and we all know that after a certain amount of time, those prepaid numbers are recycled and, of course, disposed of at will by the telephone company. So again, ensuring that should you need to bring your case to the courts, you want to make sure that the legislation has enough teeth for you to be effective in the prosecution. Communication needs to be kept simple. And the reality is also that many people do not have an email address. And therefore, the question is, are we saying that to be a driver, one has to have a phone and also email account and email address? We all know the challenges of people claiming not to have received an email. And therefore, at strategic locations within the act, I think the option, it shouldn't just say email, but maybe and or by mail. I know our mail service, unfortunately, is extremely slow still. Many of us have received bills long after the due date. I had a case recently where a letter from Providence Police Station took 6 days, Providence Post Office, which is in the same location as the police station, took 6 days to get into New Providence, which is literally a 5-minute drive around the corner. But still, what we're trying to show is that it is important to provide options. And when you depending on persons to go into the GRA to update their information, one of the things we can recommend, we compliment GRA. They have a very effective online portal. And so, of course, adding information, updating information can be done through that portal. And I think, again, that's where some of the comments my colleagues have made on the importance of a public relations strategy, an information strategy to inform persons about these issues is so very important. So, Article 45I3, to help with the administration and the operationalization of this, it says that the vehicle owner may submit a declaration of non-responsibility to the court. And the fillable PDF form, of course, could be made available on the Guyana Police Force website for download also. So under Article 45I, the numeral 4 appears twice, Honorable Minister. And again, I think that is just a typographical error. On page 5, if you look, you go from page 4, you go from subsection 4, numeral 4 to 4 again, and then to 5. So there's some amount of reworking that needs to be done there. Another point to note is that the definition of owner, they say, means a person in whose name the motor vehicle or trailer is registered. And it's interesting because the first set of data that came out of the cameras that were positioned on the new bypass actually indicated, and this was in the press, that a large number of the violations were made by government vehicles. And therefore, I think it has been mentioned here before, not directly in this context, but the Act does need to address in some way a distinction between the owner of a private vehicle and certainly how it will handle government vehicles that may break the law in terms of speeding or the seatbelt. So, Article 45I5, a possible clause could be included to read, where the vehicle owner is the employer or company or principal, the responsibility shall not be transferred to the employee or the agents. Again, that's just a recommendation. And this, I think, could assist in dealing with the ownership and the liability issues. Article 45J refers to email service of notices, and this should not be necessary, and all articles referring to emails and SMS really should be deleted. In fact, I think just the administration, as we mentioned, just makes it so cumbersome. The form in the third schedule which is attached to the bill that we are considering today, actually lists the violations in terms of speeding and seatbelt. And just as I have raised the importance of 53 in the Principal Act, we could include very simply there violations in not honoring signs. So, Mr. Speaker, oh, so in terms of road signage is important. Speed limit signs, stop signs, lane markings should all be clearly visible to guide motorists. And in the absence of speed limit signs, how would one know if they are exceeding the law or exceeding the limit? And again, this is a consideration for when you get into that courtroom and need to make sure you are going to get the conviction. So certainly, we need to look at that in this legislation. If emails are not received or there's a change in circumstances where if maybe you had an email but there's no email address on record, we need to think of a system that is embodied in the legislation that explains what your requirements would be after that. 45M says that a person must supply contact telephone numbers and again, and an email address. And I'm just saying that it could be an and/or situation in that case. Mr. Speaker, these were some of the comments and recommendations I wanted to bring to the discussion today. The actual Motor Vehicle and Road Traffic Act is 5102 is a really excellent, comprehensive piece of legislation. And I'm happy that earlier the minister talked about us being able to add amendments over time. Mr. Speaker, I know you are an individual that's very strong on technology, and certainly we want to be able to ensure that our legislation keeps up with technology. So I support this bill, but one of the key challenges I see is actually found in the foundation upon which this act is based. And that is that we have to date no digital license plates in Guyana. Unfortunately, in Guyana, you can go to 2 or 3 street corners and you can actually say, please make a license plate number PBB 4510 or PPP 1 or 5. There's absolutely no system in that license plate that guarantees the authenticity of that plate in direct relation to the registered owner and the data that is being held by GRA. So one of the things that is very, very important that I can see would need to come back in probably a new piece of legislation is how we deal with digital license plates. As we all know, RF tags with registration information and the vehicle characteristics are absolutely the basic requirement now in most other countries. And really, we need to move into the 21st century in this area. We've moved from regular phones to smartphones. Similarly, we need to move to a smart or digital license plate. So the next step legislation would be to authorize the use of digital license plates in Guyana. And of course, the technology is there to ensure that these plates can be controlled by our smartphones. In fact, just about 3 weeks ago, I was looking at a very interesting story about a person in the US whose car was stolen. And with her digital license plate, she was able to change her license plate number to stolen on the back of the car. And those kinds of possibilities could change and improve the impact of our crime fighting. So I know that the question is going to be asked, Mr. Speaker, why didn't you submit some amendments? And I have to admit that I toyed with the idea. I seriously looked at it. But I have to say that unfortunately in this parliament, we do not have a reputation of accepting any, very little of the recommendations that come from one side of the House. So that was my lame reason for not submitting it. If I'm totally honest, I thought to myself, this really would probably be a waste of time. However, I will say that on reflection, and I have sent in recommendations and amendments that, in this screaming and shouting is never even considered. But on reflection, I should have. And I do want to say to the minister that should any of these recommendations be found worthy by him, I would be more than happy to document it and share my recommendations. Thank you very much, Mr. Speaker. Thank you, everyone.
Thank you. Thank you very much, Honorable Member. Ms. Hughes. Now for the Honorable Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlal, SC.
Thank you very much, Mr. Speaker. Mr. Speaker, I listened carefully to the Honorable Member, Mrs. Hughes, who spoke before me, and I share the pity that she expressed that she did not choose to table amendments before the House. The reasons that she gave are untenable. I distinctly recall in the Natural Resources Fund Act, I believe we accepted 10 out of 12 amendments from the opposition. 10 out of 12 amendments were accepted. So, Mr. Hughes, your lamentations, I don't accept. You did not put the effort forward, and I don't know what are you recommending to the Honorable Minister. If he thinks that your views are valid, then he'll take it on board. Where legislation has a process, it has to be taken on board here. And if there is nothing put forward in writing, how can the Honorable Minister take anything on board? So that's just a fluff on your part. If we had the recommendations which were hurriedly made, I was trying to follow you, but I couldn't. And I will deal with some of them that you mentioned. I couldn't follow many of the numbering queries that you raised. I don't see them in the bill. You made a number of queries about the numbering being wrong, and I was following, and I don't see the mistakes that you were identifying. Mr. Speaker, I am happy that this bill has attracted the support of all members of the House. It is indeed a very important piece of legislation, and it's one of the legislative intervention that is of a transformative nature that I keep referring. Vehicular accident, Mr. Speaker, is at an unacceptable level in our country. Every year, as we have heard, the Traffic Department of the Guyana Police Force records an unusually high number of road fatality figures. In January of this year, the Honorable Minister, in his end of year review, informed the nation that for the year 2023, there was a 76.8% increase in fatal accidents when compared to previous years, with the total number of fatalities soaring from 99 to 175. No one can find such situation acceptable. The horrific truth is that this human carnage on our roadway continues unabated and with impunity. Not only is it a human rights tragedy, but Guyana cannot continue to wantonly lose so many lives annually. And in particular, as one honorable member referred to on this side, these are mostly young people. And the worst part of it is that a large percentage of these accidents can be avoided if proper due care and attention is exercised by road users. Mr. Speaker, I will concede that legislation alone cannot solve this problem. We have to have a cultural change, we have to have a public education campaign, and a lot has to be done, and it cannot be the responsibility of the government alone. This is a national problem that is consuming large number of our young people in particular on an annual basis. We have been introducing legislation since 2020 to now. I can refer to the amendments done to the Road Traffic Act that increased the regime of penalties to exorbitant levels. I can refer to the creation of the offense of motor manslaughter. I can refer...
Mr. Speaker?
Yes, Honorable Member.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise on standing order 40A. And 40A says, by rising on a point of order, when the member speaking shall resume his or her seat, and the member interrupting shall simply direct attention to the point which he or she desires to bring to notice and submit it to the Speaker or Chairman for the decision. Mr. Speaker, the reason for me standing on this particular point is as a result of what the honorable member alluded to earlier with regards to the amendments to several bills and motions that we brought in this National Assembly. The honorable member stated that the opposition never submitted amendments, and in some cases, amendments that were submitted by us, they actually accepted a few of those amendments. So I just want to say to the honorable member, through you, Mr. Speaker, that we on this side of the House, our colleague David Patterson, did submit.
I have to rule on the question of whether you submitted amendments or not. That's a point of order.
Okay, sir.
And I could remember, I'll uphold it, because I remember some amendments to other pieces coming from the opposition. So if he says never, then he's...
I never said never. In fact, I give instances where amendments were...
Well, we could always clear that up, right?
That's what you interrupted me for?
Honorable AG?
Yes, sir. So, I said that you...
Honorable, we're checking it, so you don't have to repeat, please.
So, sir, I was referring to the amendments that we have already brought to the Road Traffic Amendment Act that increased the penalties and created the offense of motor manslaughter. We also brought amendments to the intoxicating liquor license liquor license legislation, in which we addressed the issue of selling alcohol and intoxicating liquor to drivers and potential drivers. We introduced a regime that allows for the suspension of driver's license, for the disqualifications of drivers from holding such license, and from the revocation permanently of driver's license where persons drive under the influence of alcohol on more than one occasion and cause fatal accidents. All those interventions have already been made, but the situation continues. We are trying another set of amendments here, targeting significantly speeding, which accounts, based upon the statistics, for more than 75% of the accidents caused on our roadways, and seat belts, another important factor in preventing, they may not prevent accident, but they certainly prevent death, and they certainly prevent serious injuries if they are used. Mr. Speaker, these amendments address those two issues primarily, and they introduce on our roadways for the first time a camera system that we heard so much about. The Honorable Member Kathy Hughes spoke about some safe city and so on. Well, I don't know where those things are, but this is what we are bringing in now. And we have heard a lot about the system. I don't need to speak too much about the system, except to deal with how the system will generate the road traffic tickets. Mr. Speaker, the system has been used, I know, in North America, definitely, and in Europe. It is now being introduced in the Caribbean. In crafting this legislation, we look closely at the jurisdiction of Trinidad and Tobago, where the system is up and running. The United Kingdom, Mr. Speaker, introduced speed cameras and other speed calming measures in 1990. A comparison of fatal crashes over the ensuing decade in the United Kingdom and the United States, where speed cameras were introduced in a limited and sporadic fashion, found that the UK road deaths dropped by 34% from 1990 to 1999 when compared to 6.5% drop in the United States. The study obviously suggests that the greater reduction in fatal crash in the UK was due largely to small decreases in speed of drivers due to the introduction of speed cameras and other speed calming measures. So, Mr. Speaker, I don't think anyone will second guess the utility and value of introducing these cameras to monitor our roadways. Mr. Speaker, the bill, I can go to the bill itself, apart from the technical part of it. There is a camera that will be set up, and this camera will capture the data on our roadways, and the camera will be controlled by the NDMA for that purpose. The traffic chief shall assign members of the police force who shall have access to the database. Now, one member on the other side made a great fuss about data protection and storage of data. Mr. Speaker, this bill can't deal with those matters. Data protection is dealt with in the Data Protection Bill. This bill will store such data that is necessary for the prosecution of the offenses for which the bill is established and the bill intends to prosecute. I don't understand how the level of criticism and commentary that comes from some members on the other side. The member spoke about 45 minutes about data protection and about the need to have this data encrypted. And it a horrible attempt to sound sophisticated.
Well, AG, you gotta watch your timing, right? Because
Yes, sir.
only you get a chance when you're moving a motion to speak for 4 to 5. Everybody else gets 30 and 15, right?
But the honorable member spoke for 45 minutes on data protection and encryption of data, none of which has any relevance to this. So if all you understand, all you have to do is this will replace a system that is manually done. The same way that we store the manual paper in the court system is the same way the NDMA will be required to store the data that is requisite and necessary for the purpose of this bill. It's not rocket science. And we heard a long lecture about data encryption and data science. The NDMA will give every magistrate's court access to the database by a web application and provide a facility where payment for the tickets can be made at the magistrate's court in lieu of prosecution. So when the ticket is generated, and we have already put that system in place, we have already met with the judiciary, and there's a system in place now where the NDMA will send the data, the information, and the tickets will be generated at the magistrate's court and paid at the magistrate's court. And of course, two sections of the Road Traffic Act are affected here, and the two sections are the one section dealing with speeding, and that, Mrs. Hughes, is section 34. You said that it's 35. That was one of the queries that you made, which was not correct. And in section 45D and 45E, 45D under the Principal Act deals with seat belts, and 45E deals with children with seat belts, etc. So those are the two sections, and of course, the minister has the power to extend by order this bill to apply to different other sections. So there is a call from the other side, for example, to let it extend to traffic signs. Well, once we have the technological apparatus in place, we will extend it not only to traffic signs, but to various other offenses. Once the cameras are in and the cameras are installed, then they would cover a wide range of offenses. If, for example, you have an accident, an actual accident between two vehicles, images from that camera can be used for the purpose of establishing culpability or liability. Notwithstanding any other law, the procedure set out in 8(1) of the Summary Jurisdiction Act, where a member of the police force assigned under Section 45G finds a camera has captured a photographic image or a recording for a motor vehicle driven by a person which discloses that an offense to which this section applies has been committed by the person. The member of the force shall, so in the same way that the opinion of a policeman is formed that an offense has been committed, the same way that that policeman forms that opinion and then sends a short messaging system. Now, Mrs. Hughes, I listened to her. She said she seemed to think that these different messages being sent or different forms of communication being sent to the defendant are somehow alternative to each other. They are not. They are cumulative. So there's 4 forms of notification in this bill. So whether your SMS not working, no, they're all cumulatively. In fact, I believe the defendant is being over notified. That was my personal criticism. Because you're sending a message by SMS, then you're sending the SMS is a short message, of course, telling him about the offense. Then he gets an email, which is the whole offense going there, the charge and everything. Then he gets one by registered mail, and then a policeman will still go and serve him manually with a summons in the way that it is being done now. So there is no possibility. Well, it's very difficult for a defendant to come forward and say that he or she has not been served. And of course, the commentary has been made, the criticism has been made that it will take time to get people's email address. Of course, it will take time. When we started the TIN system, all kind of criticism you heard. When we started the VAT system, all kind of criticisms you heard. So whenever there is change, there is going to be resistance. But we have to move in the direction where we have to have a database with every single person email in the country. And if you don't have an email, the time will come where you will not be able to transact business, not only in Guyana, but in any part of the world. So those who are listening to us now, they must know that is where the world is going. And if they are not prepared to be part of that world, so be it. They will not be able to drive motor vehicles. They will not be able to get licenses. They will not be able to participate in a modern state. And that is the reality. We can't sugarcoat this. So persons who have driver's license over the next few months, they will be invited to the GRA and the requisite data will be taken. If they don't want to participate, well then they will not be granted a license. They will not be able to drive on the road. So Mr. Speaker, it's as simple as that. And the section sets out how the notification is done, and it is sent. It is impossible for the technology to detect the driver and to find the driver. The technology will detect the vehicle. The honorable member, Annette Ferguson, is normally misguided. And in her misguided presentation, she spoke about the camera not being able to detect the tint, detecting the identity of the driver. This has nothing to do with the identity of the driver. That's why I'm saying that members are not reading this bill or bills that they're speaking on. The technology here is to detect the number of the vehicle. The number of the vehicle is stored at the GRA, and that is where the owner will be charged, not the driver, and the bill says that. Because we don't know. There is no way you can know. And that is how it is in America. You drive your brother's car in America, sir. Your brother getting the ticket at the camera, generated by the camera, not you, because they don't have you in the database as a driver. They have the vehicle, and the vehicle is registered to your brother. When the owner turns up and says, look, I was not the driver, then he has a duty to inform the court, either the clerk of court or the magistrate, if he decides. If you plead guilty, you pay the ticket right away at the clerk of court. If you contest liability, then you go to the magistrate's court. That is where you inform the magistrate, look, I was not the driver. Mary Jane was the driver. You are taken to know who drives your vehicle. You are taken to know that in law, because there is an offense for unauthorizedly driving a vehicle. So you are taken to authorize the person who drove your vehicle. So you tell the clerk of court or you tell the magistrate who drove the vehicle, and that person is made a co-defendant, and that person is also brought to court as well. All of that, Mr. Speaker, is set out in the bill. Where the owner is not the driver of the vehicle, the owner shall be responsible for ensuring the payment of the penalty stipulated in the electronic notice under this part. So, and of course, the driver, the owner, if the driver doesn't want to pay, then the owner brings him to court, names him as a co-defendant, and the magistrate will deal with them. The honorable member, Mrs. Hughes, raised a number of numbering issues. I don't know what they were, but I looked at the bill and they are all numbered. From 45, they use letters, and in between, they use numbers. So I don't know where
Mr.
the
Speaker?
issue was.
Honorable member.
On a point of order 40A, and for the record, I just think it's important that I clarify.
No, you can't clarify.
Well, not clarify. I did point out the error on the part of the presenter, the minister that's speaking now. Because
It's
he's
going to
made
be difficult
reference-
for me to verify the two hearsays, right?
No, I have the evidence right here.
You have the evidence?
I have the evidence right here.
And
Earlier on, Mr. Speaker, he referred to my correction to 45H A, which says offenses against section 34, right? And I said that it was an error because section 34 does not deal with speeding. I have a copy right here
Me
of the
too.
principal act.
I have a copy too.
so I won't be able to uphold your
It's
point
right
of order
here,
because
there.
I have
there
it
is going
right
to be
here
a
too.
And
contention.
on page 5,
Honorable AG, you can
there
continue.
are two forms.
Honorable member AG, I'm sure you're getting there. Go ahead.
No, section 34 from the Principal Act at page 40, the side note reads, marginal note reads, rate of speed. It says, section 34(1), it shall not be lawful for any person to drive a motor vehicle of any class or description on a road at a speed greater than the speed specified in the second schedule as the maximum speed in relation to a vehicle of that class or description. And if any person acts in contravention of this section, he shall be guilty of an offense. Section 34(1), section 34(2), a first or second conviction for an offense under this section shall not render the offender liable to be disqualified from holding or obtaining a license.
Mr. Speaker, for the importance of the Parliament, because clearly there's an error. So I'd like to give it to you, and I'm just saying
Yes,
that
but
I
can't allow you on this point. The order of rule, we can clarify it afterwards.
No,
Please. Honorable AG.
Yes, it is your error. I know it's an error, your error.
It is printed.
It is your error. You have the wrong one.
It is printed in the
You
copy.
have the wrong
AG,
one.
I
Yes.
can make an error, please.
Yes, sir. So the NDMA system, as I said, is linked to the Guyana Revenue Authority system. And that is how the information is generated. The information on the e-ticket, sir, shall include a date, time, place of the traffic offense, the law which created the offense, such particulars of the traffic violations, and the registration of the vehicle. All that the e-ticket has is what a ticket currently issued to you manually will have. It's as simple as that. It is just that was what was being done manually, we are now doing it electronically. And of course, the images, data, video recording, etc., that is generated or that are generated and produced by the camera, obviously would be admissible in the court to establish the offense. And then we have the important provisions that Minister Ben spoke about, and that is the duty of the NDMA to ensure that the system is working and that the system works, that the equipment are calibrated, that they are serviced, that they are functional, and that they are certified by the Bureau of Standards to be functional and accurate, because people's liberty are involved. You don't want people to be convicted wrongly, neither do you want guilty people to go free. The minister spoke about a notorious fatal accident case where our national cyclist, Bentley, was killed, and the driver of the vehicle charged was acquitted, not because he was not guilty or he didn't commit the accident, but because the machine, the breathalyzer, was not functioning and did not register the level of alcohol that was in the system. And that error, based upon what the newspapers report of the magistrate's decision, was a crucial factor in the magistrate finding the defendant not guilty. Mr. Speaker, I don't think I'll detain the House much longer. I believe that I've dealt with the issues that I wanted to address, and I therefore commend this bill for passage. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Attorney General. And now for the Honorable Member, Mr. Brinley Ben.
Thank you, Mr. Speaker. Mr. Speaker, I want to particularly thank those members, honorable members, of course, on this side of the House who presented on the matter. It appears that in spite of my deliberately reading almost every section of the every clause, every section, every word of this amendment bill, that still persons, for whatever reasons, have gone into particular confusions on the other side. But in any event, I want to thank all members who presented on it. I want to remind ourselves that the serious nature and the particular opportunity we have to have this intelligent response separate from human intervention in respect of bringing this particular resort to reduce road traffic accidents and fatalities and injuries resulting therefrom. I want to, of course, deliberately thank, for good reason too, somehow, Ms. Walton Desir, Bishop Juan Ejil, Ms. Ferguson, Mr. Giles Ronson, honorable members all, Mr. Devon Sears, Ms. Hughes, and just now, our Attorney General, the Honorable Anil Nanlal, who I think has saved us just a lot of time in specifically going through the issues and clauses and the questioning of aspects of the bill in relation to bringing our discussion or debate on this matter to a close. In going through the bill, and I know that we'll go through it clause by clause just now, I only want to point to, which I mentioned previously on page 4, 45I-B, we have Roman numerals, I guess, so I think that you have 1, charging that owner with the commission of the offense, and then you have 3, which I think there is a mistake, it should be 2 rather than 3, and then 3 at the bottom in Roman numerals. Maybe we could clarify that in going through it in clause by clause. On specific issues, there was talk about the NDMA and its capability. I worry about some of the assertions which were made. While I take the point that training has to go forward, that there be new experience and new equipment going on, I believe that it is, we do a disservice to our young people and technicians and experts in this field when we try to characterize every fairly deliberate, considered step.
Honorable Minister, you said there may have been an error at 45.2?
Yes, if
45B2?
B, it has 3 in my print here.
Oh, yeah, just.
Yes. I don't know if we need to get a minute suspension to clarify, because we don't want to have to come back to amend this.
Yeah.
Okay. It's numbering, and the clerk will normally tell us that if there is numbering, we have the authority to put it in the proper sequence. So we don't have to do it.
Okay, so I'm just pointing that out. No. This is a point I made earlier, and I'm just reminding ourselves of it here again. But, well, I think the questions of SMS and data capture and data storage and transmission and so on were adequately addressed already. The question of whether the ambulances and the police vehicles would be identified, particularly in relation to being charged when they are in response missions as force responders. Those things are a given. We are not inventing anything anew here. I think that there was some issue where, well, I perhaps really shouldn't get into them, but equitable rights, data privacy, I accept, and this is natural that as a result of bringing this thing into being, there will be the robust public education. I did say, or bringing into being, which will take part or be part of the exercise about do the right thing. I did speak to a number of different initiatives we took over the years, and I said that there was a respect the road thing going on now, and that we're going into a phase of doing the right thing. And so I wasn't sure that people heard me when I said that. Particularly again, I want to emphasize that there are the questions of removing bias, reducing corruption, improving integrity, and all of those issues. I again say that we have had, well, I say now, that we have had test runs done for this intelligent system, and that in runs we have had exceedance of speed limits of an average of about 354 or 360 on a daily basis, where it was tested. And it just points out that over 100 days or so, you got 34,000 or whatever number of delinquent behavior, risky behavior on our roads, which speaks to what happens. And so when this is rolled out over the country, and the fact that you will be getting your SMS messages and all information and being called to the court, and being aware that it works, we expect that there will be a dramatic improvement in relation to this problem once everybody gets on board. And significantly, on the other side, it appears as though people might be paying some lip service or grandstanding for the cameras and for it going out there by saying that we support the bill and so on, but the amount of negativity, the amount of doubt, persons that seem to be assailed by doubts or assailing themselves or throwing out doubts in relation to every step and improvement that we try to make. The Honorable Attorney General too did speak and others did speak to the question as to whether, as to the fact, when there is an improvement, when there's a step forward, there is resistance. In this matter, we cannot have resistance anymore. The resistance and negativity will only result in our having high level of road deaths, again, particularly amongst young people, with the negative impacts which persons have somehow on both sides of the house decried, pointed out what its impact on society and communities and families, and it will not make us arrive at reducing road deaths by half by the end of the decade of 2030. So I want to look forward to our full engagement on this matter. We ourselves may not deliberately do something which will cause an accident, but we can still be impacted by an errant motorist. So it is of interest to all of us on all sides of the House, and I want to commend this bill for thorough consideration by the House and for full support in going ahead with this really important initiative. Thank you, Mr. Speaker and honorable members.
Thank you very much, Honorable Minister. Honorable members, we have had the contributions on the Motor Vehicles and Road Traffic Amendment Bill 2024. I now put a question that the Motor Vehicles and Road Traffic Amendment Bill 2024, Bill number 9 of 2024, be read a second time. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a second time.
Motor Vehicles and Road Traffic Amendment Bill 2024, Bill number 9 of 2024.
The House will now resolve itself into committee to consider the clauses of the bill. Honorable members, I now propose the question that clauses 1 to 3 and the schedule form part of the bill. Honorable members, I now put a question that clauses 1 to 3 and the schedule form part of the bill. Those in favor say aye. Those against say no. Ayes have it. The clauses now form part of the bill. Honorable members, I now put a question that the bill be reported to the Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the Assembly resume. Honorable Minister of Home Affairs.
Thank you, Mr. Speaker. Honourable members, I rise to report that the Motor Vehicles and Road Traffic Amendment Bill 2024, Bill number 9 of 2024, was considered in committee, clause by clause, and was passed without amendments. I move that the bill be now read the third time and passed as printed.
Thank you, Minister. Honorable members, the question is, and I put a question, that the Motor Vehicles and Road Traffic Amendment Bill 2024, Bill number 9 of 2024, be read a third time and pass as printed. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Motor Vehicles and Road Traffic Amendment Bill 2024, Bill number 9 of 2024.
Honorable members, I understand that we will now move to the affirmation of the University of Guyana Amendment Order 2024.
Wait, please, you.
Honorable Minister of Education,
Yes,
you may
sir.
now proceed with your motion.
Good morning, Mr. Speaker.
Good morning.
We have before us a motion to amend, a motion that allows us to affirm an order that seeks to amend the act that deals with the University of Guyana. That motion reads as follows. Be it resolved that this National Assembly, in accordance with Section 12(7) of the University of Guyana Act, Chapter 3902, affirms the University of Guyana Amendment Order 2024, number 43 of 2024, which was made on the 26th day of June 2024 under Section 12(7) of the University of Guyana Act, Chapter 3902, and published in the Official Gazette dated 27th of June 2024. And Mr. Speaker, that order seeks to, that we attempt to affirm here, seeks to amend Order 12, Section 12 of the University of Guyana Act, which provides for a council to be established and for the members that would comprise said council. Your Honor, it's no secret that the University of Guyana is precious to the People's Progressive Party and has been treated as such over the years. I think, for the record, given that this is one of the few times we've dealt with this matter holistically, I think it's good for us to speak into the record the existence or how it came to be, how the University of Guyana came to be. So, on September 29th, 1961, former PPP Minister of Education Vernon Nunes, or Nunes, however it wants to be pronounced, established a working party on the feasibility of setting up a local university. A university was possible. Nunes then submitted a document for cabinet consideration on December 6th, 1961, and that got approved. The University of Guyana Ordinance was approved by the Senate on March 18, 1963, and by the Legislative Assembly on April 5, 1963. Governor Sir Ralph Gray signed the bill into law, and on April 18, 1963, University of Guyana's inauguration was held on 1963, full stop. The University of Guyana's inauguration was held on October 1st, 1963, and classes started at UG on October 2nd, 1963. Once Cabinet approved the proposal for the establishment of a university on December 6, 1961, Dr. J. Gunn, then Premier, rolled out intensive communications with academics abroad to assist him in this needed project. A few examples of his letters and his efforts follow. On January 4th, 1962, Dr. J. Gunn wrote to Harold Drayton in Ghana requesting his assistance. On January 13th, 1962, Drayton responded that he would like to return to Guyana immediately, as the University of Ghana was willing to release him quicker by not applying the customary 3 months. On December 17, 1962, Dr. Jagan asked Horace Davis whether it would be possible to recruit lecturers in 23 fields. On January 2, 1963, Horace Davis replied by indicating that both Professor Alan McEwen and he would like to work in British Guyana, now Guyana. He believed that a 2 or 3 year budget would assist in attracting staff. On the question of the library, Davis advised that Jagan should establish a committee for staff recruitment, equipment, and building, and to appeal for entire libraries from deceased scholars or moribund institutions. On January 10, 1963, Dr. Jagan wrote to Professor Paul Barron of Stanford University, Professor Joan Robinson of Cambridge University, Professor Lancelot Hogben of Birmingham University, and Professor David Glass of the University of London. Dr. Jagan's letter was a request for assistance in staff recruitment. In this letter, Dr. Jagan also outlined the university's role. He suggested that the university should strive to develop the community through producing graduates for the civil service, teachers for high schools, and scientists and technologists for industrial and agricultural development. Dr. Jagan advocated too that the university should administer action-oriented research into Guyana's problems. On January 10, 1963, Dr. Jagan wrote to Felix Cummings in New York, asking him to mobilize funds for a library and lab equipment. Dr. Jagan also indicated that they were attempting to have Joan Robinson of Cambridge University as the first vice chancellor. You would be free to read what you think Burnham did. Can't read facts into history that don't exist. February 2nd, 1963, Lancelot Hogben replied, accepting the position of Vice Chancellor. On March 1st, 1963, Dr. Jagan thanked Hogben for accepting the Vice Chancellorship and invited him to make a preparatory visit on March 18, 1963. Professor Harold Drayton, first Deputy Vice Chancellor of UG in the University of Guyana Perspectives on the Early History, noted that in the months leading up to the university's inauguration, and especially in the first year of UG's life, many local and regional newspapers and some U.S. respectable journals frequently published items unfavorable to the proposed national university, referring to it disapprovingly as Jagan's night school. That might be the role you're looking for. And that it was a training ground for communist activists. Drayton also noticed in early 1963 that some senior education officers, in cahoots with the permanent secretary within the Ministry of Education, wrote disapprovingly of the proposed national university, and their paper was presented in tandem with the ministry's white paper on higher education to the Senate and the Legislative Assembly. This history was documented by Dr. Prim Mazir in a letter dated July 13, 2009 in the Kaichor News. These, Mr. Speaker, letters are all recorded in the historical documents leading up to the University of Guyana. As you can see, sir, and as Dr. Barry Ramsran, I don't see him here right now, is fond of saying, this University of Guyana started out with people referring to it as Jagan's Night School in the Queen's College compound. And it was nurtured and deliberately thought of and conscious effort went into making it a full University of Guyana. Mr. Speaker, the purpose of the University of Guyana is stated thus in the 1963 ordinance that established the University of Guyana, Ordinance number 6 of 1963. And it said in section 3, there shall be and there is hereby constituted and founded a university by the name and style, the University of Guyana. In section 4, the aims were outlined. The aims of the university are to provide a place of education, learning, and research of a standard required and expected of a university of the highest standard, and to secure the advancement of knowledge and the diffusion and extension of arts, sciences, and learning throughout British Guyana. Section 12 of that same ordinance established the board, which we now call the council. And it said that that board shall have power to do or provide for any act or thing in relation to the university which it considers necessary or expedient in its capacity as the governing body of the university, and the conferring of particular powers on the Board of Governors by other provisions of this ordinance shall not be taken to limit the generality of this section. In other words, the council is to manage the university. The Board of Governors at that point, 1963, at the beginning of the university, shall consist of the Chancellor and the Principal and Vice Chancellor, who shall be members of the Board of Governors by virtue of their office, not more than 2 persons to be nominated by the Academic Board when it shall have been constituted, not more than 2 persons to be nominated by the Guild of Graduates when it shall have been constituted, and not more than 2 persons appointed by the Council of Ministers, Cabinet. And then it went on to speak about how long the membership, the tenure of the members could be. So, Mr. Speaker, when this university first started, what was needed on this council were people who could get it up and running, and they were named. 2 persons from the cabinet, or named by the cabinet, the chancellor, the vice chancellor, and other persons whose role at that time was to get the university started to carry out the aims that were listed there. Over the years, that changed. And we are now here with Section 12 of the University of Guyana Act, Chapter 3902, that establishes the council, which was called the board in that initial ordinance. In that council, we had 26 members. I believe Your Honor was once a member and served on this council and would perhaps be most familiar or more familiar than most persons in here about the university and its runnings. The acting speaker, Mr. Siraj. Mr. Speaker, those 26 council members at the time that they were appointed were needed and named and acted, I believe, in the best interest of the university and worked for that time that they existed. In fact, what at that time was needed, or what we thought was needed as legislators, were more, it appeared, more persons from foreign universities to advise. I think our country has moved, and there have been several developments that both the world and our country here in Guyana have undergone that indicate a necessity to look again at who is running the country's main and sole, for this moment, university. And so we're seeking to amend this section that names the members of the councils to make it more inclusive, more expansive, so that we could give effect to Article 13 of our Constitution, which advises in writing Mr. Speaker, that in actual words, the principal objective of the political system of the state is to establish an inclusionary democracy by providing increasing opportunities for the participation of citizens and their organizations in the management and decision-making processes of the state, with particular emphasis on those areas of decision-making that directly affect their well-being. What that means, sir, is that wherever the state is making decisions or contributing significantly to making decisions, or wherever the state has a duty to ensure that good and wholesome and sensible decisions are made, we should engage as far as we can and as widely as we can from as many representative bodies as we can. And so what we're seeking to do here, Mr. Speaker, is to name more representative bodies to this council so that every single day the university will benefit from a wider variety of representative bodies, from a wider cross-section of the Guyanese public in the making of their everyday decisions with a view to serving the people of this country. And so, Mr. Speaker, we are seeking to amend the 26 members to 32 members. And this is how that amendment will happen. We have learned, sir, that since that ordinance and the amendments, that young people are to be seen and heard. The entire world has agreed that we've moved away from the adage that children and young people should be seen but not heard. And we now want to, as a world, hear from our young people so that they can influence the decisions that are being made on their behalf and participate actively and wholly in those decisions. And so, at section 12J, instead of 4 persons to be nominated by an NGO, who, in the opinion of the minister, are most representative of the interests of women, farmers, Amerindians, and business, we are adding in and youth. So we are removing and we are putting a semicolon at the, removing the semicolon, the period, and adding in youth. So that is an addition to the council, that we want youth representatives on the council so that we could hear from the young people of this country about how they believe the university can work to serve both the young people and the future generations of Guyana. We are also amending this section to include at section 12K, 1 person to be nominated by the Guyana Trade Union Congress, and we are seeking to amend it to say, and 1 person to be nominated by the FITUG. Mr. Speaker, in 2016, in the matter of the Trade Union Recognition Amendment Act 2009, between the Federation of Independent Trade Unions in Guyana, that is FITUG, as plaintiffs, and the Trade Union Recognition and Certification Board as defendants, and this is reported at 2016 High Court Demerara Civil number 82, the Honorable Mr. Justice Sandal Kissoon on the 13th day of, I agree, yeah, he made a good and sound judgment here, dated the 13th day of October 2017 and entered the 8th day of November 2017, ordered and declared, and this is how it's read, it is further ordered and declared that the plaintiffs, which would be the Federation of Independent Trade Unions of Guyana, are the most representative organization of workers in Guyana. With this judgment, sir, we thought it fit to include, not to remove the GTUC, whose membership, I know, include members of the opposition of this House, not membership whose executive membership includes opposition members of this House. We're not removing them. We are adding to them the most representative labor union in the country so that we could carry out and give effect to the Article 13 of the Constitution every time the council sits. In section 12, we are amending subparagraph 2L. It used to read 3 persons to be appointed by the minister, who in the minister's opinion can contribute significantly to the university in the field of medicine and law. And we're amending that to say 6 persons who in the opinion of the minister can contribute significantly to the university in the field of medicine and law, information and communication technology, that's ICT, environment and climate change, natural resources, and national defense and security. These speak for themselves, sir. In this era where COVID forced us and continues, it appears, to force the university, given complaints we've seen in the media, social and mainstream, to use ICT to deliver education. To have a specialist or someone sitting on that council to speak directly to the issue of information and communications technology speaks for itself. Environment and climate change. Mr. Speaker, Guyana is advancing its efforts on the SDGs, Sustainable Development Goals, for which the environment is a key goal. We're also the signatory to key UN conventions on biodiversity, climate change, and land degradation, and we're continuing to meet convention obligations. The LCDS, which was tabled in Parliament twice and approved, continues to be one of the most forward-thinking national strategies in relation to the environment, climate change, and low-carbon development. It has been recognized at the UN and sets out Guyana's priorities on the environment, natural resources, climate change, etc. to 2030. The university over the years, our university, has also been advancing its efforts in the areas of environment, from setting up an environmental studies unit in the early 1990s in the Faculty of Natural Sciences to today having a Faculty of Earth and Environmental Sciences and continuing to expand efforts. Also, Guyana continues to be a leader on payment for forest climate services, starting with our partnership with Norway and continuing today under the LCDS 2030, the voluntary carbon market with sale of our forest carbon to Hess Corp and continuing to advance work with new market opportunities. And of course, you know, we have named in Guyana the champion of the earth, whom you know as our Vice President and General Secretary, the Honorable Bharat Jagdeo. Mr. Speaker, given what I just read, what I just said, to name to the Council a representative from the ICT community, from the environment and climate change community, from the natural resources community seems obvious. To us, it is obvious. We also know, and we are fully aware of our continuing diplomacy with other countries dealing with national security defense and security issues. And we know that many of the officers coming out of the University of Guyana who work in different fields, who will have to advance this not only in the typical sense of national defense and security, but in our diplomatic circles, need to hear or need to be represented on that council, and the views of an expert, therefore, should be heard on the council whenever they meet. And so that seems fairly obvious to us, and that is one of the inclusions we seek to make. Thirdly, Mr. Speaker, in section 12(2)(m), the amendment that we seek to make here would be to remove 6 persons nominated by the Chancellor, of whom one shall be from each of the following. The association, it was 6 persons, the Association of Universities and Colleges of Canada, the American Association of State Colleges and Universities, the Committee for International Cooperation and Higher Education of the UK, and the University of the West Indies. Historically, Mr. Speaker, if you look at the various appointees, and we have had some remarkable chancellors who I think this entire House would be happy to thank for their service, and we have one right now, Mr. Green. If you look historically at the composition of the council, you will see, sir, that there were vacant many times, often, more often than not, vacant seats for at least 3 of these 6 nominees, these 6 spaces. So we're seeking to amend this to say 4 persons to be nominated by the Chancellor, of whom one shall be from each of the following: the Association of the Universities and Colleges of Canada, the American Association of State Colleges and Universities, the Committee for International Cooperation and Higher Education, and the University of the West Indies. But we also seek to add here, sir, a subparagraph N, 3 persons to be appointed by the Minister from nominations from the Christian, Muslim, and Hindu organizations. So let me read that from the order itself. 3 persons to be appointed by the Minister from persons nominated by the Christian, Muslim, and Hindu organizations. And therein, sir, lies the end of the amendment we seek to make. Again, I repeat, we had 26 persons serving on a council where the needs of Guyana, the realities of Guyana, were reflected in the membership of that council. We now have different realities in Guyana. We have discovered oil, we are benefiting from oil, we are in a different natural resources environment, we're in a different environment. Regarding the environment, we're in an entirely different place in our country, and we're seeking to put representatives on this, our only university, to reflect that, so that we could, the 1963 ordinance gave us what we needed at the time, and we have amended accordingly over the years to make that council what was needed for those years. And this is what we believe would be needed now. I want to specifically bring to the attention of the House, Mr. Speaker, that these persons, for example, the persons from the Christian, Muslim, and Hindu community, have to come as nominees from a representative organization. So the representative organization will have to name persons to this council in much the same way we do when we sit at the select committee for the committee in Parliament that names persons to various boards and the constitutional commissions. Additionally, Mr. Speaker, the persons who are to come and represent the interests of women, farmers, Amerindian business, and youth must come from NGOs. NGOs must nominate them. They're not persons that, while I believe I myself can do a fantastic job of naming decent and sensible people who can contribute to the council, I think we are sticking with good governance principles and saying they must come from representative bodies, large representative bodies, who can recommend persons who will give effect to Article 13 every time they sit on the UG Council. Mr. Speaker, I think I would like to end there, but it would be remiss of me to fail to recognize what has been put out into the public. And what has been put out into the public are statements from political parties suggesting all kinds of sinister motives, including that the government wants control of the University Council. That I explained very clearly for anyone who wants to pay attention why we're doing what we're doing. It is to make this council inclusive. Whenever the PPP Civic is in office, Mr. Speaker, you've seen repeatedly and consistently growth in education. You've seen repeatedly and consistently efforts to improve our country through the education sector, beginning in 1961, when that PPP minister put together a team, when this PPP minister put together, Mr. Nunes, put together a team to start the entire University of Guyana. And I didn't go on, but it's here for when I speak afterwards. I didn't go on about the resistance over the years, including, the resistance over the years to that university. But we could go through, Mr. Speaker, and I'd be happy to do it at now or after, our manifesto for 2020, when we went to the people of this country and invited them to give us their vote and place their confidence in us to develop this education system. And in that manifesto, Mr. Speaker, we specifically said that we were going to provide free education at the University of Guyana within 5 years, and that we were going to provide a pathway for debt write-off for students with outstanding student loans. And we've done that. In fact, the Minister of Finance announced not too long ago the pathway for the students who have to benefit from the debt write-off. And that pathway, sir, is if the student had to have graduated, and be living in Guyana, and they would benefit from the debt write-off. And we said within 5 years, we would be providing free education at the University of Guyana. The state, therefore, sir, the government, therefore, has an even bigger interest in making sure the university is run in a way that gives effect to the aims of the university. It has a duty, not a right. It's gone past the right. It now has a duty to make sure that the children who go there exit there in a way that can develop this country that gives effect to the aims of the university when we started. And Mr. Speaker, there are problems, and we can't pretend that there aren't. There are issues that have come to the public's attention. This morning, someone whom I do not know from the education faculty wrote me to say that she is waiting on grades since 2023, and she's frightened that she would not be able to graduate because they keep carrying it to different persons and they're not getting addressed. And I sent it to the Vice Chancellor, who, to her credit, as she always does, immediately responded to say she would look into it. But we keep getting those kinds of complaints. And you can't be a member of this House and in this country and say you do not know about those kinds of complaints. We see repeated complaints in the media, sir, about the university being online and not an in-person university. Those are issues people have, and they want their representatives to deal with it when they sit at meetings to deal with how this university is to be run. And we have not a right, again I speak of the duty we have, if we are to practice good governance, in making sure those voices are heard and represented, and that people are served in the way they want to be served. So very simply, sir, I cannot imagine which of these persons that we want, which of these bodies, which of these representatives the opposition would object to. So I would imagine that this is going to be a very short debate and that we'll be able to go home soon. Because I can't imagine, is it youth that they're going to object to? Is it to the religious bodies? Is it national defense and security? Is it FITO? Who is it the opposition can object to? We're not removing anyone from this council. We are adding persons to this council. We are adding persons to the council so that we have a more inclusive council that could offer more to the University of Guyana. With that, sir, I commend the passage of this motion at the right time.
Thank you very much, Honorable Minister. I now call on Honorable Member Ms. Coretta MacDonald to take the floor.
Thank you, Mr. Speaker. I rise to make known that the decision to bring this amendment to the House is very unfortunate, if not a gross dereliction of good governance duties. Sir, autocratic regimes are often nervous governments with authoritarian tendencies who are very paranoid. They always believe that if they give up an inch of control, it will be to the end of their domination. Sir, whenever we are faced with a situation where one ruler has absolute control and decision-making power in all matters of the state, we see the type of amendment that is currently before us. Mr. Speaker, the motion represents the pattern of real control freakism, which characterizes every government under the control of the PPP. Mr. Speaker, the motion seeks to affirm the University of Guyana Amendment Order number 43, which was gazetted on June 27, 2024. Pursuant to the orders ascribed to the Minister in Section 12(7) of the University of Guyana, this amendment represents an affirmation of the move to amend Section 12(2) of the Act. The order represents several impactful actions. One, it substitutes for the words 26 members, the words 32 members. In paragraph 1, by substituting the word 4, the word 5. By substituting for the words Amerindians and business, the words Amerindians, business, and youth. In paragraph 4K, the motion affirms the order to empower the Federation of Independent Trade Unions in Guyana to nominate one person. 5, places the sole power in the hands of the minister to appoint 6 persons at her whims and fancies, who the honorable member determines based on the instructions of the Central Executive of the People's Progressive Party. The order seeks to give effect to the arbitrary power, yet again, for the minister to appoint 3 persons nominated by the Christian, Muslim, and Hindu organizations. Mr. Speaker, we have learned over the decades and established a rule of thumb when it comes to the action of the PPP as exemplified by this motion. The devil is always in the details, like my good friend over there. And these actions are never born out of an interest in good governance or in national interests. This is another grab for total domination and control, and a further attempt to bring the University of Guyana under the political thumb of Freedom House. This is a blatant action to hijack the University Council. This has been the lifelong dream of the People's Progressive Party, and this is exactly what they're attempting to do now, and it will never happen. The University of Guyana has been under an assault from the second the government was installed in August of 2020. The People's Progressive Party sees the University of Guyana as the place that educates the youth and provides employment opportunities for those who have independent views, but they don't want that. They want that to end. We have just seen the latest action, Mr. Speaker, to undermine the university with the presentation of Budget 2024, where there was a $4 billion allocation to parallel tertiary operations under the direct control of the political directorate in the form of the Guyana Online Academy of Learning Goal. Mr. Speaker, there is little doubt in my mind and in the mind of dispassionate observers and citizens on the whole that this amendment is another step in the direction of undermining the University of Guyana. This act for domination, which has emerged straight from Freedom House and possibly decided at a PPP Central Exec meeting at maybe Rob Street. Sir, I will provide my assertion by providing context and a background on the matter to understand the intricate plot that is now afoot. And given the effect with the order, we must examine these attempts by the PPP, which began as early as 2015 and executed by the same minister who now heads this mission, which perhaps has been ordered at the highest levels. Political control of the University of Guyana has always been a main goal of this regime. And it did not begin with this order, and it will not end with this action. As early as 2012, the PPP waged fiscal war on the University of Guyana by allowing this university to run a deficit of $200 to $250 million annually. Mr. Speaker, lest we forget, it was this very regime that refused to sign the government of Guyana initiated World Bank loan of US $10 million for the University of Guyana Science and Technology Support Project. Mr. Speaker, the university had to fight tooth and nail to get access to that loan. This action, this history calls into question. Mr. Speaker, to make clear that the order is another stage of the evolution of the PPP's consistent, contentious relationship with the University of Guyana, we must examine the different reports that have sought to technically assess the University of Guyana over the years. These are the 5-year Development Plan, 1986, the Human Resource Training and Development IDB Program, 1991, the University of Guyana Academic Plan, 1990-1995, which was initiated in 1991, the Distance Education Department of the Institute of Adult and Continuing Education's 5-year Development Plan, 1995, the Presidential Commission of Inquiry into the University of Guyana with 40 recommendations, 1996, Trevor Hamilton and Associates Limited Conceptual Program for Improving the University of Guyana's Cost Effectiveness and Enhancement of its Relevance, 1996. National Report of Higher Education, UNESCO, 2002. SOAR, all of these reports presented ideas that would transform the university, but were discarded and allowed to gain cobweb because it did not seek to gain the only mission of the People's Progressive Party to ensure that all the key decisions of the union must be made in Rob Street and not at Turkine. Mr. Speaker, please allow me to delve into this credible case by drawing attention to the fact that in a time when the world is moving away from political control of universities and making higher education policies that make wholly independent universities, we have seen this amendment before us that goes in the opposite direction. In the case of Britain, there is no single public university. Sir, we in the coalition understand that universities have a singular opportunity and obligation to contribute to the development of society and the democracy, and to play an active role in shaping societies and strengthening the social contract. Therefore, the relationship between academic freedom, institutional autonomy, and democracy is critical, and it is a fundamental value for higher education system across the globe. Here it is no different for Guyana, and this amendment contradicts the letter and spirit of the aforementioned. Mr. Speaker, we stand against this amendment in its current form, and by extension, the order because the autonomy of the university is so valued and so real that nearly every suggestion for changing the act is an attack on the institution's autonomy, which the PPP hates with a passion. Mr. Speaker, if the minister has no interest in political control, the order should take the power away. Then the order should take the power away from her office and place that decision in an independent commission, or leave the current formula in place. You cannot tell this House that we must rely on the goodwill of the minister with the track record with which begets this administration. They only want control. Perhaps, Mr. Speaker, we might see a different course of action if the government educates itself on the concept and importance of the autonomy of institutions of higher learning. Mr. Speaker, the notion of institutional autonomy can be traced back a few hundred years with the evolution of modern states, where there was an increasing need to demarcate the roles of the state, the church, and the learning institutions. This demarcation was necessary because the growing tensions between the state and universities and their influence over society. This tension also helped to shape the debates and philosophies on institutional autonomy. Mr. Speaker, I cannot believe that we are here to debate an amendment that takes us back to a time when there was concern about the influence of universities over society. Further, Mr. Speaker, at this time in our history, we should be here dealing with legislations that speak to a tertiary education policy in relation to our oil and gas development. We should be positioning our education system to adjust to the trajectory of our development. Instead, we are here to amend an act to increase government's control and to decrease academic autonomy. Sir, I hereby point to the concept paper for the amendment of a CARICOM strategic plan for tertiary education services in the CARICOM single market economy by Professor Tiwari. And on page 11, he stated, and I quote, "A review of the legislation concerning education in general and tertiary education in particular in the Caribbean reveals two interesting phenomena. The first is that many of the education acts are outdated, going back to the 70s, 80s, and 90s, when given the significant development that have taken place in education regionally as well as internationally over the last 20 years. Regional legislation, especially related to tertiary and higher education, needs to be revived, reviewed, rewritten, harmonized, and integrated to support the evolution of a seamless tertiary sector across the region. End of quote. Mr. Speaker, we should heed this wise counsel and have a revolutionary overhaul of higher education policies and the revision of all legislation connected to education in this new oil and gas economy. Sadly, this is not within the interest of this government. They have opted now to politicize the University of Guyana. Make no mistake, Mr. Speaker, this is what it's all about. Mr. Speaker, the People's Progressive Party, they want to have control. They want to be in control in who is in authority at the University of Guyana so that they can direct them at their will. They want to decide who control the faculties. They want to control who lectures to the student and what political messages are filtered in the classroom. This, again, is all about control freakism. Mr. Speaker, this is the reality. And if the government wants to prove me wrong, they should withdraw the order and scrap the motion. Mr. Speaker, I must caution the folks on that side of the House that politicization of tertiary education is dangerous business. Mr. Speaker, the literature tells us that politicization of education comes with serious consequences for the average country. It results in a difficulty in research, a difficulty to reach consensus on important educational policies and reforms, as the focus may shift towards political agendas rather than the best interests of students and educators. Frequent changes in educational policies and priorities because of political influences. When the education is politicized, policies may be revised or overturned depending on the changing political landscape, making it difficult for the education process. The distortion of facts, research, and evidence-based practices, policies, and curriculum decisions may be influenced by political ideologies rather than objective analysis and research. This will have a negative impact on the quality and accuracy of educational content and may compromise the learning outcomes of our students. Sir, the politicization of the tertiary education system kills academic freedom and stifles innovation. We do not need this at this time in Guyana's history. Sir, the politicization at the level of the University of Guyana can limit the autonomy of academic leaders and infringe upon academic freedom. Heads of departments and faculties and lecturers may face pressure to align their teachings with specific political beliefs or face consequences for presenting diverse. Mr. Speaker, diverse perspective and critical thinking skills in the lecture halls and the lecture theaters. Whether it is in the stables or the GWLT, UG must remain free of everyday husking of Guyanese politics. This amendment themes with the possibility to curtail the creativity and effectiveness of the university teaching and hinders the development of well-rounded individuals that cannot contribute to the development of the oil and gas economy. Mr. Speaker, when education becomes highly politicized, it can erode public trust in the educational system. People may question the motives behind the policies and decisions, leading to the loss of confidence in educational institutions and their ability to provide objective and quality education. In this case, the people are observing the government's approach to UG. Sir, the Council of Europe Parliamentary Assembly warned about the threats to academic freedom and autonomy of higher educational institutions, and in doing so, the august body stated, and I quote, national parliaments and international parliamentary bodies have also have a role to play in identifying relative increases or decreases in respect for academic freedom among state partners and performing a framework for regular evaluation. Dialogue and reform. Dialogue and reform the Assembly. Dialogue and reform. The Assembly calls on national MPs and relative parliamentary committees of its member states to remain vigilant as regards to significant deficiencies or decreases in respect of universities' values, and to undertake inquiries into the causes and to develop appropriate policy remedies when necessary. End of quote. This is the duty, Mr. Speaker, that calls us today in this Assembly. Mr. Speaker, what we are contending can be seen in every action which this order seeks to effectuate. It will substitute for the words 26 members, the words 32 members. What we note, sir, is that when the University of Guyana Act came into force in April of 1963, it's embedded in our Constitution the legal arrangement for there to be a reasonable level of autonomy to the university. Once this amendment is passed, then that level of academic influence will be gone, and the political domination comes in with the expansion of 32 members. Sir, this is how governments begin to exercise their domination. Importantly, sir, the order seeks to substitute for the words Amerindians and businesses, the words Amerindians, business, and youth. On the face of it all, sir, one may want to wage war against this aspect of the amendment. One might be tempted to applaud the inclusion of youth on the university decision-making board. After all, it is the coalition that has consistently championed the cause of youth empowerment. We have consistently argued for meaningful youth representation. We are fully aware that even when youths are given opportunities to participate in formal government bodies, the positions are often non-voted. So there's no way to know if they have any influence. Make no mistake, Mr. Speaker, we believe that youth participation can fulfill young people's quest for purpose, self-worth, and belonging. When youths contribute towards decision-making for the communities or a university, it instills deeper bonds between youth and their community and institutions such as the university, and establishes them as valuable leaders. Sir, we know that youth participation can influence awareness, can increase awarenesses of the challenges that others in their communities face, along with a sense of duty of identity to identify solutions which can improve their surroundings. However, sir, we do not believe the methodology for this amendment will give effect to the aforementioned principles. The minister will simply select a youth that is a political lackey to execute their instructions of the government, of the people. This defeats the purpose of youthful representation. For the record, Mr. Speaker, we are not against any legislation that calls for representation of Amerindians and youth. We disagree with the methodology. If you want to empower these groups, take politics out of the equation and let the legitimate youth organizations or groups and authentic organizations select the representatives, not the minister, whenever she feels. This amendment should include language that compels the minister to consult with organic youth organization before the selection is made. Sir, what the government has done here is to look at the act and is seeking to see how they could cleverly pack the council with their own lackeys to gain control. I have no doubt, Mr. Speaker, the government selected this change to accuse those who oppose the change to be against the inclusion of youth. Let me restate, we have no issue with youth representation being enshrined in this act. We are concerned about the method of the selecting of representation. Sir, in paragraph K, the amendment affirms the order to empower the Federation of Independent Trade Unions of Guyana to nominate one person. If there was any doubt about this order being a naked attempt to hijack the council, this aspect of the amendment erases all doubt. Sir, I can speak to this act with some authority. I have been in the husking of trade unionism in Guyana for the longest while. What the government has done with its use of FITUG is a scandal of gigantic proportions. This organization has been a front of the People's Progressive Party, with all of its actions in complete lockstep with the government. There is no chance that this organization will nominate someone who is interested in things academic. As a result, the PPP government, through this expanded UG Council of 32, will now have full control over such matters as the appointments of the Vice Chancellor, Deputy Vice Chancellors, and academic staff, as well as over the planning of budgets and financial expenditure of the university. As I've explained, Mr. Speaker, this is dangerous business. Sir, we have seen over the years the modus operandi of this government. They have consistently demonstrated that they are more interested in political domination than the technical aspects of the operations of state apparatus. Sir, the PPP is committed to the maxim of you will have your say and we will have our way. Therefore, they will use their majority to pass this amendment, regardless of how much we on this side of the House oppose some, even with the recommendations we proffer. Mr. Speaker, however, this government is in trouble and the writing is on the wall. Mr. Speaker, I must ask, was any consultation done with the University of Guyana? Or if there were, did the Honorable Minister heed the advice given? Mr. Speaker, there will be a change and it's imminent. We would like to go on record with our vision for the university. That is, we will review the impact of these amendments and restore academic autonomy. We will restore the University of Guyana to being an independent body. We will make the University of Guyana one of the best centers of knowledge in this region. We will thus substantially increase funding to the university with a focus on promoting applied research and teaching and enhancing the physical aspects and other critical elements of the faculty and student life. Mr. Speaker, this control freakism will lead us to exactly what we saw a couple of days ago with the announcement of the national grade 6 assessment exams, where confusion and panic reigned. Wrong scores, right slips, incorrect addition. Mr. Speaker, the confusion that has been brought along with schools that have been governed by boards, this is where we want to take the university. And in so doing, Mr. Speaker, this motion that is before us, this amendment that is before us, we will not accept it in this manner. I thank you.
Thank you, Honorable Member. We will now give the floor to the Honorable Minister of Youth, Sports and Culture, Mr. Ramson.
Thank you very much, Mr. Speaker. And therein lies the reason why the GTU lost their fight with the government. Because she lacks credibility. The Honorable Member, Coretta MacDonald, lacks credibility. They come here, as they usually do, and feign as if they care for people in this country. Because when they had the chance to do something about the University of Guyana, what did they do? Absolutely nothing. In fact, they made it worse. During the time that the APNU AFC was in government, what happened to fees? What happened to fees at the University of Guyana? It went up by 18%, despite the fact that during their campaign, David Granger himself, before he became president, he said he would guarantee a job for a graduate within 18 months. 18 months of graduation. And then when he became president, when he was asked about the jobs, his response was to go and sell cocoa rice and guava jam and pepper sauce and plantain chips. That is the record. So much they care, and they cared about education, and they feign with this pretensive attitude about caring for people. There are two words that should never be mentioned. Two words should never be mentioned from the APNU AFC. Is one, democracy. That's the first word, democracy. And number two, youth. That's the next word that should be never mentioned by the APNU AFC. Their first action, and the reason why I'm dealing with it in this way is because it is hypocritical. They destroyed all of you young politicians. Your political leaders destroyed you. Destroyed your political careers. Christopher Jones, James Bond, Trevor Williams, Sherrod, Malika Ramsey, a number of the young political leaders, even Jorman Figueroa, never gave you an opportunity to be part of the camp.
Mr. Speaker. Thank you, Mr. Speaker. Mr. Speaker, I rise on a point of order. The Honourable Minister is making reference to members of this House without addressing them properly. I'll appreciate if he can give regards and respect to them by the designation as Honourable Member.
Thank you.
Persons who are not, sir, within this dome are being also referenced, and I think the substantive speaker ruled on us not imputing, especially on members not a part of this House.
Thank you, Honourable Member. Honourable Minister, you know the right thing. Go ahead, please.
I wish that they had regard for you and your young members in the opposition now when you were in power. I wish they had regard for you. I wish they gave you an opportunity to be in the seat of this House, in this honourable House. I wish they gave you an opportunity to sit in the cabinet. I wish they gave you the opportunity. So when you had the first opportunity to go and rep for young people to have a say, what was it that the government did, the APNU AFC government did when they came to...
Mr. Speaker. Mr. Speaker.
Honourable Member, Ms. Ferguson, you're rising on a point of order.
None of y'all ain't gonna break my stride. It's coming at you. It's coming at you. I want you to come. I don't care. I don't care. You can come from now until tomorrow.
Honourable members, let's allow Ms.
Thank you very much.
Ms. Ferguson, you're rising on a point of order.
Yes. Good morning, Mr. Speaker. I'm rising On a point of order, standing order 40A. And may I quote for you, sir? By rising on a point of order, when the member speaking shall resume his or her seat, and the member interrupting shall simply direct attention to the point which he or she desires to bring to notice and submit it to the speaker or chairman for a decision. Mr. Chair, Mr. Speaker, sorry. The honorable member stated earlier that the former president, who is not here to represent himself, Mr. Granger, promised jobs to young people. So,
that's a public statement.
Mr. Chair, I have found the quote and what the honorable member alluded to earlier. No way have I picked it up in a public document that was.
There must be a time limit to these points of orders.
That was carried by Demerara Wave on the 9th of April 2017. The headline states, sir, I will do everything possible to help you to get jobs, Granger tells youth. And if I may quote him directly, I will do everything possible to help you to get jobs, but you must also want to help yourselves.
This has to come to an end.
He was quoted as saying in a statement issued by the Ministry of the Presidency. So, Mr. Speaker.
Honorable member, you've made your point. I think the honorable minister was alluding to what the former president said without directly quoting him. He
has to be factual because I'm quoting from a public.
Yeah, I didn't quote
the honorable minister.
Where you quoting from?
Honorable member, the minister was not quoting what the former president said. Honourable member, your time will be given back to you. Please proceed.
Thank you very much. Thank you very much, Mr. Speaker. And when the APNU AFC came to government, besides the fact that they did not appoint any young people as ministers and members of the cabinet, I'm not even sure if any of you who are here were members of the cabinet, but leave that to one side. Here is what I know. The first action that they did, they removed completely the Ministry of Culture, Youth and Sport. They removed it completely. They removed the voice of young people at the level of the cabinet. The one word, and when you were campaigning, you used young people. APNU AFC used young people. That's why so many young people in this country were so disappointed. Because you worked them, and you fooled them. And when you came into office, even if you only did an appointment, you failed on that. The average age of the government of Guyana, the cabinet of Guyana, was 68 years old. 68 years old. On the street, people used to call for the abbreviation of government of Guyana, government of geriatrics. Government of geriatrics. And that is why none of those young people, because they didn't get an opportunity to be a minister or a PS while they were in government, that's why they're still reeling from that situation. And some of them, now that they've lost their seat on the central executive, that is the end of their political career. That is the end of their political career. And I see the honorable member Annette Ferguson wanting to defend Mr. Granger. Mr. Granger couldn't even save you just now from getting into the central executive. So, and let me tell you something else. Let me tell you something else too. It is the leader of the opposition. It is the leader of the opposition who is going to make proposals for a recall. It is the leader of the opposition. So just be clear about that. And as we are on the subject of this matter, one would think that the expansion of supervision at the University of Guyana and governance would be something that you should support, especially when government is about to make significant investments into the University of Guyana. That would be something that everybody as a taxpayer, all of you are taxpayers, everybody would want to see that there's more supervision. I'll ask you one question. Since you are afraid or totally against this, I will ask you one question. Are you satisfied with the condition and the performance of the University of Guyana? And if your answer is yes, then I will ask you to go and talk to the university students. Go and talk to the university students. All of the university students will answer in the negative. They will answer in the negative that they are not satisfied with the performance. Let me tell you what transpires there. Lecturers, some lecturers or some classes are not scheduled until very late in the day, till sometimes 7 o'clock at night, when during the day there are no classes scheduled. A lot of the students are going up there, and when they're up there during the day, they play cards, running rap romy. That's what they're doing up there. Now, I've been to quality universities all around the world, and I'm extremely proud of quality universities. And when the government of Guyana is going to make important and big investments that is part of a holistic approach for the transformation of the education sector in the country, it is important that the expanded governance arrangement as well as the oversight is there. In fact, as taxpayers, all taxpayers in this country would want that. And government has a responsibility to ensure and be aware and to know about the accountability of government funds. It's government funds. And we have to respond. In addition to that, when those young people come to us and talk to us about those very same conditions at the University of Guyana, which you are not proud about, you could never be proud about, we as government, we have to respond. And it's not just about doling out money. It's about how money is spent. No one can ever, let's do a comparison quickly. How can you, if you were to compare the University of Guyana's performance versus our regional brothers and sisters, and you can examine where those universities rank in comparison, and what are the facilities that they have, and the experience that they have. And there's a reason. And I can prove to you that the young people in this country are voting with their feet. Look at the public service, the Gold Scholarship. Over 20,000, in fact now it's over 20, almost 30,000 young people have gone on that Gold Scholarship and benefited from that Gold Scholarship. You know why? Because they're voting with their feet. They've made a choice. And none of your points and shouting and heckling is going to change that fact. And I refuse to accept this crocodile type of caring that you're coming in here and feigning caring. You only care when you're in opposition. You only fake caring when you're in opposition, because in this very same legislation, if you check the act, what proposals are what amendments were made. What amendments were made in the APNU AFC's 5 years in government? What amendments were made to the legislation? Zero. Zero. Nothing came to this house to help to transform the governance arrangement of the University of Guyana or to do anything that is supportive. Now let's deal with the statement. Let's deal with the statement coming out from Congress Place. I want to make reference to one particular point. This is what they said. A PNCR government, not APNU AFC government, a PNCR government, not an APNU AFC government. We are very clear about the intent of that statement. And it's not worth, trust me, it's not worrying me at all. In fact, we have never been more excited. This is what they said. So I noted very carefully that they have now severed their reference to any APNU AFC potential government, right? Potential. They have now realized that the AFC is just dead weights. Dead weights. And to be honest, they were riding the PNC for a very long time in that last 5 years, so congratulations. You guys gave them more than they deserved. More than they deserved. And when you go alone in the next election, you'll see how many seats you get. You'll be destroyed. Now, here's what it said. Will a PNCR government will reverse the impact of these amendments. They will reverse the impact. They won't reverse the amendment. They will not reverse the amendment. They said that they will reverse the impact of the amendments. If they were so against these amendments, they would have simply said that they will reverse the amendment. What did they say? They will reverse the impact of the amendment. So then, let's examine very carefully the amendments that they are against, or what impact it can create. What impact it can create. Because let's understand the investment that we have made in the last few years. We moved our education sector budget from $62 billion to $135 billion. We have commenced the construction of scores of schools all across this country in areas that hitherto never had schools before. Never had schools before. In areas that the APNU AFC, while in government, knew that there was a deficit and decided not to even construct one. So that investment and that transformation, which is happening in all across the country, in every sector, that transformation is happening all across the country. That transformation must now happen in the education sector, of which higher learning and the University of Guyana is an important part of that. Education is now a universally accepted concept, that it is a government service that should be provided. But higher education in particular, is one of the main strengths of a modern economy. And a modern economy is more sophisticated, it's more complex, and that complexity requires the University of Guyana to respond. Imagine in the sports sector, for example. I just want to use this one example to show you how anachronistic it is. If there is not even a kinesiology program at the University of Guyana, some of you may not know what the kinesiology program is. Some of you may not know what the kinesiology program is, but if you cannot have a modern sports sector, if you don't have a kinesiology program at your university, that doesn't exist. So I'm saying that transformation which is happening across all of the sectors that are being transformed before our eyes, that must also happen in the education sector, of which the University of Guyana has an important role to play, especially because of its ability to deliver higher education in the knowledge-based economy. So I want to let everybody know, both in this house and across this country, that there has not been the transformation that was necessary to see at the University of Guyana, which must happen now. Government intends. We have just put $11 billion into the student loan relief program. We've just put $11 billion. Now, it's not just taxpayers' money. It's not just taxpayers' money. It's Guyana's money. It's not just taxpayers' money. It's Guyana's money. Now, and in this situation, it's government's money that we're putting towards that, because we make the decision about where and how much it's going to go. So, because we are making significant investments into the University of Guyana, that oversight, as well as increased governance arrangement, must also now be equally important. In fact, it is the responsible thing to do as a government. It is the responsible thing to do as the government. So, I want to conclude by saying that this order, which is here for an affirmative resolution, it is going to be supported wholeheartedly by this side of the House. I'm confident also that all of the members on your side of the House, if you intend to call a division, that they will not vote in favor of this, because some of them might be sleeping. 3/4 of your entire opposition here, 3/4 of your entire opposition are not even here. You love the University of Guyana so much. You care about higher education and the University of Guyana and this order so much that 3/4 of you are absent. They couldn't be bothered to be here, just like you couldn't be bothered to support young people while you were in government. This order will receive full support from the government of Guyana. The University of Guyana will get the investment that it is needed. University education will become free before the conclusion of this 5-year period, and tens of thousands of young Guyanese will benefit from that, and it will help to transform this country, our country, the country that we all love so much. All of us will benefit from that higher learning and the investment that we are making. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Minister. Honorable Member, Mr. Duncan.
Article 4 million.
Thank you very much, Mr. Speaker. All protocols having been observed, I'm privileged to stand on behalf of not only my party but the parliamentary opposition and lend my voice to this order, especially as it concerns the University of Guyana. You know, I know our parliamentary colleague, Minister of Youth and Sports, Charles, is very fond of quotations. And there is one that says, until the lions have their own historians, the tale of the hunt will always glorify the hunter. And there's another one by Plato. I know he has a fondness for quotations. Plato says that all of you will then be chosen for a higher privilege, and the studies that you pursue without order in the early years will be brought together, and you will see the relationship to those studies and to one another and to truth. I know higher education isn't your forte, MP Hamilton, so you mightn't grasp it. But I learned this sitting in the classrooms at the University of Guyana. I learned it there. Right? I don't wish to know anything about you either. I do not wish to know anything about you. But I have a particular love for the University of Guyana. And I want to say very early to all the members who are here that we have to keep politics out of the University of Guyana. We are trampling on very, very dangerous grounds here. And I'll tell you why. I'll tell you why. I have had the great privilege. I know Charles talked about MP, our colleague, talked about foreign university, and I don't knock them. If you have the privilege of going to a foreign university, take the opportunity. I have nothing against that. But people who stay and contribute to our university, there is value there too. People who go to UG, there must be value there as well. I had the great privilege of doing industrial relations and management through IDC, that's the Institute of Distance and Continuing Education. I had a great privilege. And in that program, I met Professor Bishop, who was former Chancellor. I met Mr. Timothy Jonas in that program lecturing there. I met some good folks, not going after the money because they were never remunerated appropriately, but just have a passion for serving their nation. I had the privilege as well studying communication studies. So what we do on a daily basis, bringing valid and credible information, is not a fluke. It's theory meeting practice at the University of Guyana. In my first year as a communication undergraduate, I had Dr. Forsyth as a first-year student. I had Dr. Paloma Mohammed as a first-year student. We don't have a lot of doctors teaching our first-year students now because we don't attract that kind of talent because of the cost of attracting that kind of talent. Don't let us politicize UG. And after I graduated communication studies, I pursued law after that. And we had some great people in the law faculty as well. We lost Sheldon McDonald very early during that tenure, who was my head of department doing law. We lost Calvin Eversley, who was Harvard trained during my years doing law. We lost as well a gentleman who taught in the health sciences. He did medical ethics or something like that with us. We had it rough in those years. We had former Chancellor Short petite fella? Messiah, Keith Messiah, Eversley. We had former CCJ Justice Pollard. These were people who didn't go after the money. We had Kim Kite John as well. They were there providing service. So I say that to underscore, while I do not knock foreign universities as well, there is some value in the University of Ghana. I want to start there. And I want to compliment again the Minister of Education, Priya Manik Chan, one of the better persons, I think, in the PPP. Minister Manik Chan, you must take people like Charles under your wing, MP, and bring him up, because he's wild. Wild like buckbead. And to have longevity. Minister Manik Chan knows this. You need range in politics. Charles got one gear, MP Charles Ramson, the honorable member, he got one gear, is fifth gear. And if you drive the car in fifth gear out, you can burn it. Give the honorable member Manik Chan her due. She got range. She could give a feral blast and then she could come down. But you can only do that if you submit yourself to some tutelage in this thing called politics. So Charles got to humble himself. You know it all. You know all the Plato and all the Shakespeare. You don't know UG. And not only have I had the privilege of contributing, of UG contributing to my life, I have had the great privilege of running for student government, testing your ideas very early, and not just running, winning as well. And I want to recognize, I don't want to draw him into the debate because that's not what we do here. But I want to recognize the current UJSS president is in the house here. And his own efforts have been following it from afar. And I want to recognize former president as well, Ganesh Mahipal. We didn't represent no political parties there. I ran against Ganesh, who was in Student Factor. I ran against Jurita. Jurita was in the Economic Students Party. What was the name of it? USA, United Students something. We ran against each other on the campus, and we didn't know our fates were going to be intertwined. I never see Priya in a political party at UG, but she still make it here. I definitely didn't see Charles in there. I didn't see Hamilton or Kwame or so on. But we tested ourselves. And you know, if you've been to UG, if you could make it in GWLT, on that stage there, you could make it in the well of the National Assembly because you had to come with something. People didn't take you by face value what party you belong to. But you had to bring something to the floor. And we challenge the administration of our day. There's something that is called progress. So we didn't build 50 schools, but it is called progress. Maybe we didn't have oil money to build 50 schools. We didn't institutionalize paid tuition education, and we didn't have oil. We did not have oil. And in 1992, when the People's Progressive Party came in, they met a free education system, and they introduced tuition. 1992. Yeah. I'm saying it's caught up in the whole tenure there. We did not introduce free tuition education. So if you come now and you are providing and promising free education, you're just correcting your own course. You're not doing the students of this country a favor. You are putting things back as you found them. And you're now finding value in free education. And we did not have oil. And so I wanted to say, as I begin, that the growth of the university belongs to Chedi, it belongs to Forbes, depending on who you ask. What is clear is that the life of the University of Guyana is inextricably bound up in the life of this nation. And we can't run away from that. Right? We just can't. As I said, we subsidized fully, the government of the day, post-92, subsidized completely the education for students. And you folks, somebody pays for it. So it was subsidized fully. Then we come to this order. Now, when Charles speaks so passionately, again, it is from afar off. I had the privilege of sitting on the student council of the University of Guyana. I had the privilege, I know our honorable colleague, comrade Miss MacDonald, she stopped the history of some of the transformation taking place in UG in the early 2000s. But I was there with former Chancellor Carrington from Trinidad. And he had a strategic plan that he started working through. I sat through almost every one of those planning sessions with the private sector. You know what I found? It was always poorly attended by the government of the day, if at all. And then in government again, the PPP comes to say they're interested in UG more than you. But I have been there with Professor, what's his first name? Dr. Carrington. Lawrence Carrington, tall Trinidadian fellow. In those sessions, I didn't see PPP pouring through the doors to come and to play a part in moving the university forward. So to stand here this evening and say that you love the university more than anybody else is hypocritical. And I want to circle back to what I started talking about with progress.
Honourable member, I would like you to find a substitute for that word. It's deemed unparliamentary, hypocritical.
Two-faced, two-mouthed. I want to circle back to progress. When I was a first-year student at UG, there were long lines from the registry, wrapped around the building, going out of the campus. You had to go and submit a paper form. Right? The PPP did not change that to a computerized system. That was pressure from UGSS. Right? Shut down the campus. And I come into that, shutting down the campus. That was the university becoming progressive in its thinking that started us on a course of reforming some of the structures at UG. I was a student at UG when you sat in GWLT and fan yourself, fetch chairs into GWLT. Huh? This was under the PPP. No Wi-Fi. Today, because of progress that started under the last, hold on, I'm coming to the tables. That started under the last administration. GWLT is air-conditioned now. But Charles hasn't been back in a long time, so he won't know. I went open day this year. I didn't see anybody from the PPP there. I walked every faculty. I didn't see anybody from the PPP at open day. There is where it matters. But that is what you call progress. The stables is a metaphor in and of itself. In and of itself. My first day doing law, criminal law, Miss Amsterdam, fantastic woman, short in stature, big in big in brains, drilled into you, the mens rea, the actus rea, and a whole host of other things. Why you all are doing law? She asked each of us, oh, I want to be a humanitarian lawyer. I want to be a this, I want to be a that. The hands went up around the class. I was a poor little paggy boy from South, coming out of Ishmael, didn't know all these big things. Just had a little beating in my heart to press forward. Mother's a nurse, paid for my education at the University of Ghana. Look, let me talk this story. When we were having protests on campus, Dawes and Saddam would always ask, I thought y'all want to be human rights lawyers. How come y'all are out there? It was always a couple of us, as per normal, at the front in the fight for betterment at the University of Guyana. But you could have never engaged the PPP on that betterment. They didn't want to hear about that betterment, and they would wait you out. Let me see how long y'all could go there march. Let me see how long y'all could be absent from your class. 1 week, 2 weeks. And it's not only students. Lecturers had varying protests on that campus. Oh, I come into Freddie, hold on. Right? I know some of the union leaders so well. Mr. Haynes, because you lend support with them. Dr. Francis, because I didn't see PPP people there in the struggle when those people were asking for betterment. Under their man, Dr. Upadei, who supervised a certain PhD and now get a big work at goal. He get the brown bag. Now he won't come back and take over UG under the table. I've been there like talk. Right?
Mr. Speaker.
Honourable Minister, you're rising on a point of order.
The honourable member just called Professor Obadei's name, as well as to impute that he collected a brown bag. Right? So those are things that should never remain on the record, and he should withdraw that. And he knows better too. He knows better.
Thank you, Honourable Minister. Honourable Member, you're reminded that you should not be mentioning names of persons who are not in the assembly, and do the right thing.
Professor Upadei, thank you very much, Mr. Speaker, was always reluctant to meet with the staff, always reluctant to meet with the students, and we understand why now. Because the friends, family, and favorites started under him. Because I remember when UG was to get a particular contract for a particular high court software, and he got it personally. That is fact, that's out there. So it started, we were there. But I want to come back to the Honorable Minister's order. Because we have said, and I think the next Minister of Education has articulated this, and I don't want to go back and tread the territory, about the pitfalls, about the control freakism that comes with increasing these numbers, that puts the government squarely in control, because we have already had foreshadowings of this in the past. When Freddie had its sanity and wrote in 2020 that seminal paper, the Honorable Gentleman Freddie wrote a seminal paper on racism, the PPP, and all of that. And Freddie, in that university setting, was hounded by the PPP and his acolytes. And they were responsible for his dismissal from the University of Guyana. Freddie took that matter to an ombudsman who confirmed that. And imagine if they did not have total control as yet. It comes now to what the Honorable Member Greta McDonald says. They can want to dictate who get an honorary PhD. They can now want to get one from a proper university because they got one from a no-name unaccredited one. Which friend and family gets into what programs or who don't get in to the program? Which lecturer saying too much publicly and must be dismissed from the university? This has already happened in the past when people were bowing to pressure. And this is where they're coming to again. The PPP wants to exercise control freakism over the University of Guyana. And there has been tremendous uncertainty and vacillations as they pursue this. The PPP loves UG. UG has an online program that has started a little while now. It's ahead of goal. And the PPP loves UG so much, they create a parallel online program, rivaling UG in the budget for the program. And they love UG so much. This love looks strange. Strange love. The budget for the online program rivaling the entire university. And I've been talking predominantly about Turkine campus. I ain't touched Tain and John as yet. But not only did they create goal, Guyana Online Academy of Learning. And I saw the Honorable Member Manik Chan made the allusion to one student calling her this morning, using that as a justification to change the composition of the entire council. Goal has had its own issues as well. People went to classes. The folks said they're not registered in that course, that university. It started late. You got some degree programs for 2.5 years. All manner of things. A lot of complaints has come. Now, if Goal and UG got a budget rivaling each other, who is the council for Goal? Who makes up the council for Goal? Who is the council for Goal? Huh? Who is the council? Who is the governing body? What are their statutes? And Goal budget rivaling UG. And the Honorable Member, Mr. Ramson says, because of these investments, they need more people. Well, I rather assume they can make some more investments in Goal as well. But how come Goal is so secretive? Like the administration of men on a mission. You don't know. Who are these people? UG, the government says they love UG more than the rest of us. As I said earlier on, I was a student of the Center for Communication Studies and graduated. I didn't waste time. I said 50 more because we didn't just drop it. We come through. Went through that program. And we mentioned the stables earlier. I want to connect the two. I was sitting in a class. I won't call the lecturer's name because you can figure this thing bias and so on. But I think it's a lecturer on your side, but I won't call it name. Fantastic woman. She used to work in the judiciary. That's as much as I say. One day in one of the law classes, we were talking about the stables. I can't remember how the conversation came up. And she said to me something I've never forgotten. She said the stables is an example of when the stable was constructed to last about 10 years in the building of the university. It lasted about 40. She said the stables is an example of when you settle for less, temporary becomes permanent. And that is emblematic, symptomatic, idiomatic of the PPP, because the Guyanese people have settled for less with them, and temporary must not become permanent. They never sought in the 23 years they had the University of Ghana to change the stables. The complexion of the stables I knew when I was a student has changed. The same council. The stables is what happens when you settle for less, she told us. Temporary becomes permanent. I didn't forget that. So UG had the Center for Communication Studies that was housed in a building that looked like the stables. But it was a Center for Communication Studies. We had Paloma as the director, Forsyth, as I said in my early years, Bram and Nelson, people committed to a process. The government so loved UG. They went and started their own communication center in the Media and Communication Academy. They couldn't bring journalists through the Communication Center of the University of Ghana. Bring those resources through the University of Guyana. They went and create the Parallel Center. But Minister Manik Chan will argue with you, right, that UG is the brainchild of Cherry Jagan. Well, Cherry must be turning in his grave when he see what you all have done to his vision and his dreams. And then I want to come to the final thing as I wrap up. When I was a student doing law, one of the struggles we had is that law students were only allowed into UE, St. Augustine campus, whatever the name of the place is called, 25. But we were producing hundreds of students. It was cheaper, and still is cheaper for people from the different Caribbean countries to study here. And so they pour in. Right? I don't want to misquote the AG. Right? But we engage the government of Guyana of the day. I wrote countless letters in the newspapers on why Guyana needed its own law school. And every one of my engagements with the AG met a wall that says, we had too many lawyers, we didn't need more. And then suddenly an about face with the championing of this law school. They were dead set, we didn't need that. We had too many lawyers. All the letters I wrote to the papers are there. Letters to the editor. One issue after the next. As a matter of fact, we went as far in the Law Society putting together a symposium on a local law school. I'll give you the time frame. You know who we had visiting at that time? In a commission of inquiry, we had the then chairman of the CLE, what is it called? The Legal Education Body. The Legal Education Council. Was a woman. Can't remember her name now. But she was part of that commission of inquiry. We invited her to that symposium on why we needed a local law school. I think the former chancellor, one of the former chancellors came, and some other persons came. Nobody from the PPP showed up. Nobody from the PPP showed up. But they love UG. And I'll end with this, I'll connect the dots. When we were doing that simple program, that simple symposium on the need for local law school, a mother reached out to me, much like the student reached out to the Honorable Member Priya Manik Chan. The mother said, I have a daughter, she's doing law. Should I bring her? I said, bring her. And after the mother brought her, the symposium came to an end, she introduced us, we took a photograph. That young lady, the short of the story, ended up being my lawyer on a matter quite recently. That is how we came full circle. Ended up being, I'm saying...
Honourable member, you'll have to make that story shorter than short. Your time is up unless you get an extension.
I'm saying...
Mr. Speaker, I move for the honourable member to be given 15 minutes to conclude his presentation. By standing order, that is permitted, once granted by the Speaker.
Honourable member, you have 5 minutes to wrap up.
Thank you very much, Mr. Speaker. I'm saying we never know how far the ripple effects of our actions can go. It is very interesting to see the People's Progressive Party take some decisions now they were diametrically opposed to just a few short years ago. And I know you don't want to believe this or accept it, but it was a time in the not too distant past. You were out of government. Be very careful what you're asking for here. Be very careful what you're asking for here. And so I do not believe that we can support this order. I think it goes against the grain of everything the university should stand for. And I'm being advised by folks who know that this concept of a transformed university, as I said, started a long time ago, picked up steam a couple of years in the recent past. But this whole idea of the council was already canvassed in the shape and form of a modern council. And advice was received from non-political persons, academics, and those persons who study university and compositions and so on, that the council, in keeping with best practices, should actually be smaller. And I know that the PPP got a penchant for small bodies. And I'm not. We had a big oversight body for the Natural Resource Fund. They say too big. It's too much oversight. The honorable member, Ramson, says, because of the investments in UG, we got to get a big supervisory body. Well, all this investment coming through the NRF, but to shrink the NRF. So the thing, the maths and maths. I end with this. UG has showed over the years, and in the recent past, it has improved its international ranking. They have added a number of new programs with the same council. The work wasn't stymied. They have added a list of new policies. The student numbers have gone up, while other universities, like UE, has shrunk in registration numbers. Graduates have gone up. New PhDs. When you go on campus, you don't recognize it. The infrastructural projects, staff promotions, and a whole number of things are testament that UG is on a path. And I warn us, we've seen this movie before. In conclusion, certain changes were made to the PAC for better governance. Now the PAC hardly meets. And we warned this was the ulterior motive. They said, no. The papers locally are replete with the words of the Attorney General, the Honorable Gail Teixeira, all the democracy and the greater this and that, and everything has gone in the opposite direction now. How many meetings were missed? How far back the PAC is? They're coming now and they're arguing the same thing for UG. Greater this, greater that. But we've seen this movie before. With that being said, I want to humbly submit. Now we put this order into a select committee. UG was notified of this order through the press. When I spoke to UG even about the cancellation of the student debt, they have not been engaged on that. And the Honorable Minister of Finance knows this. They have put forward a number of proposals for the cancellation of student debt that they themselves have had to walk back. You need X amount of contributions, and then no, we can take that off the table. You need to show that you're employed. No, we can take that off the table. Because these things are not being thought through in a very comprehensive manner, befitting the highest institution of learning in our nation. And so, Mr. Speaker, members of the government, members of the parliamentary opposition, I humbly submit, let us put this order into a select committee, consult with the stakeholders properly, and then come back and see if we feel the same way about it. Thank you very much, ladies and gentlemen.
Honorable Minister of Labour, Mr. Joseph Hamilton.
Okay, thank you very much, Mr. Speaker. Mr. Speaker, I want to situate my presentation by starting here. This is a study that was done by one David Jenkins in 1988. And it was, what is the purpose of a university? The purpose of a university is to survive by giving society enough of what it wants in such a way that it earns, retains, and makes space for its proper pursuits, including systematic criticism of what society wants. The disciplines need constant renewing and constant resurrection for the sake of humanity. So, the conversation about staying where you are. You know, the National Assembly we're sitting in this morning, there was a time when it just had 35 members. 35 members used to be in here. Today we have 65 plus, we can accommodate 4 technocrats. So that is what life is. As society evolves, you have to change structures. Society don't just stand still. And somehow, the people across there is of the view that if you attempt to expand the university council, somehow you have some ulterior motives. You know what they have not said? With all the conversations, they have not said, and tell us when you all stand up, that we should not appoint a person, a member of the religious community of the Christian community. Tell us that. Tell them that this morning. Tell the Muslim community that they are unworthy to have a member on the university council. Tell the Hindu community that they are unworthy to have a member on the university council. Tell them that. Don't spin around and round and round. Tell the young people that they are unworthy. They are unworthy to be on the university council. Because when you look at the amendment, the expansion is those representative stakeholders. At one time, they accuse us of not including stakeholders And now when we expand and include stakeholders, they're cussing us for that. They normally accuse the PPP of not allowing stakeholders that are relevant in the society. I don't know anyone here could question the relevance of the religious community in this country we live in. And so you have tell them that you don't want them, they're unworthy to be on the council. Now, Ms. Coretta McDonald, honorable member, and a lot of these people in here, they're too young to understand what I will be speaking. Too young. Honorable Coretta McDonald spoke about the university must be a place where democracy flourishes. You know, not so long ago, Walter Rodney, a Guyana scholar, couldn't get a job there. Flourish, democracy flourish. Not so long ago, one professor, Dr. Joshua Ramsamy, there was an attempted assassination of his life under the democracy, the party she belongs to talk about. So these things you must remind. You know, the nation need to be reminded, because when a member of the PNC comes here and stands up and screams about democracy and the democracy in the university at UG, you have to remind them of a time. Yes, it is relevant. It is relevant that a national scholar named Walter Rodney could not he couldn't get a job there at this democratic place. And Joshua Ramsamy, no, that is doings of the People's National Congress, not the PPP. So we ain't got going back there. And you will never get back there, because you will never get back in government.
You said the same thing in 2015. Let the cop say you prove.
So, Mr. Speaker,
You said the same thing in 2015.
you know, in 2015, the people are there, across there, APNU, AFC, whatever they call themselves,
We rigged it, now we rigged it.
you know, they promised all the glorious things for UG, you know. What they would have done. But you know what? When they got into power, they raised the fees at the University of Guyana. You think we trust you? You always do opposite to what you say, what you tell people you will do. You raise the fees at the University of Guyana.
Why you don't sit up?
Mr. Speaker,
Why you don't sit up?
Mr. Duncan regaled us. He spent half hour
On my lived experience,
telling us about himself.
can't do.
Not this act, you know, not this amendment here. He didn't speak to this. He spent half hour speaking about I and I.
You want to talk about
Somehow you think,
you want to talk about you?
my good friend, last Saturday was the AFC elections. You were not elected, and you have to wait for the next Congress 2 years from now.
Lots of people, but you got to wait.
So Pomposetting here this morning about
You got
how
to wait until you're in the next Congress.
it's useless.
That's a part of life.
It's useless. And right now, he is, right now, Mr. Duncan. Mr. Duncan is, I wouldn't use the word, what he is.
You could go ahead, you're a nasty man, call it.
Imagine that.
You wouldn't surprise nobody.
Mr. Speaker,
Useless.
you know, I heard Honorable Member Coretta McDonald and I think Duncan. They have this concern, and they always have this concern about the minister to act. If not the minister, then who?
You should be the last person talking to you.
I don't understand. If not the minister appointing, then who? Then who? If not the minister. Don't go there. Don't go there, please.
Right there we're going.
Don't go there. If not the minister, who? You didn't tell us that. If the minister is not authorized to appoint, who will do it? Somehow, and that's the reason why you all was kicked out of government. Because you have no understanding how government function.
Why were you kicked out?
You have no understanding how government function. Mr. Speaker.
Honorable Minister, just give me 1 second. Honorable members, I've been listening to the debate. When certain members were speaking, there was good enough silence in the room. So please honor the minister with your ability to listen or leave. Go ahead, Minister.
Mr. Speaker, a lot of things were said about University of Guyana. But, you know, for me, the important thing is, and we have to, as a nation, we have to ensure that the University of Guyana, that we, as the citizens of this country, fund, we have to think about whether the university is training students for the present and future labor force of Guyana. It's not just to have a university. It is not just to have a university. And I will say this, as regards education delivery in our country, we need to, and that is a conversation we have to have, making technical vocational education as relevant and prominent as academic education. So it is, no, it is not so. You see, you don't even know. You're so ignorant of the facts. The reality of the situation is, what we're churning out, and you know, it bears my point out. You will see regularly dozens of young people on social media saying that I graduated from UG 2-3 years and I can't get a job.
They say the same thing about gold. They say the same thing about
Secondly, just last year, in conjunction with the ILO, we did a study about jobs in oil and gas future. Many of the things that our people study at the university, those jobs will not be around. Those professions, they have gone.
So you sound like a clown.
And therefore, it's not just about hollering about university. It is about what you want the university to be.
And you can fashion it.
Yes, the PPP Civic, capable of fashioning it. The PPP Civic is capable of fashioning things. When you look at the country, presently, people have said that Guyana is a big construction site. They couldn't say that under you. You did nothing of substance. Mr. Speaker, what this order is seeking to do is to add stakeholders. That is what this order is attempting to do. It is to add stakeholders and the youth. That is what this order is about. And the next speaker, you must get up and say that the Hindu community is unworthy. The Christian community is unworthy. The Muslim community is unworthy to be on the university council. You know, I must say this. You know, when the attempt was to include a farmer's representative on the UG Council, the same people said, what will they do there? What am I talking about? You're too young to understand and know. The question was asked, and look, see Paul Lorraine will know that. The question was asked then. The question was asked then. What a farmer representative know about UG and what will they do on the council? The question was asked also about our Amerindian brothers and sisters. So this is not new with the people over there. They said then that what they know about university, they're bush people.
Joe is projected.
No, I'm projecting. Madam Gail Teixeira is, we know the times and the periods. The persons, the party then, and the highfalutin black middle class then questioned why a farmer representative should be on the UG Council. Why an Amerindian representative must be on the UG Council. And so it's the same thing we have this morning. The question, you know, for many of these people who spoke, I don't think they are objecting. Let me say this. I don't think they're objecting to the expansion of the council. I think their objection is to the organizations that would expand the council. I think that is the problem. And you almost say that.
You saying it, nobody.
You almost say that. I know you all over there think. I know you all.
Because you're over here.
Mr. Speaker, look, the fact is, a government must govern. That's the purpose. We have no intention in controlling. A government must govern. A government must bring policy forward to the people of this country that entrusted them to govern. And governing is not control.
That's what we tell you.
And my good friend, Mr. Speaker, before I take my leave, you know, oh, I forgot to, Madam Coretta McDonald, honorable member, she questioned why FITA and not TUC. She questioned. Go back to the answer. She questioned why FITA and not TUC. You know why FITA? Because it is the largest representative body of unions in this country. Not a paper TUC. So they want the paper there. So as I was saying is that the question is not about the expansion. The concern over there is about who the council will be expanded with. What? You jump high or low, the order will be passed. You know that, right? You know, at the end of the day, you jump high or low, the order will pass because as a government, we believe that the expansion of this council will serve the university better and the nation better. So, Mr. Speaker, I'm in full support of the amendment that was brought here. Pardon me.
Thank you very much, Honorable Minister. And now for the Honorable Member, Mr. Ganesh Mahipal.
Thank you very much, Comrade Speaker. And let me start first by seeking your permission to congratulate all the pupils of this country who wrote the NGSA and were awarded their respective schools. And I'm happy to say that my son also wrote, and he did well. And I know that there are other members of parliament whose children wrote, and I'm sure that they also did exceptionally well. And I'm sure as they grow, they will attend the University of Guyana, and hopefully they will get a very good university to attend, one that does not have political interference. Sir, I want to echo the sentiments of Honorable Member Sherrod Duncan and say that we should not have political interference at the University of Guyana. So I will not be making what I will consider political speech, but rather present some facts, and hopefully it can convince the Honorable Minister of Education to withdraw this order and rather submit for us to reach as a committee where we can look at this University of Guyana in a more holistic approach, Comrade Speaker, because there is no doubt that the University of Guyana requires attention. And I think adding 6 or 7 members will not fix the University of Guyana. And that is something that we have to accept here and now. Nobody on the opposition side, sir, and I must put this to rest, is against the Hindu community. Nobody in the opposition is against the Hindu community. Nobody is against the Christian community. Nobody is against the Islamic community. Nobody is against the youth. Nobody is against the Amerindian. Nobody is against the other nominees that the Honorable Minister is seeking to add to the university. But we have a University of Guyana Council with 26 members right now, and we have to accept that from a holistic standpoint, the University of Guyana requires the attention of this National Assembly and politicians in general to fix it to serve the purpose of academics. Comrade Speaker, let me take this opportunity to say also that I've witnessed the Honorable Minister of Education and her presentations in this House on numerous occasions, several times. And this is one where I got the feeling as though she herself is not embracing this. I don't get the feel as though the Honorable Minister of Education is 100% behind this. And I'm drawing that conclusion, sir, from the many presentations I have witnessed before from her. So clearly this is she is used as the conduit here to bring what seeks to be a political interference at the level of the University of Guyana. Sir, this piecemeal approach to fixing the University of Guyana will not work. This piecemeal approach to fixing the University of Guyana will not work. And if we are genuine in terms of fixing the University of Guyana, then we will want to address it holistically. Sir, let me say to you that, and I admire her boldness, the Honorable Minister of Education, to stand and say, UG is precious to the PPPC. And that touched me. UG is precious to the PPPC. The preciousness of the University of Guyana to the PPPC caused them in 1994 to put tuition fee for children to go to the University of Guyana for students. It was free. 1994, it became 127,000 Guyana dollars, which was 1,000 US dollars at the time. And all that they're talking about increasing student fees, there was never an increase, and the Honorable Member Teixeira knows that, because we sat on the council when the case came to us that, you know what we're doing? We bring in the $1,000 equivalent. the $1,000, the equivalent, which was the $220,000 at the time. And we have to be honest in this house, sir, especially when we have members who would have served on the University of Guyana Council with us here. Sir, outside of that introduction of tuition fee at the University of Guyana, let me tell you how much the PPPC loved the university, how precious the University of Guyana is to the PPPC. The current composition of the council, the current composition of the 26-member council that the People's Progressive Party love and is precious, must have a representative from the Minister of Education. From 2021 to now 2024, it has been vacant. No nominee came from the Minister of Education for the University of Guyana. 2021 to now. The representative from the Ministry of Finance, the 26 and the 26, there is also a slot for the representative from the Ministry of Finance, vacant. There is a nominee from the political party in office, vacant. There is a nominee from the Minister for Medicine and Law, in fact, 3 nominees, vacant. So the 6th seat that the government has to occupy on this council, the 6th seat that currently exists for the government to occupy on the council, they are all vacant. From 2021 to now, nobody is sitting in those seats, and you are coming here to tell us that the University of Guyana is precious to you, Comrade Speaker, and you didn't occupy the 6, but you're going to put more. So on what basis must we now believe that you will occupy the more? Is it that with the more, the quorum will go up, and then they may not be able to meet, the university may not even be able to meet the council? That is perhaps what they're seeking to do, to shut the council down in its entirety. Sir, let me say also that Article 13, to which the Minister of Education spoke to, mainly speaks to wide consultation. So if you're going to make a change to what exists, then you are supposed to have wide consultations to do so. And this that is before us here, the University of Guyana themselves did not know about it. UG themselves did not know about this, Comrade Speaker. Comrade Speaker, Comrade Joe Hamilton said that the PNC said that Amerindians are bush people. I take offense of that, Comrade Speaker. And I will like for the Honorable Minister to provide the evidence to this House where the PNCR said that Amerindians are bush people. I want him to provide that evidence, Comrade Speaker. And if he cannot provide that evidence, then he owes this nation an apology. He owes the PNCR an apology, and this nation by extension an apology, of which that statement ought to be withdrawn. And I trust, Comrade Speaker, that you will crave my indulgence in ensuring that that evidence is produced. And if not, hopefully it will be withdrawn. Comrade Speaker, I want to also touch on the claim that when we had the chance, what did we do? But before I go there, sir, let me quote what was said by the Chancellor of the Judiciary at the 45th convocation ceremony by Justice Carl Singh. And these were his words, sir, not mine, his words. And as I said to you, sir, I'll be quoting a lot here. He said, "University autonomy has been defined as the freedom of the university to govern, appoint key officers, determine the conditions of the service of its staff, control student admission and academic curricula, control its finances, and generally to regulate itself as a legal entity functioning in accordance with its statutes, and its freedom of expression, freedom of action, freedom to disseminate information, and freedom to conduct research and distribute knowledge without hindrance or restriction. These twin concepts facilitate the flowering of thoughts and ideas and are the bedrock of flourishing and meaningful academia. Dilution of the degree of university autonomy or academic freedom should be stoutly resisted, since history shows that interference in the affairs of universities lead to intellectual regression. The concept of university autonomy and academic freedom must be shown the respect that is shown to the doctrine of the separation of powers, which is constitutionally recognized here in Guyana. These are the twin pillars supporting the structure which ensures that the university's role in the discharge of its responsibilities is meaningful. These were the words of Justice Carl Singh at the 45th convocation ceremony. Clearly, he's saying to us, stop interfering with the University of Guyana. Stop the political interference at the University of Guyana. But, Comrade Speaker, as if that is not enough to convince the People's Progressive Party and the Minister of Education to withdraw this order and come with a bill that can address the entire act of the University of Guyana, let me continue to quote what are best practices around the world. The method of selecting board members varies, but what is evident is that in all countries researched, governments have a say in the selection of members to this ultimate body. The involvement of the government in the selection of members to this ultimate body ranged from appointment by government of external members, as in many European countries, but the names are suggested by the institution. By the institution. So the appointments that the governments make, they come from the institution. As in Sweden and the Netherlands, in France, the state has no say in appointments to this ultimate body. In Australia, some universities have 1 or 2 members appointed by their state parliament. Attempts by the government to extend this to all external members met with strong opposition, and so the idea was dropped. In the UK, the board is free to select its chair and members without government's permission or intervention. Sir, and this was taken from best practices in university government structure, from highly consultative national process from 2010 to 2012 under the Government of Guyana's initiative. Sir, the document went on to spell out what the recommended structure of the University of Guyana should be. And it says here, the recommended structure, the basic elements of the existing structure remain. That is, the council with its attendant committees, the appointments, and the academic board, the faculty board, and the committee of deans. However, the recommendation is for the composition of the council to be enhanced to reflect its focused responsibility on institutional governance. And the structures that they are suggesting is the chancellor, the vice chancellor, the deputy vice chancellors, 2 representatives from the university academic community, 2 representatives from the academic board, 3 private sector representatives, 2 non-government agencies representatives, 2 government representatives, 1 from the opposition party, 3 representatives from regional institutions, 1 representative from the staff union, 1 student representation, 1 from the Guild of Graduates, and 4 lay persons appointed by the council. And this goes to show that the argument of us withdrawing ourselves or withdrawing the politics from the University of Guyana is what the academic centers seek to do around the world with universities, and we should engage in such practice and stop this political maneuvering and political control of this organization. Comrade Speaker, they cannot bring an argument to us and say that with this political control or this appointment by, or these appointments by ministers will cause this university to function effectively. Gaisuku, all the members are being appointed by them. All the members of Gaisuku board are being appointed by the government of Guyana. Has Gaisuku satisfied its target in the last couple of years? Has Gaisuku been renewed? Has Gaisuku satisfied what it had to satisfy? That's a living example before us. They look at what is happening with all the other boards that we have. GPL board, all are being appointed by the government. We're still plagued by blackout. And so many other boards we have, sir, that are being controlled by the government, appointed by the government, and they can't function effectively. But somehow, we are to believe that the University of Guyana, adding more members appointed by the government, will solve the problem of UG. I don't know which world my friends are living in. Now, let me bring my argument now to this whole aspect of what has happened in the University of Guyana from 2012 to now. In 2012, under the Minister of Education, Priya Manikchan, there was an operation called Operation Rescue UG. And Sherrod would know about Operation Rescue UG, and former presidents of UGSS will also know about Operation Rescue UG. This is where the University of Guyana Student Society, the University of Guyana Workers Union, and the University of Guyana Senior Staff Association came together, put a document in place, and pointed out the issues that are affecting the university and the University of Guyana Council in its current format. And they said that the problems that the University of Guyana Council has, 1, the composition of the council does not include sufficient academic representation of the university. There are only 4 out of 26 guaranteed academic members of the council, and this is insufficient membership to reflect the academic purposes of the university. 2, as per the statutes, it is impossible for the University Council to be fully constituted because 3 of the agencies identified as sources of representation to be nominated by the Chancellor may have been pertinent in pre-independence time, but not currently. For instance, the Committee for International Cooperation in Higher Education in the UK no longer exists, and new academic organizations have come into existence. The civic society representation was apparently designed to ensure public representation of important groups in Guyanese society. The principle is fully acceptable. However, the practice over several years has not fulfilled the intention of the provision because the ministers appointed persons based on partisan political considerations rather than explicitly the fulfillment of public interests. The council fails to function as a national representative body for the reasons stated above, as well as the lack of participation of most of the appointed members. A quorum of 8 suggests either the committee is too large or there is little or no penalty for no-shows. The ability of a minority, 5 members, making the decision for the 26th council has led to undue influence of a small group to control the council. The person who chairs the council in the absence of the chancellor is not elected by the body, and this has caused the council to lead by the dictates of who appoints the chair, and that is the government. The council's involvement in the appointments committee and the appointments of the bursar, registrar, and director of Berbice campus has led to unqualified intrusion in the hiring and firing of UG employees, reporting to the vice chancellor, thereby undermining the authority of the chief executive officer of the institution. The process of appointing the whole council is disruptive, does not allow for the development of and transferal of institutional memory, and serves to constrain appointees' expressions. And there are some more here, but in the interest of time, Mr. Speaker, let me say to you that after Operations Rescue UG was birthed, there was growth in how they were going to address the issues surrounding the University of Guyana. And from that, we had a team that was put together. But before that team, one would recall that in 2012, a petition came to the National Assembly. And that petition was presented by Dr. Rupert Roopnaraine. And in that petition, there was the call for us to relook at the composition of the University of Guyana. A special select committee was set up, Comrade Speaker. And this was not done by way of trying to put 1 or 2 or 3 or 4 members on the council. It was done with the intention of ensuring that there is, the title of it is, University of Guyana has a governing body that has the capacity to transform the institution into a truly national asset. That is what they dubbed it as. And it was the Minister of Labor at the time, Comrade Speaker. It was the Minister of Labor at the time who suggested that it be named on the appointment of a new, fully constituted council to ensure that the University of Guyana has a governing body that has the capacity to transform the institution into a truly national asset. So the PPP, the APNU, and the AFC in 2012 were working towards ensuring that there is an institution called the University of Guyana for it to serve its purpose by relooking at the entire composition of the council. Not just adding members, but to look at the entire composition of the council at the University of Guyana. The Minister of Labor, Dr. Nanda Gopal, said, Mr. Chairman, would it be proper for the committee to sit discussing an issue like this without it being brought to the university administration, and for the administration to discuss it, and then after that procedure would have been exhausted, if needs be, it reaches this stage? To my mind, this is preemptive or preempting whatever the university and or the Ministry of Education may want to do, and then to come to this area. I would have thought procedurally that if not the university administration, let us assume that they have tried and failed at the university level before we move in the direction of a new council. So because of that suggestion that came, they invited this special select committee, invited the university administration, and a number of people who have a wealth of experience at the University of Guyana to come and give their feedback, to come and give their presentation, to dialogue with this special select committee. This special select committee that had 5 members from, in fact, it was chaired by the Honorable then Dr. Rupert Roopnaraine, and from the People's Progressive Party side, there were 4 members. There were 5 members, sorry, 1, 2, 3, 4, 5 members. The Honorable Mohammed Irfan Ali, he was Minister of Housing and Water at the time. the Honorable Dr. Nanda K. Gopal, Minister of Labor, the Honorable Mrs. Indrani Chandrapal, the Honorable Mr. Odinga Lumumba, and the Honorable Dr. Vindhya Vashini Prasad. So I am sure Dr. Prasad is well au fait with what I'm referencing here. And from the APNU side, we had Dr. George Norton, the Honorable Christopher Jones, and the Honorable Annette Ferguson. So even Miss Annette Ferguson, Honorable Member, knows what I'm talking about. The Alliance for Change, they had Mr. Trevor Williams, the Honorable Trevor Williams at the time. So all three political parties were working in the best interest of the University of Guyana in 2012. Why can't we do it now? Why can't we work in the best interest of the University of Guyana now? Why can't we continue from where they have left off? But let me tell you how far they have gone with what they had to do, Comrade Speaker. Comrade Speaker, out of all the work that was done from 2012 to now, sir, we arrived at a draft legislation. A draft legislation at the University of Guyana that very members of the committee who were a part of it, they did not reach to further deal with this draft legislation. But this was the next meeting that they had to present to the Special Select Committee. A draft legislation that seeks to repeal the existing act and seek to address beyond the membership of the council. There were many other aspects of the University of Guyana that needed to be addressed in the act, and that is why a draft bill is what we arrived at. And I have a copy of it in my hands. And I cannot understand or fathom the thought. Why is it that from 2012 to 2018, there were so many progress? In fact, this draft bill, sir, was submitted to the then Minister of Education, Nicolette Henry, in late of 2018, and it would have been tabled in this House in 2019, but we know that there were reasons for that not happening. So I hope the Honorable Minister will not claim that she does not know about this, because in 2012, when it started, she was the Minister of Education. Sir, with all that I have said there, I want to put on record that the APNU AFC is fully supportive of us addressing the University of Guyana by way of looking at the entire act that exists, by way of us addressing the faults of the entire act so that we can modernize the act and bring it up to date with what we have before us here and now to make the University of Guyana a better place for all of us who have not gone there as yet, and even our children and grandchildren who will have to study there someday to come. We should not go down the road of trying to politicize the University of Guyana, which can lead to further destruction, further harm, and bring greater hardship on the people of Guyana. Sir, I trust I have made my point solidly, and I trust that the government, the People's Progressive Party government, the Minister of Education will see sense in removing this order, and let us address this by way of dealing with the act, and if possible, let's repeal it and replace it with a well-hammered out, a well-thought out, and an act that can enjoy the support of the People's Progressive Party and the APNU AFC. We can do it because we did it before when we were dealing with the bill that had to do with the single window bill. That bill, when it came, we went to the Special Select Committee. In a matter of days, we hammered it out. We came back to this House and we presented to this nation a bill that enjoyed the support of both sides. A bill that was well thought out, and it is now being implemented. We can do the same for the University of Guyana. We have the willpower to do it. We on this side, we are prepared to do it. Tell us, are you prepared to do it? I thank you, Comrade Speaker.
Thank you very much, Honorable Member, Mr. Mahipal, and now for the Honorable Minister of Parliamentary Affairs and Governance, the Honorable Madam Gail Tishia. Sorry, yes, Honorable Minister, it's the Honorable Member Tabitha Halley. Please, Tabitha.
Thank you, Mr. Speaker. Mr. Speaker, thank you, Anya. Mr. Speaker, before I begin to speak to the issue, permit me to take a minute to first congratulate all the children who did well, all the children who wrote the National Grade 6 Assessment. I'm one that believes that no matter whether you're in the 1% or not, that is not the end of your knowledge and the end of what you can accomplish in life. And so keep pushing through and go on to excel and do great things. I would also like to congratulate all who have been elected to new positions and posts in the executive of their respective parties during the PNCR and the FC Congress and conference respectively. And permit me to also congratulate Mr. Vincent Henry, who was recently elected chair of the APNU. Mr. Speaker, as I read the affirmation of the University of Guyana Amendment Order and the individual amendments being proposed by the Minister of Education, I must say I was indeed appalled by it. Mr. Speaker, with all that is wrong in our education sector, from the nursery level to the secondary levels and the myriad of needs that the University of Guyana has, the Minister of Education, in her own deliberate judgment, has come to this Parliament to change the number of persons on the council. In her deliberate judgment, moving from 26 to 32 is the apparent answer to the much-needed support and resources required to strengthen the capacity of the University of Guyana, so that this institution meets the needs of our nation today and in the future. I simply cannot understand why a ministry that seems unable to correctly add the scores of our grade 6 students at this particular time seem more preoccupied with increasing the number of persons on our council. Mr. Speaker, my colleagues before me expressed quite succinctly why this may be the case. And if their assertions are accurate, then the minister, and by extension this government, must at some point come to the realization that no amount of Thursday ramblings or pictures pretending that you are like the ordinary Guyanese folk will blind Guyanese to the fact that over the last 4 years, the PPP has used every opportunity at its disposal to ensure they have complete control over every aspect of our society, from the state media to the police force to the health sector to the constitutional bodies and commissions, some of which cannot be constituted because the PPP were unable to get their way during the nomination and voting processes, to state boards and other state agencies that any Guyanese would expect to be governed by professionals who can make the best technical decisions in the interest of the citizens of the country, have all become political. But based on what the minister stood here and said in her opening remarks when introducing the bill in the minds of those on the other side of the House, Dr. Jagan's work to get the University of Guyana on its feet somehow means that the university belongs to the PPP, and thus any instant where the PPP is not in control of the university is flawed, and so they have to correct it. Further, Mr. Speaker, it would be interesting to hear, as my colleague Ganesh Mahipal noted, the real reason why the government party over the past 4 years neglected to nominate the members that they have the authority to nominate to the UG's council. One can only wonder why now, and why, despite the fact that the university would have shared its long-term vision, Blueprint 2040, with the government in 2021, no attempt was made to engage university on their proposed plans and how these plans fit into the government's development strategies. This government cannot be serious. Yet they come here saying they love the university and they want what's in the best interest of the University of Guyana. I understand as our only national tertiary institution, the government would want to ensure that the resources the state has invested can be properly accounted for and utilized in the most efficient manner. That's normal. However, with the current strength of representatives on the council, the government has the ability to be an integral part of the current discussions engaging the administration of what is required. Instead, it appears that the signals from the government were contempt for the premier institution, the institution that has contributed to the certification of so many of its ministers, so many of our public servants, our CEOs, and other leaders of industry in the private sector, entrepreneurs, teachers, scientists, historians, and those in a variety of fields in the arts and culture. What then can the minister say is the rationale for this contempt? What has the university done over the past 4 years that gave the Minister of Education and further the PPP the view that it should be completely disregarded? And at this moment, they have suddenly awoken from their slumber and decided that 32 is better than 26. Mr. Speaker, during the years that coincide with this period of disregard for the university, it is opposite to note the extent to which the National University has excelled and continues to make a mark globally. And Mr. Speaker, I know this because a certain gentleman stood up here and behaved like if nothing is happening at the University of Guyana, and they're just in dire straits and they're doing all horrible, and so they're going to invest some money, and so they need to be in control. We may not know or remember, but when COVID-19 forced us to shut down all public services and schools, the University of Guyana had to and successfully provided during the pandemic to online teaching and learning. And now to blended learning, even responding to the government who requested to accommodate the teachers through online learning in the various certificate, diploma, and degree programs in the Department of Education so they can maintain their services in the classroom. But Mr. Speaker, there is so much more for which University of Guyana should be celebrated. Its emphasis on innovation and research, as demonstrated in the high rate of publications on topics that create the empirical basis of policymaking, cannot be overlooked. We have, as our first example, Mr. Speaker, the University of Guyana's recent pioneering study by Ms. Samantha Forrester, lecturer and researcher in the Faculty of Agriculture and Forestry at the University of Guyana on sustainable fish health. Our second example, Mr. Speaker, is the University of Guyana's Institute of Innovation and Entrepreneurship, which has a technology transfer facility, which provides a platform for innovators to collaborate with the private sector and the community to create and share new products, including more recently, bread made from sweet potato flour, which was initiated in its symposium and exhibition on indigenous Guyanese flowers. Third, Mr. Speaker, there is the example of the lecturer and the 3 students of the University of Guyana's Computer Science Department that won the International Webby Prize against competitors from Harvard, MIT, Cambridge, Oxford, etc., for creating an AI module to monitor carbon dioxide from our forests. Yes, our national university achieved this feat. A fourth example is the research in new techniques of rice cultivation at the Berbice campus, and the recent launch of Alpha YG's virtual augmented and immersive education AI platform in collaboration with the Guyana Marine Conservation Society for enhanced research and public education and awareness on environmental issues in Guyana. And then, Mr. Speaker, we have our UG alumni who continue to excel. No better example than the highly acclaimed scientist Vidya Rupchan, who has been lead coordinator of the Pfizer vaccine that literally saved the world from devastation from the pandemic, and for which UG awarded an honorary doctorate in 2022 during their graduation ceremonies. There is much more, Mr. Speaker. The archives of UG are replete with these accomplishments, while the government of Guyana failed to make its nominations to council. Most condemnable is the fact that the Vice Chancellor, supported by her senior management team, has been aggressive in sourcing external support and partnerships to build laboratories, increase the number of faculty achieving PhDs, and then we had a press release in December of 2023, which informed Guyana that approximately 28 PhDs were awarded from graduate programs at Arizona State University, my alma mater, thank you, one of the top-ranked universities in the USA, and that another 12 or more are due to qualify from Canadian universities. In addition, those of us who follow the reports from UG are aware of the highly dynamic environment that exists through its seminars, conferences, programs, all of which contribute to public awareness. These, Mr. Speaker, are indeed just glimpses of UG's work even during this period in which, except for brief flashes, it has been completely disregarded. Nowhere is the volume and importance of UG work more forcefully illustrated than in its recently released 2023 Vice Chancellor's report. It is a must-read, and in so doing, I believe that you, and in fact we, will all be proud. Mr. Speaker, we recognize that on the opposite side of this House are those who pride themselves on using the least studied and least logical approach when making decisions, and any attempt to bring words and phrases such as reason, logic, feasibility studies, and special select committees will be scorned and frowned upon. So while we do not expect good sense to prevail on this occasion, one can only hope that as they follow through with this amendment, that the minister will show the Guyanese people and the faculty and staff of the University of Guyana that any government of Guyana representative on the UG Council will have the capacity to perform their duties as professionals, staying committed to the principles such as academic freedom, freedom of thought, and academic integrity, the freedom to have differing ideas and worldviews. I will hoping that this will be retained at the level of the Council. I stand here hoping that the government's silence on the Blueprint 2040 by Vice Chancellor Paloma Mohammed means acceptance of the strategy, and that any government representative will buy into the vision so that the university can continue to achieve the aspirations set out in this blueprint. Any attempt at the alternative, Mr. Speaker, by being partisan and politically motivated, could be a travesty and an injustice to the premier tertiary institution that is now nearing the end of its 60th anniversary. Guyana's development requires a tertiary institution committed to research and development, the freedom to explore, the freedom to design, and the freedom to research. The founder of UG, according to the Honorable Minister, none other than Cherry Jagan, and those who gave to, built, and sustained UG's foundations, including members of the present council and the distinguished trustees and associates of University Foundation, would no doubt expect no less. Thank you, sir.
Thank you very much, Honorable Minister, Honorable Member. Honorable Minister Gail Tashir. Check again.
Mr. Speaker, you know, we've gone down this road before. I have listened to the different arguments, and
Minister, you may want to move the microphone a bit closer to your mouth. Yes, please.
yeah, I want to say a few things because I think that we have created a conundrum in this discussion, and we have to dissect. I think we have to dissect the issue in an analytical way and cut some of the verbiage out and the accusations. We seem to be a people that prefer to live in a realm of victimology, of looking at boogeymen behind every bush instead of dealing with progress and how we're moving forward, and to label things. We like labeling because labeling is so easy. If you label everything, you don't need to analyze. You've given it a category, it's in a box, and it's neat and tidy. But it doesn't stand up to scrutiny. A couple of things have been said here tonight that we need to speak about. If we're serious in this Parliament about our university and creating knowledge, science, creativity, imagination for our young and beautiful nation. This is not about control. This is about what is the best way to have a governance structure that allows knowledge to bloom. That's what universities are about. That's what universities are about from the beginning of time. From medieval times, they were controlled by the kings. They were controlled by kings because of knowledge, science, research, art, architecture, and they became highly political institutions. Highly political. These comments that have been made here today about, not politically interfere in the university, and that don't put politics in the university. Well, you see, you don't understand, Ms. Ferguson. There's a difference between partisan politics and politics. And if you understand that, maybe we have an opportunity to talk. But since you don't understand it, because politics and partisan politics are two different things. Life is politics, universities are politics, business is politics, countries are politics. When a child doesn't get a food to eat, that is politics. But partisan politics, that's different. And I want to go back to the same comment about politics, and that the PVP has put always interfering in the university. Unfortunately, when the university was created, it was Jagan Night School. It was degraded, denigrated. Why? Let's talk frankly in this Parliament at 4 o'clock near in the morning. That here was an Indian boy from Port Morant who became a dental surgeon who dared to talk about a university in our country, who dared to fight the British colonial powers to make our country independent. That's why it was called night school. That's why it was called Jagan Night School. Because it was derogatory, it was meant on a class basis. It was class and race in this country. From the beginning, it was class and race. From the beginning. You can't fix it, Mr. Ganesh Naipal. If every time you try to fix something, you all jump in with your political interference and your race and your class and everything else. Mr. Speaker, partisan politics has been the thing that has hurt University of Ghana. And let's talk about it. Let's talk about it. It began with Jagan Night School. And after independence, it became the bastion of the People's National Congress. It became their bastion and it remained there. And so it was this bastion of the class, of the new class that had become independent, that was no longer colonial. And it was a place for only some people. And that's why what Joe said, in 1995, when the Act was debated in Parliament, and we were adding on farmers and all these other people for inclusivity, it was, what are farmers going to do there? What are farmers going to do there? You weren't in Parliament in 1995. Go check the records. I don't have time for Miss MacDonald, really. You are such an utter disappointment. Utter disappointment to the women of this country. Utter. No, I'm not a disappointment to you, maybe, but I'm not a disappointment to me. I know what my life has been for this country. Mr. Speaker, but let's get down to brass tacks, Mr. Speaker, if you'll allow me. We went through 68 rigging, and we became the bastion, University of Guyana became the bastion of the People's National Congress, with the flags flying, with the ceremonies there. And yeah, national service was created. And for those of you who don't remember, or you have forgotten history, or history isn't important to you because it might bring up some things that are not very nice in the history of the People's National Congress. But national service took the university students of our country from the 1970s to the 90s that they had to do service with the national service. And then it meant many families didn't want their girl children to go into the camps of the national service. There were many people who didn't, and there's a famous national service poetess, Madas, who was raped and mentally destroyed. And she was a young university student going to the University of Guyana. She was a poetess. She wrote painful and beautiful poetry. But she had to go because she had to get her degree. And you could not get your degree, the piece of paper saying that you had done your degree, unless you went to national service. And eventually it was softened down to 1 year. Thousands of students never got their degree, never got what you say, the kaja, the piece of paper that said that they had passed and they were now owners of degrees or diplomas. Many left the country. Many came back in the 90s to try to get their degrees. Some did, some did not. But national service damaged the university irreparably for 20 years. 20 years. And then Walter Rodney, our beloved visionary, who was recognized in Tanzania and different parts of the world, and our university said, no, we don't want you. We don't want you. And so when you talk about political interference, this is the era of your political affairs from 1968 right through. And in fact, right through to now. Mr. Speaker, when the issues of the university, this government, through the different times of being in government, have been very careful with the university. And we haven't got far. We haven't got very far with it. Because every time you go to put your big toe in a policy direction, there's a scream that arises like a phoenix from the university. It says, don't touch, political interference, PVP at it again. And everybody backs off. And that's how your game you play all the time. Well, now it's over, the game over, right? Mr. Speaker, you know, go back to political interference, Mr. Speaker. I was on the UG board. Ganesh was there for a short time, and he knows why he was there for a short time. I was on it. And one of the interesting things, because I love university, I love research, I love analysis, and I had not been in that environment for quite a long time, so I was looking forward to that. What I encountered was resistance, intellectual resistance to newness and ideas. And it was as if you were trying to push, like Sisyphus. You know the tale of Sisyphus. Sisyphus tries to push the rock up the mountain, and he pushes up the rock, and as he gets to the mountain, it rolls back down. And you felt like you were on that wheel all the time. Mr. Speaker, we had a panel at the university to search for a vice-chancellor and a deputy vice-chancellor. And we went Internationally, we advertised in New York newspapers. We got people from Fiji and Ghana and Trinidad and Jamaica and everything. And we had a panel that did the interviews and recommended selections to the UG Council. Professor Obade was the final selection, having gone through. The candidates, the shortlisted ones, were brought to Guyana at the cost of the university. They met with the students, they met with the professors and academic, and they met with other stakeholders. Can you remember that? In Walcott Lecture Hall. And Obade was hired. 2 vice chancellors were hired. One was Barbara Reynolds, and the other one I can't remember. I think it was Paloma, I'm not sure. Anyway, and what happened? Dr. Rupert Rupnarine, who my Paul refers to, honorable member, to bringing the petition in 2012 November to the House to have it go to select committee. Dr. Rupert Rupnarine is the chairman of this select committee. He's also a member of parliament, obviously, and he's part of the panel, which I'm part of, that recommends Obade, Obade is selected, Obade is hired, and then the government changes. Rupert Rupnarine becomes the Minister of Education, and Dr. Obade's contract is terminated. Again, political interference? You forget these things? Do you forget these things? But, Mr. Speaker, you want to fix it now after you've done the damage all these years? Well, after 30-odd years of hammering this place, you now coming as Pontius Pilate? You coming now as Pontius Pilate to say, let me clean up this mess together? Crocodile. Mr. Speaker, the select committee that my honorable friend refers to, it called petitioners led by Dr. Melissa Eiffel, as well as the Vice Chancellor at the time in 2012, and the acting Deputy Vice Chancellor, who was Madam Cox, Marlin Cox. Marlin. They all came to the committee. I was not in the committee. And this committee heard their views. And then at the very last minutes, which were never adopted, they met 10 times. It met 10 times between November 2012 and December 2013. The last minutes have not been approved, but they set up a select committee to look at possible amendments. Nothing ever happened. The committee never reported to the House. There was no bill. Nothing was presented to the House. If Mr. Maipaul is saying there's some draft program, a draft bill, I know nothing about that. But, Mr. Speaker, the issue here is that if we truly want a university that is a model in a developing country that has got one of the fastest growing economies right now, we have a lot of catching up to do. So I'm very conflicted listening to the debate about why these amendments are so problematical. Because when you read the report, as Paul opened the door with this report, this select committee, there are differences of views between the different persons who come before the committee. One says, look, the council's governing according to the Act. No one comes up in what way has the council violated the statutes. And in fact, university members say, staff say, that part of the problem of the university is the staff itself, how we manage, how we deliver, and they go into details in that. So the issue that we have here is that what is the problem? Is it a problem that you have with expanding the numbers? In what way would that do would that hurt the university? When you're talking about adding on climate change and natural resources and ICT, et cetera, in what way does it harm the University of Ghana? Does it harm? Secondly, you have another problem you have to confront in your argument. The problem is this: you lump universities together. Universities are private universities, fully funded privately. There are universities that are partially funded by government, and the universities that are fully funded by government. There are also universities funded by different foundations. Guyana's university is fully funded by the government. Unlike universities, in say University of Toronto or Oxford or whatever, they're different. They have different governing structures and different financial structures. So when you say you don't want the government to have control, but you have taxpayers' money, which we come to this house to get approval to give university. And this house and the taxpayer of this country have a right to know. They have a right to figure out if the money is being used in their best interest of their country. And so you have a conundrum. You're pulling examples from different places, hodgepodge, and you're not looking at what are the structures that are different. A fully funded university by a government has a different structure than one that is privately funded, for obvious reasons. And so, the funny thing is, in your argument, there's a very big hole in your argument. And let's do it this way. According to the official gazette, your University of Ghana last published council is for 3 years, from February 2018 to December 2020, but actually it's a mathematical mistake they made. So you have a Chancellor, Nigel Harris, you have a Vice Chancellor, Ivelaw Lloyd Griffith, you have UG Academic Board, Jacqueline Murray, Paulette Bino, Norwell Hines, President UGSS, Dr. Joel Thomas, President UGSSA, Vibert Welch, Permanent Secretary, Ministry of Education, Vincent Alexander, APNU AFC Rep, Representative Opposition was not present, etc., etc. And so it comes up to 25 people that they were appointed. So that's the last appointed council. In the meantime, you have had a new chancellor, that is Professor Edward Green, and you have a new vice chancellor, Paloma Mohammed. Obviously, at some point, the university without numbers has proceeding to govern, and hopefully governing within the statutes. But that this in no way, the comment made about the government not appointing people, has in no way interfered with the University of Ghana, one, getting its budget from 2020 right through to now, annually. It has not interfered with the fact that the University of Ghana has appointed people, has been going around doing whatever it does, has not brought in any policy that harms it. In fact, has brought in policies that help the university. One, in terms of helping to pay off the loans owed by university students over the years, promising in its manifesto that the fees will be removed, and that bringing other universities through the Ministry of Health and other places to work with the university, whether it's research, medical school, and whatever. So this view of political interference, you've had a period of time where there's been no council properly constituted. None. It hasn't been constituted properly. Yet the university is managing fine. The university has been spending its money. It's been doing whatever it does. So where does this argument of political interference come from? It is a sham. It's a sham. You have a problem with the truth because your whole argument falls apart, boom, on the ground, just by the point that the last board appointed expired. No board was appointed. You continue to function. You continue to spend billions of dollars, and no one troubled you all. And all of a sudden, because the government says, look, you know, we really need to focus on this university and get it to be the model of a developing country, Latin American type of university that is dealing with climate change and its whole new approach to things. And yet, one step in that direction, and you get this revulsion coming from the university or some elements of the university as well as the parliament. Why? Why? The fact that, are we not proud as Guyanese? Are we not proud as Guyanese that the low carbon development strategy was created in Guyana by Guyanese in consultation with Guyanese? It wasn't intellectuals coming from London or Moscow or China or Cuba or anywhere else or Washington. It was ours. It's ours in 2009 and 2010 and again now when we came up with 2030, LCDS 2030. That is your whole development strategy right there. In what way does the university of our country, funded by the taxpayers of this country, do not have a say in what it does and what it does to forward our nation? In what way do we get into these bizarre intellectual gymnastics to try to justify a position of political interference? That's why you all want 6 people more. What utter ludicrousy. I would like to suggest to all of you that when tomorrow you have your cup of coffee, hopefully when you wake up, go and look back at what you all said in this house in this period. It is a level of myopia, of a type of thinking that will not move this country forward, certainly will not move you forward, and will not help your party, which is fine with me. We don't want you to go anywhere, so you can continue down this crazy road you're on. But, but Mr. Speaker, the fact that, you know, this country, with what we have available, the amount of research, and let's be frank, if it wasn't for NARI, NARI has done historically amazing research over the decades. Over the decades. We're no big university, but NARI has contributed, where's Zulfi? Agriculture, is that right? To the different strains of rice and the strains of that, I don't know all the thing. But I'm saying that NARI as an institution has contributed billions of dollars of profit to Guyana through the research done over the decades. New variants of rice and new variants of that and so on. I don't want to put down the university. I want our university to do well. I want our university to be a model. I want it to compete with the University of West Indies. I want it to be better than the University of West Indies. But we have to stop putting the discussions into these partisan political boxes. So when the Minister of Education comes forward with a policy to do whatever, it won't be seen as, oh, this is a PPPC, want to control everything. If we live in that world, we will go nowhere. Because the university and the young people going to it, and those who are there, we need to be able to have laboratories and science and research and surveys. Let me give an example of how the partisanship affects us. I have been for years trying to get data on what is going on with young men in our country. Marginalization, absenteeism, drop out of school, da-da-da-da-da. I've gone to the university several times, including several lecturers, and said, have we done any surveys? How do we address young males in our society if we don't have some data available? No research has been done. No research has been done. We have social issues. We have social problems. The universities of the world, including what ours should be, is the intellectuals are able to contribute to solving problems in our societies, whether it's drugs, whether it's violence, whether it's skills. This is what universities are about. So where there are universities where there have been problems with violence in some cities, the universities have played an important role in analyzing, surveying, and coming up with progressive ideas to governments, to cities, of how to address some of these issues. I don't know what that rattling in the background is. No wonder, Miss Ferguson, you had to go and get a university degree overseas, paid by the taxpayers of this country. You didn't go to the University of Guyana, you went overseas, paid by the taxpayers. And you're rattling on about at 4 o'clock in the morning. Stop rattling. Mr. Speaker, I said rattle. What's wrong with the word rattle? Mr. Speaker, the issue of governance, when we read the statutes and we read the Act, the University of Guyana Act, the Council has clear mandates on what its responsibilities are. We can't be between and betwixt. The mandates of the Council, as far as my recollection, has not been the issue. The issue has been a hypersensitivity to the presence of people who are categorized as being pro-PPP or PPP. And so, Mr. Speaker, Mr. Maipal can come and talk about, let's look at this bill. But I think the issue, we went through all this in the university. We had the Trevor Hamilton report, which we dissed it. The University Council dissed it. It did not fulfill what we wanted. And I'm saying we meaning the council, not we meaning PPPC. It was criticized. Even Dr. Rupert Rupnarayan, who was part of that council with me, was very dissatisfied with the Trevor Hamilton report. And so we know these things. There has to be some kind of open-mindedness that the university does not feel that every time there are appointees there, that they don't think they should be spoken to. Somehow in the university, there appears to be a view that these non-academic elements who come to us, whether it's politicians or not, are not smart enough to tell us what to do. And so there's a certain elitism, it's unfortunate. It's unfortunate. But universities are about openness, about being willing to experiment, about being willing to look at problem solving, about being able to find the best answers with what's available at the time. And we need to be able to have these discourses. The Act itself is not an impediment to the university making changes. The statutes and the Act, as far as I'm concerned, I may be wrong, is not an impediment to our university moving in a much more progressive direction. That's not the impediment. It is one in where we have to have open discourse. How do we balance the research and the training of people with what is our environment? Not just about labs and things like that, but actually being able, just like someone mentioned, I think, Mr. Bita, Ali Sarabo, about the young man, Guyanese, who contributed to the vaccine, the Pfizer. Our people do that. But that was about being in a setting that was looking for answers. You cannot be productive if you're not trying to find answers. If you're going through the rote, this is what we've done and this is what we do, then you're not going to find answers. How do we find answers in our country to one of the big issues of hydrology? For example, one of the biggest problems we have in our country is flood. We're a low-lying country. We're one of the 10 countries in the world who are most vulnerable to disasters with climate change. Go on to the UN sites and see it. We're in the same category as Fiji and Samoa, what do you call it? Samoa Islands? Solomon Islands and so on. Vanuatu and these places. So if that's the case with floods, then the whole issue of hydrology, hydroelectric and hydrological design, architecture, of how do we over time deal with the issue of flooding. Do we have a new Silica City being built? Does that mean in the next 30 years that we have to move from Georgetown and move up the mountain? But these are issues that universities think about. They're paid to think, they're paid to write, they're paid to research. And so how do we as a people discuss the future of the university in the context of one of the fastest growing economies, in a country that is low-lying, in a country that has one of the largest collection of carbon dioxide in the world, preserving the world? How do we take all these elements, positive and negative, and use the thinkers of our society, the people who can think, who can write, who can research, to find answers? And how do we encourage at the university people who are willing to be free thinking and not be confined by what political party they're thought to be wearing on their sleeve? We put people in boxes. And so why should we do certain things if someone's thought to be PPP or someone's thought to be PNC? We keep putting people in boxes and we get nowhere with that. And so this is such a simple amendment to have caused this discussion to go for 4 hours when what we have been doing is chasing boogeymen behind the bush. That's all we've been doing for the last 4 hours. You know, I didn't see the boogeyman yet, but somehow you all pull it out all the time and wave them around because that's how you like to do it. But we have to, this is not going to harm the council.
Honorable Minister, you're about 4 minutes over the 30.
Yes, thank you. I'm going to.
So you'll need a few more minutes to find that boogeyman.
Yeah, I just need to, one more minute. Mr. Speaker, I hope that in the discussion tonight, that we try to move away from these labeling, and look at things with a fresh eye. To summarize, Mr. Speaker, these amendments are not going to affect the governance of the university in terms of its statutes, its laws. It doesn't undermine the power of the council, but it also will hopefully bring in some new blood, some new people that will want to have open discourse, discussions with different stakeholders about how can we move and create a progressive university, an even more progressive university than what was originally envisaged by Jagan when it was called the University of Ghana and Jagan Night School. Thank you.
Thank you very much, Honorable Minister. And now for the Honorable Member, Ms. Manzo Walton Dizzy.
Mr. Speaker, thank you I have the privilege of wrapping up the contributions from my colleagues on this side of the House. It is 5 to 4 in the morning, and so I don't propose to be before us long. But I have to observe, Mr. Speaker, a few things. You know, when the Honorable Member, Minister Teixeira, started speaking, I realized that we have a problem. We have a problem in this country. And you know what that problem is, Mr. Speaker? The problem is that the people of Guyana, the future generations of this country, the present generations, are being held hostage to a lot of hurt feelings and the need for revenge somehow. To hear the Honorable Member Gail Teixeira stand and speak with such vitriol about what happened in 1968 means that we in this country have a problem, because it means that our children, we who were not even around in 1968, are being held hostage to hurt feelings. Honorable Member, I would strongly suggest therapy, because we have a nation to build, and we cannot continue to be subjected to your vengefulness and your hurt. Go get therapy.
Mr. Speaker, I ask the young lady to withdraw her comment.
Why?
At 4 o'clock in the morning, I think you should be some
Honorable
restraint.
Minister, you had an opportunity, another proper point of order.
This is the
Go
point.
ahead, go ahead,
She
Honorable.
makes my point very well, Mr. Speaker. There's a level of vitriol that we felt all the way across here. And so, you know, Mr. Speaker, this nation is in a crisis. Mr. Speaker, I will say that the conundrum that the Honorable Member before me admitted to is the cognitive dissonance that has been caused by the very erudite and sound arguments of my colleagues on this side of the House. And so they hear sense on this side. But on that side of the House, they have a difficulty with reconciling it with what we know, Mr. Speaker, are ulterior motives. They got ulterior motives. And you know the boogeyman that the Honorable Member Teixeira is talking about? I want to suspect that it might be a boogie woman.
On a point of order, Mr. Speaker, the honourable member cannot impute improper motives to the members of the government, members of this House.
I don't recognize your point of order. Boogeyman is something. Go ahead, Honorable.
Thank you, Mr. Speaker. Mrs. Speaker, you know, she spoke about the boogeyman, for example. Mr. Speaker, the reality of it is that we have the very recent example of the PAC that my colleague Mr. Duncan referred to. The Honorable Member came with the same righteous indignation. If you all remember that? Right? She spoke about the same boogeyman and that there is no ulterior motive. And a year later, what has happened? The PAC has been decimated. It is a shell of its former self. So the Honorable Member must forgive us if we are not quick to agree with her
because we have the benefit of experience. And so, Mr. Speaker, I will say this because I will address each member in turn. The Honorable Minister Manik Chan, you know what is important? Mr. Speaker, what is important more often is what is not said than what is said. And in her presentation, there appear to be some material omissions. Some material omissions, and one must wonder why. One must wonder why. Mr. Speaker, there is no doubt that this amendment seeks to increase control over the Council of the University. It is obvious. But, Mr. Speaker, you know what is important, and the Honorable Member Mahipal made the point, that from 2020 to now, certain positions have not been filled. Well, it is important to note, Mr. Speaker, that this would have been the case from 2016, because then they were in opposition, and they did not appoint an opposition nominee. And so here is the dilemma, Mr. Speaker. You have a government that has failed to demonstrate commitment with the existing numbers, but are proposing to increase the numbers. Make that make sense. Make that make sense, Mr. Speaker. And this is why we know their motives might very well be sinister. That's right. Because you don't show up, but then suddenly... Mike, none of this sinister. Might be sinister. You have demonstrated no commitment, but suddenly you want to increase the numbers. As if to suggest to the people of Guyana that an increase in numbers will somehow cause you to be committed. And it just might, Mr. Speaker, because guess why? With the current configuration, the persons appointed by the minister alone will form a majority. And so this is why they haven't been participating, because they do not participate in anything that they cannot utterly control and dominate. And so that is the sinister motive that might very well be there, sir. So we're not going to participate because we don't have a majority and we can't control it. And you know, the Honorable Member Ramson, with his garrulous loquacity, he betrayed what the thinking is. He betrayed it. He said we're about to make significant investment, and so we gotta control it. That's basically what he loose lips, sink ships. And he sank the ship of the government.
Speaker, I raise on a point, or that's not what I said. I never said that because we are increasing, we have to control it. That's not what I said. That's not what I said. I have never said that.
Honorable Minister.
And I object to that.
Honorable Minister, I will oppose your objection. Honorable members, please quote him correctly if you want.
If they're saying that I quoted it correctly, I'm challenging that.
We can always check the records. Honorable Member, Ms. Walton Desir.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, so, you know, we have to be able to examine these things in a sober and a temperate manner. So we have Madam Gail Teixeira, Honorable Member. We have the Honorable Charles Ramson, who stood here and said that he has been privileged to attend first-class universities in London, etc., I am supposing. And he was very loud in the praise for the university, but what he fails to recognize is that those universities have those standards primarily because they're not interfered with by governments. That is why, and the honorable member gave the share comes to this house to say that because the government is providing the resources, that because the government is providing the resources, they are somehow entitled to fiddle with the constitution of the council. When, Mr. Speaker, if we are going to be transparent, that draft legislation that Mr. Mahipal spoke to in this house indicates that an acceptable measure of reporting is to lay a report in this house, much like many other agencies. So for the Honorable Guilty Sheriff to stand there to tell us that because we are giving the university money, we have to be able to fiddle with the composition of it is disrespectful to our intelligence, Mr. Speaker.
I take great objection to you imputing that she's saying that you are saying that she said the government can fiddle with the composition. Please.
I'm guiding.
Please,
Mr.
she's here
Speaker.
too long for me to allow you to impute.
No, Mr. Speaker, that is
For me,
perfectly fine.
fiddling has some other connotations. Please.
I withdraw the word.
Thank you very much.
You're welcome, Mr. Speaker. So we cannot assume that because you provide resources, you are at liberty to commit certain acts. So, Mr. Speaker, the honorable member, Minister Manik Chand, and in the interest of time, I will hurry it up. You know, Mr. Speaker, when the honorable member was speaking about the appointments by the Chancellor, she made note, Mr. Speaker, that certain appointments were not made. That's right. She said that these appointments were vacant. What she did not say was that it was for the reason that the Honorable Mahipal spoke about. That some of these institutions from which the appointees were to come.
You're imputing. If she didn't say, please, don't put an interpretation on what she didn't say as
Mr.
a
Chair,
particular motive.
No, Mr. Chair, I am making a statement of fact. When she spoke about the non-appointment by the Chancellor, she did not indicate that the non-appointment was as a result of what Mr. Mahipal pointed out.
No, but that you're speculating. You're trying to draw. No, please.
Mr. Speaker, I think I have made the point. I will make the point this way. Mr. Mahipal stated in his debate that at least two of the organizations that the Chancellor is required to appoint from are no longer in existence.
That's why you appointed 4 instead of 6.
And this is the reason why 4 instead of 6 were appointed. But we would not get that, Mr. Speaker, from what was said. And you see, those omissions, wittingly or unwittingly, are problematic. Mr. Speaker, I want to move on to address the issue that was raised about studies not being carried out. Instead of griping about studies not being carried out, fund the studies. Fund the universities. That is how it works. We now have resources that we have never had before. And you come to complain that the university has not done this research and has not done that research, as if to suggest that that would justify you adding persons that we are not sure will contribute to the academic management of the university is problematic. And once we're talking about appointments, Mr. Speaker, the fact that we
in this House are expected to believe, given what the government has said, that appointing all of these people will somehow result in the academic enhancement of the council, that burden has not been discharged, Mr. Speaker. And to add, if political influence and partisan politics was not the motivation, then you could simply require the chancellor, if it is a certain caliber of people that you want, you prescribe the chancellor's discretion. Why wasn't that done? Why is this only in the sole deliberate judgment? It is often what is not said that tells you what motive is afoot. And so you need these people with sustainability experience, etc. Yeah, that is what Madam Teixeira said. Sustainable development and those backgrounds in the military. Why not give the power and the environment? Why not give the power to the chancellor to appoint? You know for a fact that two of the institutions don't exist. Why not amend and take those out completely and replace it? If it is that your concern is about upskilling the council, then why does the discretion have to lie solely with the minister? That is the mischief, right? That is the mischief, Mr. Speaker. And so I believe that my colleague, Mr. Mahipal, made an important contribution, that in 2012, all political parties worked together, and they demonstrated an ability to work together. And I want to echo his call. This is the University of Guyana. It is something that, you would think, given what the Honorable Manik Chan said, would be a point of pride for this government. But instead, we see them setting up goal and funding goal. And there is nothing wrong with funding goal, Mr. Speaker, I want to make that clear. But the importance of the university should be reflected in the allocation to the university. If they care so much. So, Mr. Speaker, I want to add my voice to the chorus of saying, let us hold our horses on this matter. Refer it to a committee. Because, Mr. Speaker, what is most concerning about all of this? That an order has been passed that materially affects the existence of the university as we know it, but the university has not been consulted. And how is that acceptable in this time? That you are making an order that affects the university materially, but the university is not consulted. And so, Mr. Speaker, my colleagues on the other side would heckle. My colleagues on the other side may make light of this. But, Mr. Speaker, we on this side of the House, we understand the seriousness of it. And whilst they may say, oh, we will have our say and they will have their way, Mr. Speaker, history will record that we warned. History will recall that at 4:15 in the morning on Tuesday, the 11th of July, 2024, we warned. Tuesday the 9th, Mr. Speaker. It feels like we've been here for 2 days. 2 days, Mr. Speaker. No, but in the seriousness of this moment, we are going to understand in time the implications of what the government did. And we will look back and we will remember that we on this side of the House, we warned, we implored, we begged, we beseeched that it not be done. But
it fell on deaf ears. But you know, the Bible has a saying, he that is rebuked and stiffens his neck will be cut off suddenly and without remedy. He who hath an ears to hear, let them hear.
Thank you very much, Honorable Member. And now for the Honorable Minister of Education, the Honorable Priya Manichan, to
Your Honor,
conclude.
thank you. If we're going to be kept here till 4:15 in the morning, it should be for sober, sensible contributions. Members coming and repeating everybody else's points, and missing all the points, and totally misinterpreting what they read is just a disappointment when we're talking about the foremost institution of learning in this country. The previous member stood up, and all the honorable member did was to repeat what her colleague said, all his misinterpretations. Mr. Speaker, let us begin, Mr. Speaker, with the biggest misinterpretation and untruth that was told repeatedly in this House by Mahi Paul, honorable member, by Amanza Desir, who had nothing else to do in her whole presentation but to repeat what the honorable member said. And they're all, of course, very honorable, as their leader showed when he did them what he did them during the previous election. Mr. Speaker, there is no council in existence at this moment. And Mr. Chair, honorable member, said it, but she didn't hear or she couldn't understand the honorable member. So she came and repeated what Mr. Mahi Paul said. There is no council in being at this moment. If we look at 12.3, Your Honor, you'll see in the University of Guyana's Act that councils are appointed and they have a tenure. They're appointed for a particular period. This council was expired sometime in 2020, so much so that I've received, it was expired. So there's no vacancy because there's no council. So, Mr. Speaker, this idea that we failed to appoint persons and this proposition that we did is just simply untrue. Now, two things, sir. The honorable members are standing here to say to you, Mr. Speaker, that the honorable member had not, I give her the floor again so she could repeat what Mahi Paul said. Honorable member had nothing of substance to say. In her usual state, all form, no substance. Stand up, flicker here 2 times. Says understand a few times with an accent and believes that's a presentation in this House. Unfortunately, sir, we should get more substance in this House when people are looking at us, especially when we're talking about the foremost learning institution in this country. Shouting in this House across there from a seat that she doesn't even belong to should not be allowed in this House, sir. Mr. Speaker, the honorable members have to make up their mind. The honorable members have to make up their mind. And on one hand, the honorable members are saying, on one hand, the honorable members came here with a script. Their leader sent them and jetted off to New York, and they came here with the script. It is to say that the PPP wants political control. That's the script. And then they could build some fluff around that. Well, if the PPP is so obsessed with political control, how it is that you stood here repeatedly and said, we failed to take the control by nominating people over the last 4 years? How does that reconcile? Nonsensical, illogical. It may be the hour of the night. I've heard better from the honorable members. So it may be the lateness of the hour, the earliness of the hour that caused that level of illogic. Then the honorable members are saying to us, we don't want political involvement. This thing must be devoid of politics. But they stand here and say, why can't we get together, these 3 parties, and do more for the university and pass an act?
We don't want to get together with you or any other political party and pass an act. We want to appoint a competent council with persons who have this country at heart and have them decide what must go in the act. And that is what we're doing here tonight. So, Mr. Speaker, the presentations were very confusing. I want to also, so on one hand they're saying something, and the other hand they're saying something else. Dr. Rupert Roopnaraine, and they referenced it, so they know about it, laid in the House a petition, and he actually chaired a select committee. And when he became Minister of Education, substantive doctor, he was written to by unions of the university. And they asked him to change the political appointees on the university. And for 5 years, the APNU AFC did nothing to change any of the appointees on the board. And you come here now and cry crocodile tears about who you think we want. We are coming here to say we want to put young people. We are coming here to say we want to put people who are experts in environment and natural resources and the religious community. That is who we're coming here to say we want to put. Which one do you object to? Because you need to say that. At some point, they need to say which one they're objecting to, sir. Because I'm still unclear about which one it is that they object to. Mr. Speaker, to address a few more untruths. The university, and I want to be very clear. I don't know who at the university the honorable members are speaking to. And I don't want to say, I cannot impute and assume how it is that the university learned of this. But I can say with sureness, and I can wake her up now and have her send me the message, that the permanent secretary of the Ministry of Education informed the Vice Chancellor of this motion before the motion came to the House. So I am saying that, and it is on the record, and I'd be happy to prove it. So I don't know what it is that these honorable members were told and by whom. The other thing is, Mr. Speaker, the Honorable Coretta MacDonald, who herself is not familiar with that or any university, so we could perhaps excuse her, stood here in this House and said very clearly that we had failed to sign. You see, these members are saying these things, listening to, I'm not even sure who. We were refusing to sign a loan to improve the University of Guyana. I stand here, Mr. Speaker, and I would like to lay this over in this House because I believe it is important. And it reads, Financing Agreement, University of Guyana, Science and Technology Support Project between Cooperative Republic of Guyana, that would be us, and International Development Association Financing Agreement, and it goes on. And this thing was signed in Georgetown on September 19th, 2012. September 19, 2012, and in Washington, D.C. on September 30th, 2012. And we decided here what we were going to do. And it was to put down the medical building in the University of Guyana so that we could produce more doctors at a higher quality, that CAMHC, that has to give us accreditation, would have no problems with giving us. Do you know, sir, that in the 5 years the APNU AFC was in office, not a single stone was laid there, not a single drawing was done. We left them the drawing, they just had to reconfigure. It took for us to come back, this PPPC government, to come back into office.
Honorable Member, Mr. Ramson, please. 3 times and out to your seat.
Mr. Speaker, it took the PPPC government to come back into office for Frank Anthony, honorable member, and I
to go with the university and turn the sod, and I'm happy to say that it's very advanced. The building is very advanced. So don't tell me you like the university and you like people in this country when you had all the funds at your disposal, twiddling your thumbs, doing nothing for the people of this country, doing nothing to develop medical sciences in this country, doing nothing to produce doctors in this country, but bawling when you see people get scholarship on the goal? Bawling when you see that? However, Mr. Speaker, there are members in this House who understand the importance of scholarships and understand the importance of study and advancing themselves intellectually because they took it for themselves or they were given it for themselves. They just denied the people of this country that. And Mr. Speaker, that brings me to goal. That brings me to goal. Goal is not in competition with University of Guyana. The University of Guyana was established by Dr. Chedi Jagan, and the Guyana Online Academy of Learning was established by President Irfan Ali, and both of them are PPPC, presidents and members. The PPPC has repeatedly demonstrated in a tangible way interest in education and educating our population. Goal is different from the University of Guyana. And so we're not rivaling each other. The University of Guyana is an in-person university. Guyana Online of Learning is a medium. It's not a university. It's a medium through which just under 30,000 people, Guyanese young people mostly, are going to more than 20 overseas universities through a special arrangement we have. That is what goal is, Mr. Speaker. And we have no apology for investing in goal, because in investing in goal, we have invested in the young people of this country. And that is how you show love. That is how you show understanding that education builds. And Mr. Speaker, here is the issue. Here is the issue. The fact that we have 30,000 persons just under on goal tells you that our Guyanese young people chose goal. They chose goal. That doesn't mean that they rejected the university. It can very well mean that they're working, they have children, they want to study online, and in fact, when we crafted that promise in our manifesto, we crafted it because we went house to house, bottom house to bottom house, to the same farmers and housewives that they scorn. On that side of the house, we went and people said that is what they wanted. And that is why you see it in our manifesto here, sir. In our manifesto, we said very clearly that we will provide at least, well, we said 20,000 online scholarships, and that we will have university and online university. That's what we're doing here with goals. So they're not rivaling each other. Mr. Speaker, Mr. Speaker, we contacted, you know, Mr. Speaker, there are people who contributed to this country. And it's always very sad. I'm always very saddened when I hear us being unable to be grateful and appreciative of that fact. Dr. Opade gave service to this country and continues to give service to this country. And we are very grateful on this side of the House, and on behalf of a grateful nation, we say thank you. Mr. Speaker, the honorable member said coalition champions youth, and then she pulled up some AI thing and read it out to us. The average age of the coalition ministers, as the Honorable Charles said, was 68. 68 years old was the average age of the coalition ministers. You couldn't look across you and see a colleague. We saw friends, but you couldn't see a colleague. These were people who, Mr. Speaker,
She just bring a whole document. She just brought a whole document. You made no point in 30 minutes. No point in 30 minutes. Zero. Zero.
Mr. Speaker, the fact that you can't say you like young people, and every time you get a chance to show that you like young people, you do exactly the opposite and then expect people to believe you. We have seen repeatedly how Young people have been moved out, shifted out of position for older folk. And nothing's wrong with old people. But you can't have an average age of 68-year-old advising this country or making policy for this country and expect that the policy is going to match what our young people of today want. Half of them cannot turn on a computer, could not turn on a computer and had to get parliamentary help, sir. And we saw that repeatedly. Mr. Speaker, the honorable members spoke so warmly of how they love the University of Guyana. In their tenure, fees were raised by 35%. In their tenure, sir, fees were raised by 35%. Students, and it is not the equivalent of $1,000. It was not the equivalent of $1,000. It was facilities fees. In 2015, a student who was paying $160,000 left in 2020 paying $228,000. This is love. This is love for the university and for people. And when they did this, Mr. Speaker, they accompanied it with several threats. Several threats, Mr. Speaker. These were the headlines in 20. List of names who failed to repay Guyana. You listed the names of young people of this country in the newspapers and then threatened them. Students who owe UG could be barred from leaving the country. You caused national panic. So when we were in a place, we left the country where people could work and go on holiday once a year. You know, in this period, the majority of teachers go away. You had them frightened and worried, listed their names in the newspapers, put their names in the newspapers and then threaten them that you would bar them from, and you wonder why you're sitting on that side of the house.
Mr. Speaker.
Yes, Honorable Member, Ms. Ferguson.
Pleasant morning again. I rise on standing order 40A. Earlier, the honorable member made reference to the PPPC's manifesto, and they promised online universities and scholarships, 20,000 scholarship. But I have a copy of the manifesto here, and nowhere can I locate that the manifesto made reference to
Honorable Member, policies are all over the place, even on the platform. So I can uphold that point of order. Honorable Minister, you get your time back, please.
No, sir, you know why I brought this page? Because I actually want to go through each one to tell you what we have done in the last 4 years. But I'm looking at the time, and I'd be happy to do it. But so let's address that, sir. We're talking about the oil money. When the PPP came into government in 1992, these were the stats. We had 30% of our students who were able to access high school. That means that out of every 100 children, only 30 could have gone to high school. All 100 writing common entrance, only 30 could have gone to high school. When the PPP came into government, we had one single secondary school in the hinterland. One single secondary school in the hinterland. When we came into government, sir, 30% of our teachers were trained. Without oil, as a HIPIC, that would be heavily indebted poor country, with white mouth still, and with all kinds of poverty-stricken diseases, we were able to build 13 secondary schools more in the hinterland. 13. Do you know how many the APNU built in their 5 years? Not a single secondary school started or finished anywhere in this country, let alone in the hinterland. When we came in, 30% of our children were accessing secondary education. Without oil, Mr. Speaker, without oil, Mr. Speaker, when we left the APNU-AFC, 78% of our secondary children were accessing secondary school. When we came in, 30% of our teachers were trained. Without oil, when we left, 82% of our teachers were trained. It is now 100% trained or in training. Mr. Speaker, once there is a will, once there is political will, with or without all money, you will get it done. What the APNU AFC lacked was political will, care for the people of this country, care for any development in any sector, and they watched only themselves, and you saw them increasing in stature and in every other way. So, Mr. Speaker, this myth that money, oil money alone is what contributes remains a myth. And if the young people of that party will put that into your head, then you will never be able to lead this country, and that is a tragedy. Mightn't be a tragedy, but that would be sad, because if you are saying you can only run a country with oil money, then you are not at all diverse in the way or innovative in the way you can spend. We move from a heavily indebted poor country to a developing country to a developed country without oil. Without oil. When we came into office in '92, the World Bank did a study on us, and they said 6 to 7% of our people were living in poverty. In 2008, the World Bank did the same kind of study on us, and they said we had cut poverty in half without a single cent from oil. Good policy, prudent management, and sensible governance did that, with a loving, caring heart for the people of this country.
Honorable Minister, I'll have to ask Mr. Duncton to go back to his seat, because when he sits in his own seat, he's quieter. Honorable Minister, you may continue.
So, Mr. Speaker, we are not here for the political control the honorable members speak of. We have to, and it is disrespectful to the people who will go on that council. And I heard somebody say, why not appoint people you think can contribute? I don't want to misquote, but it sounded to my ear as though there was a specific type of person that could contribute, and that would be a fallacy. We have had farmers, we've had people who can't read and write who understood, so much so that they put you where you are, the issue of assigning bonus and the theft of it. They understood that. And they were on their bottom house in a rubber slip and a short pants with a vest on. Can't read and write. So putting people on the council, sir, might not mean educated, lettered people, but it might mean people who can bring to that council the experiences that would add value to the council when they're making decisions for the wider population. And so, Mr. Speaker, whenever the PPP has any kind of authority, whether it's political authority in government or authority on a council or a board, we've always shown how we have consistently used that authority to bring about good. Whether it is more schools, whether it is better quality, whether it's more farmers and varieties, whether it's more solar systems, whether it's more titling of lands, whether it's more roads and infrastructure, whether it's more house lots. Whenever we have authority, whenever we're in a place where we can exercise that authority, it is always used to do good and bring about better. And what we have, sir, here, because I listened to this great suspicion, and all I could think is, thief man don't like see another man with a bag in his hand. And that's the issue. That was the issue. Thief man don't like see another man with bag in his hand. You assume that they got the bag the same way you got the bag, thieving. And so the AP and UAFC cannot tell us about control and control freakism. It was that party who, when they went into the 10th Parliament, passed a motion to amend Standing Order 86-2, changing the composition of all 4 sectoral committees to 3 representing government and 4 representing the opposition. That is control freakism. That is a fear of allowing the system to work. And that is why they're so frightened. They imagine that we are going to do what they would have done had they been in this, had they been sensible enough to be in this position. They imagine that we are going to be the kind of dictatorial people that they would have been had they had these numbers. That is not what we want to do. We make no apologies that we believe that the University of Guyana has produced some great people and has some fantastic alumni, many in this house, not too many over there, many in this house. And we believe that more can be done. We believe that like any other board or council or decision-making body in this country, the more quality you have on the decision-making body is the more you will get out of that body. And we believe that the University of Guyana is well poised to help change this country. We believe and we want to see Dr. Jagan's vision be projected onto the land nationally, and that is what we're here doing today, sir. And so we are standing here asking that this honorable house support this motion to affirm the University of Guyana Amendment Order, Order number 43 of 2024. And I do so humbly ask.
Thank you very much, Honorable Minister Priya Manichan. Honorable members, I now put the motion. That is, that this National Assembly, in accordance with Section 12(7) of the University of Guyana Act, Chapter 3902, affirms the University of Guyana Amendment Order 2024, number 43 of 2024, which was made on the 26th day of June this year under Section 12(7) of the University of Guyana Act, Chapter 3902, and published in the official gazette dated 27 June 2024. I now put the motion. Those in favor say aye. Those against say no.
Division.
The ayes have it. The motion is carried. There is a call
Division,
for
sir.
division. Let's ring the bell and give persons an opportunity to get in their seats and to refresh their Wi-Fis. You just give them 2 minutes so far. You got it. We got to get those online to refresh. We're just about a minute away from starting the division call. Mr. Clerk, you may commence.
Dr. Kisoon?
Aye.
Mr. Sears? Mr. Sears? Mr. Sears?
He answered no.
Okay, I didn't.
No.
Mr. Sinclair?
No.
Miss Lord?
No.
Miss Philadelphia?
No.
Mr. Jai Prashad? Mrs. Flubres?
No.
Mr. Raj Kumar?
No.
Mr. Mahi Paul?
No.
Mr. Figuera? Mr. Cox?
No.
Mr. Patterson?
No.
Miss Finance?
No.
Miss Ferguson?
You got the call back.
No against political control.
Call back, Miss. Call back, Miss Finance.
Miss Finance? Miss Finance?
She didn't. Mr. Patterson had answered twice.
Absent.
One more time.
Miss Finance?
Call Joretta.
And Marcus absent. Miss Ferguson?
No against political control.
Mr. Singh Lewis? Mr. Singh Lewis? She was here. Mr. Sirabu Hali?
No.
Dr. Cummins?
No.
Mr. Henry?
No.
Mr. Ramsaroop?
No.
Miss MacDonald?
No.
Mrs. Walton Desir?
No.
Mr. Jordan?
No.
Mr. Jones? Mr. Jones? Mrs. Hastings Williams? Mrs. Hastings Williams? Mrs. Lawrence. Mrs. Lawrence. Mr. Duncan.
For the love of Eugene, no.
Mrs. Chandan Edmond. Mr. Chandan Edmond. Mrs. Hughes.
No.
Mr. Holder.
No.
Mr. Ford. Mr. Ford. Mr. Ramjatan. Mr. Ramjatan. Mr. Norton.
No.
Mr. Skunja. Ms. Veersamy. Mr. Williams. Dr. Smith.
Yes.
Mr. Jaffer Ali.
Yes.
Dr. Westford. Dr. Ramsaran, sorry. Mr. Pearson Fredericks. Mr. Narayan. Mr. Datadin. Dr. Mahadio. Mr. Charlie.
Yes.
Mr. Siraj. Mr. McCoy.
Yes.
Mr. A. Prasad. Mr. Indar.
Yes.
Ms. Rodriguez. Ms. Parag. Mr. Ramson.
Yes.
Dr. V. Prasad.
Yes.
Mr. Kroll.
Yes.
Mr. Bharat.
Yes.
Mr. Hamilton.
Yes.
Ms. Sukai.
Yes.
Mr. Mustafa. Ms. Manik Chand. Dr. Anthony.
Yes.
Bishop Ejel.
Yes.
Mr. Todd.
Yes.
Mr. Shearer.
Yes.
Mr. Nandlal.
Yes.
Mr. Jagdeo. Mr. Jagdeo. Mr. Phillips.
Yes.
You get 33. 33, 4. Mr. Speaker, 33 members voted for the motion with 23 against.
Thank you, Mr. Clerk. Honorable members, the motion is carried. Honorable Prime Minister.
Mr. Speaker, I move the adjournment of the Assembly to a date to be fixed.
Thank you, Prime Minister. Honorable members, have a safe trip home. The Assembly stands adjourned to a date to be fixed.